okay. Let's see. I don't know why it stopped me. All kinds of YouTube problems. Let me get this set up real quick. Live. Here we go. Yeah, Tayo Toy's anniversary broke the feed. All right, let me save. Oops. Okay. Is everybody here? Everybody ready? Let's just add this to our list of issues. Okay. All right. I want to hit play. Everybody here? Giving everybody a minute to swap over, get caught up. No idea what happened. It just kicked me off. Decided that we were done with that stream. Third time's a charm. Third time's a charm. So here we go.
Individual stains that Lieutenant Davison designated for his examination.
And the EX numbers or the EX letters?
Right, so those were samples that I took for DNA identification purposes. So Lieutenant Davison was examining the bloodstain patterns, and in his examination, he selected stains, gave them those letter designations, and from each stain pattern, I chose one and collected it.
Why did you only choose one?
Really, it's just to get a representative DNA profile from that stain pattern or region of the garage.
And as you say, you chose one. What did you do? I mean, if you could walk us through the process briefly.
Using the same method that I used on the previous blood-like stains. I field tested it with the KM test. Noted that, whether it was positive or negative, and then using that two swab process with swabs moistened with sterile water, I collected the stains.
If I can just have a moment.
What a wild day.
Sir, just a couple questions if I can. If you can take a look behind you. Showing the map on the left, but on the right side, it's photograph 2 out of file 6 on states 9. What does that depict?
That depicts the photograph, an overall photograph of Area A, and corresponding overhead view on the sketch map of Area A.
Was that prior to processing?
This was in the process. This was the beginning of that examination.
Okay. And I'm actually going to bring that back down to. Okay. Picture 3 of that same file. Sir, what does that depict?
Again, that's just another view of Area A.
If I can, just draw your attention, ask you some questions about these. There's a sort of like an upside down L-shaped file. What is that there for?
That's to help give scale to, may I approach the screen?
If you can, thank you.
So you can see this discoloration here. That appeared to us to be a white mark where maybe some blood-like material was on the floor, and there was an attempt made to wipe it up.
Can't hear.
I'm sorry, sir, if you can, just move that microphone behind you, maybe up a little. The one. Thank you. And the yellow arrow up on the upper middle part of that photograph, what does that depict?
That's usually placed by the photographer to denote the north.
So it's directional?
It's directional, right.
And this yellow marking, is that the yellow marking you were talking about before?
Correct, that's that yellow masking tape I was talking about.
Okay. Now, with respect to these 3 items, did you put those down?
No, I did not.
Okay. And over here on the right-hand side, we have that same, I guess, ruler marking. What does that depict?
That's, that same L scale is being used to denote another stain pattern found on the garage floor.
And is
close
that,
to the wall.
oh, I'm sorry. Is that for documentation?
Yes.
Now, with respect to the rest of the garage floor, there's these little dots here all over. I'm going to push the photograph up if I can. All these little markings. What are those?
I mean, it's a garage floor, so you have plant material, you have, you know, other types of vegetation, you have sand, road salt.
Now, I'm going to show you picture 4, sir, in that same file. What is this?
This is part of Lieutenant Davison's examination of the garage floor.
Were you present when these markers were placed down?
When they were placed down, no.
Okay.
But I was, I observed these in place.
Okay. And just to go in, what do they read, please?
They read A12, A13, A14, and A15 with my marking of State Police Exhibit 40.
And this is this correct?
Some of y'all are saying okay, and some of you are saying you lost it. On mine, it shows that I'm still here, so I'm going to keep it going. We'll see how.
Corresponding on the map on the left-hand side of the screen?
Yes, in this area here.
Okay. And with respect to states 40, did you utilize that same 2-swab process in swabbing it?
It's the same process. It's first KM tested and then collected with the 2 swabs.
And the KM test?
Was positive.
And just to clarify, this is which one is what is this depicted?
That is stain A12.
Okay, if you can, sir, I'm just going to show you a series of photographs. If you can, just point to the sketch map to correspond where they are located. If you can.
A12.
Thank you. Now state 6.
A13.
State 7.
A14.
And state 8.
A15, where Exhibit 40 was sampled.
And is that the area that you swabbed that day, sir?
Yes.
Thank you. That's state 9. With respect to these areas, did you mark these or delineate these in any way?
I did not place those scales.
Now, with respect to this area, if you could tell me what this is?
This is a photograph taken overhead of stains denoted as A16, 17, and 18, along with Exhibit 41, which is in this area here.
Okay. Now, just briefly, if I can, I just want to be clear. With respect to A16, 17, and 18, do you recall viewing those that
Yes.
day? Okay. And you took a swabbing off of which one?
Off of stain A18.
Okay, which is up here, right?
Correct.
Who took the photographs that day?
It was Detective Katie Keppel and Detective Bob Hazen.
If you can, sir, same question, series of photographs, if you can just point to the screen where.
This
it
is stain A16, A17, and A18.
Do you recall, by the way, this is kind of leaning, I guess, angled one way. And then I'm going to draw your attention to the preceding two photographs, 17 and 16. Actually, I'm sorry, it's photographs 12 and 13, but A16 and A17. They're leaning the other way for the photographs, and the overview has them this way. My question is just, which way are they supposed to be?
The scales were not moved, if that makes things easier. The photographer is probably just standing on one side of the stain or the other.
In the course of the photography and processing scene, do the scales ever move?
Not on the garage floor in this case.
Oh. And I believe we went. And actually, did you review the part designated as garage B? And if I can, sir, do you recognize what is depicted on the screen there?
Yes, that is another.
Oh, I apologize. I hit the wrong
Sure.
button. There you go.
And that is the another part of the left side garage bay in the center of the garage.
Okay. Is
For
the
most of you-
photograph one?
For most of you, it's staying so far. Oh gosh, knock on wood. Why did I say it? But I know some of you, it's still kicking out. I don't know what's going on with YouTube. It just ended my stream. It just decided I was done. It started me on 2 streams earlier today. I don't know what's going on. So we're just along for the ride. So wherever it ends, wherever it takes us, we'll find our way back to each other. But apparently today is just going to be one of those wonky days.
On states 9, file 7, photograph 1, is that area depicted on I should say the map, a depiction of an area on that photograph?
Yes,
If you could just point it out on the photograph, please.
it's this area here. You can see the B placard right there.
And for the record, that was the middle portion of the
The
photograph?
middle, correct.
Okay, now on this, we have, on the map portion, we have the numbers ranging from B3 all the way up to B11. Is there a B1 or 2?
That I don't know.
And states picture 2, does that depict an area depicted in the map?
Yes,
Okay. And states 3.
yes, that's the right-hand side of the map.
Okay. States 4, what is on that photograph, please?
That's a fragment of paper towel that appeared to have blood-like stains on it that we found in Area B, the left-hand side of the garage, and it's located right there on the sketch map. It's Exhibit 42.
For the record, you're pointing to the middle portion of the garage. Question about sorry, withdraw that. With respect to the 42, that paper towel, can I ask you to describe some of the, I guess, dots that are contained in the 42? What exactly did that appear to be to you?
Yes, this material here appears to be plant-like, maybe part of seeds or.
Did you take any swabbings of 42?
I did not,
Silly
not?
Pig, welcome.
because I just seized the entire fragment of paper towel.
How did you seize it?
I put it in either a paper bag or a paper envelope.
Did you seize anything else out of that area B?
Yes.
What did you seize?
There were 2 stains. B3, I took a sample of, is Exhibit 38. B11, I took swabbings as Exhibit 39. And Exhibit 43, which I believe was another paper towel fragment.
Picture 5, what does that depict, sir?
That's another paper towel. It's a larger paper towel fragment with apparent blood-like stains. You can see this reddish staining here.
What did you do, if anything, with the 43?
I just sure it was photographed, sketched it into the map, and I seized it in a similar manner as 42.
Did you take any swabbings?
I did not.
And if you can, sir, is what's on picture 6 depicted on the map as well?
This was a stain designated as B3. that I took swabbings of as Exhibit 38.
And did you do any testing on Exhibit 38 as well?
I did a KM test on it.
And the results?
Positive.
Now, what does this depict, sir?
That is stain B4, located there.
And for same questions for the next couple, if you wouldn't mind just pointing out where it appears on the map corresponding with the picture. So picture 8, B5.
B5 is here.
Picture 9, B6.
B6,
Picture 10, B7 and B8.
B7, B8,
Picture 11, B9.
B9.
So these are all those blood-like stains that
Picture
they saw
12,
on the garage
what does that show, sir?
floor.
So that is stains B9, B10, and B11, which are up in this area here.
Thank you.
A sample of B11 I swabbed as Exhibit 39.
And that is, if you, okay. And the same swabbing process, same every?
Same swabbing process that was also tested with the KM test that was positive.
Now, picture 13, what is that, sir?
That is, appears to be one of those blood-like stains, that swipe mark that we saw up in area A.
And is this depicted on the map in any way?
I don't believe so.
Okay. Was that contained in area B at all?
Without seeing an overall shot, I really couldn't say that.
Okay, let me see if I can. Here's the overview. Does picture 1 assist you in any way? And if it doesn't, that's, you could just say that
It's
too.
hard to say, man.
Okay. Now I'm going to ask you, if I can, about the bottom part of that garage side. You could take a look. Are you familiar with Detective Pearson's map for C?
Yes, this is the portion of that left garage bay closest to the door.
And for the record, I'm going to say it's 9. I am now in file 8. File 8, picture 1, what does that depict, sir?
That depicts that left garage bay, and area C is in kind of the closest to the driveway. It's this area here.
Okay. And for the record, he's pointing towards the middle bottom portion of the photograph. Picture 2, what is that a picture of, sir?
Those are some more of the blood-like stains we found on the garage floor.
And the yellow arrow again?
Again, denotes north.
We're at 1.25.
Picture 3, what does that depict, sir?
That is area C with some of the stains and exhibits marked up.
Do y'all want to do 1.5 while they're just going through all these pictures? We can do that.
We have the 68 placard right here. What is that supposed to designate?
That designates another fragment of paper towel.
If I can, just.
Another fragment of paper towel. So that shows
Is that
more
depicted on
evidence of
photograph?
the cleanup.
Yes.
What did you do, if anything, with 68, please?
I collected it in the same manner as the other fragments of paper towel. It was packaged in paper.
Did you take any swabbings?
I did not.
And if you can, sir, picture 4, and if you wouldn't mind, same thing, just if it is reflected on the map on the left side, if you
Hold on,
could.
stop, please.
Oh.
Everything left.
Oh,
What has just happened, ladies and gentlemen, is that, of course, the entire proceeding is recorded. The recording system just went down. So what we would ask you to do is just return to the deliberation room. Please do not discuss the case.
Oh. Their whole recording system just went down?
We're going to take
Jamie?
our morning recess until 11:30. 11:30, Mr. Marshall.
All right. Sorry, we're very close.
All right. The good news is we get to speed up a little bit to catch up. So at least we're not the only ones having tech issues. Look, if it went down in the courtroom, they're having tech issues too, right?
Madam Monica, do we know what happened?
We do not know, Your Honor, but we were able to rectify whatever that problem was.
Thank you.
It's not
You can bring the
just
jury
us.
in, please.
does Your Honor wish me to get Detective Riley outside? We can call him back in. Thank you.
Got it. The council stipulates to the presence of all of the jurors.
Yes, Your Honor.
Yes.
You may be seated.
Thank you, Your Honor.
It's going around.
Detective Riley, if you wouldn't mind taking a stand next to the TV again. And just to back up a few of my questions. With respect to States 9, File 8, Picture 4, I believe, if you could you just, is what's shown in that photograph on the map on the left-hand side?
Yes, with the exception of the stain mark G20, which is not depicted on this map.
What area is that stain attributed to?
Area G.
And so the yellow numbered ruler in the, I guess, the middle portion of the photograph?
It would be this line here.
Okay. Picture 5, actually.
As stain C0.
No, with respect to the way the photograph is that how it's depicted on the map? If I can, I'll go back to States 4 and draw your attention to the line again. Where is C0 on States 4?
It's here in the center of the photograph.
Please, the mic.
Oh, if you can,
Yep, it's in the center of the photograph.
thank you. And this is picture 5 again. Picture 6, if you could just identify that in the map as well.
Stain C1.
And picture 7.
Stain C2 in the center of the sketch map, from which I see is Exhibit 37.
The aliens have
Same
made their way
process
to
as we
Panama
did
City.
before with the swabbing
Same testing and swabbing process, correct?
and
From
the test
Miami.
results.
Positive.
Thank you. Now, picture 8, sir, what does that depict?
Picture 8 depicts the interior face of the left garage bay door.
If I can. Did you seize anything for evidentiary value on the garage bay door?
Yes, I seized a sample of the flow-like stain. It was on the inside of the garage door.
States 9. Actually, I'm sorry, if I can go back to States 8. Where on the door, if you could please point, did you seize that item?
It's in the center of the photograph, slightly to the left-hand side.
Okay. For the record, he's pointing to the middle, essentially the middle of the left screen.
Yes.
And States 9, what does that depict, sir?
That is the stain.
Yeah.
A sample of which I seized is Exhibit 67.
And the same process?
Same swabbing process, same testing process.
And the results?
The test was positive.
Did you process the right side of the garage in the?
Yes.
Are you familiar with Detective Pearson's map for Zone G? I mean, I'm sorry, G, D,
Area D.
Area D. Yes, thank you. For the record, this would be States 9, File 9. And I'll show you photograph 2, actually. Do you recognize what that is, sir?
Yes, this is a overall photograph of Area D, the right-hand bay of the garage. Out of frame to the left would be the mudroom door. Give you a little orientation.
And are there areas below Area D?
Yes, you can see the marker for Area E and Area F, which would be by the overhead door.
I'll show you States 1 out of that file. What does that show, sir?
That's overall the right-hand garage bay with Area D at the top of the photograph, Area E in the middle, and Area F at the bottom.
States 3, or picture 3, I should say. What does that picture depict?
That is a photo of a blood-like stain that we found in Area D.
And the 56, what does that mean?
Oh, I'm sorry. So I designated this as State Police Exhibit 56. However, it's the photograph. The exhibit is going to be the photograph of what we thought was a footwear impression or shoe print.
If I can, sir, just a couple questions. Is that depicted, Exhibit 56 depicted on Zone D map?
Yes, Exhibit 56 is here in the approximate center.
Okay, and with respect to photograph 3, if you can, I'm going to scroll in. What drew your attention to this area?
Well, it's another blood-like stain on the garage floor, and there was a distinctive pattern to it.
Could you see the pattern in that photograph? Or
Yes.
Here, I'll scroll
It
up.
appears to be, see these hash marks here?
And for the record, I would say the middle part of the photograph.
Yes.
Picture 4, what does that depict, sir?
Again, that's a stain pattern located here in Area D of an apparent footwear impression.
And if you could just point to where that appears on the picture 4.
It's here in the center of the photograph.
Picture 6,
It's another stain pattern,
And where does that depict on the map?
Exhibit 7.
And if you could, please, picture 6, point to what you are describing, please.
It's in the kind of the lower portion, the center of the photograph.
Okay. Actually, I'm going to scroll in a little. Oops, sorry. If I can go back to 7D. With respect to Exhibit 7D, when you were pointing, if you could point to the area now that it takes over the whole screen, what you were describing.
Sure, it's a floor-like stain on the garage floor, and you can see a partial distinctive pattern within the stain itself.
How did you place that 7D marker on there?
I did, yes.
Okay. How do you document this or seize this as an exhibit?
Well, the hard way would be to jackhammer up the floor and send that to the lab, but that's impractical. So what we decided to do is photograph them properly, 90 degrees with scale, and send the photographs to the lab as Exhibit 70 for identification and possible comparison.
Thank you. And 71, is that depicted on Zone D map as well?
Yes, it is Exhibit 71 here.
And why did you seize that item, sir?
Again, this is another floor-like stain on the garage floor. You can see, that a similar pattern in it, but you can also see the swipe marks through it.
Picture 8, what does this show, sir?
Picture 8 is it's another area of blood-like staining that appear to be wipe marks.
And was this all contained in Area D?
Yes.
And picture 9?
Yeah, it's the additional stain pattern found in Area D.
If I can, I'm going to scroll. Oops. Up here, this marker, I guess L-shaped marker again. What is that?
Again, it's another blood-like stain on the floor with a similar pattern, but a lot less detail to it.
And with respect to these items just around, and if you can follow my cursor, sir, there are little dots or things. What are they?
It could be vegetative matter, plants.
Not blood, vegetative matter.
Anything,
Just all those little dots.
picture 10, was this contained in Area D?
Yes, right here at the almost at the border of Area E.
And is this the same item that you seized on 525?
This is correct. This is the hair.
Okay. Now, with respect to States 9, File 10, so are you familiar with Detective Pearson's map for Area E?
Yes.
Okay. Sir, photograph 1 out of that file, what does that depict?
It's an overall view of, again, that right side garage bay. Area E is depicted here right in the center.
Photograph 2, what is that, sir?
This is a blood-like stain pattern that we located in Area E. It's located here kind of top center of the area. And I took a swabbing of this area to sample the blood-like stain that was on the garage floor.
Was that designated as a exhibit?
Yes, Exhibit 51.
There is a pink arrow on the right side. Do you see where the pink arrow is?
Yes.
What exactly is that?
That in this large stain pattern, the arrow depicts exactly where I took the sample from.
And same process, 2 swabs?
2 swabs, yes.
Did you test it?
I did.
And the results?
Again, every now and then, just make the same objection regarding any quote results.
Maybe overruled.
The test result was positive.
Thank you. Sir, picture 3?
It's a similar stain pattern. Another blood-like stain appeared to be a white. It's located here at the left-hand side of Area E. And again, I sampled this using that same swabbing technique, same testing technique, and I took the sample from this area here.
And the test results?
Test results were positive.
Picture 4?
Picture 4 is another blood-like stain found in Area E. And the stain pattern itself appeared to us to be a textured glove. If you can imagine 3 fingers here.
What exhibit was this marked at?
I marked it as State Police Exhibit 55.
Thank you. And States 5. What does that show?
That's an overall view of Area E taken from kind of with your back to the mudroom door. So you can see Exhibit 55 here, that swipe mark.
And picture 6?
It's an off-kilter view of Area E and the right-hand side of the garage.
Thank you. I'm going to draw your attention now to States 9, File 11. Are you familiar with Detective Pearson's map concerning Zone F?
This is
Yes,
at
ma'am.
1.5 speed. Can you imagine? Like, this is 1.5 speed.
Picture 1 off of States 9, file 11. Sir, what does that depict?
It's an overall view of the right-hand side of the garage. You can see area F is down here. This is the kind of the threshold of the overhead door. And area F is up in this area. Takes up center all the way down to the bottom of the photograph.
Thank you. Picture 2.
It's another blood-like stain pattern we found on the garage floor. Again, this is a threshold of the overhead door.
I'm trying to scroll in a little bit. So that yellow arrow again, what does that depict?
That denotes north.
Picture 3.
That is, again, another blood-like stain pattern we found on the floor. Again, there's more detail inside this pattern. So we designated it as State Police Exhibit 54, photographed it in a similar manner as the others.
And is that depicted on the map?
Yes, it's located on the left-hand side of area F.
Picture 4.
Picture 4 is another blood-like stain pattern found on the floor.
And picture 5.
That is a blood-like stain that I tested and sampled as Exhibit 52.
And with respect to the swabbing process, same swabbing process?
Correct, same testing and swabbing process.
And the test results of this one?
I refer to my report.
Would it refresh your recollection to take a look at your exhibit report?
Yes.
That's what I was thinking too. This is a hard, and there's been so much fighting outside of, not fighting, you know what I mean, arguments outside of the presence of the jury. I bet this is a hard one for them to follow.
It's 11 for ID, please. Sir, would it refresh your recollection to take a look at your exhibit report?
Yes, it would.
I'm going to hand you and draw your attention, please, to page 3. Please take a moment, do not read that out loud, and look up to me when you're done. Did that sufficiently refresh your recollection, sir, as to the results of the test?
Yes, it did.
And what were the results of the test?
That KM test was negative.
Thank you. And is that depicted on the map as well?
Yes. Exhibit 52 is there.
Thank you. And state 6, or picture 6, I should say. What is that?
Yeah, that's another overall view of area F.
Are you familiar with area G, sir?
Yes.
Okay. And now states 9, file 12. Are you familiar with Detective Pearson's map?
Yes, I am.
Photograph 1, sir, what does that depict?
That is a photograph of the center garage bay, 69 Wells.
And is area G contained in that photograph?
Area G is in the area in which the Range Rover is parked, so it's in this area here.
Photograph 2?
Photograph 2 are some blood-like stains we found in area G, up in this area. And for orientation, this is the step into the mudroom.
Now, what are the, were exhibit numbers given to each of these stains?
The stains that I sampled, yes.
Okay. With respect to exhibit, or states picture 3, what is that, sir?
That is a stain we sampled as Exhibit 47.
Is that reflected on the map?
Yes.
And
47.
when you say sample, did you conduct the swabbing process that you
I-
testified to earlier?
I did.
And the test, any test?
I did test that, and there were some stains up in this area that tested negative. And just from this, I don't remember which ones were which.
Would it refresh your recollection, take a look at your exhibit report again?
Yes.
If I may. I'm going to draw your attention to page 2 of your exhibit report. If you could please just take a look.
It must be right next to the microphone too, because you can hear that computer noise and you can hear that
Did that
aggressive
refresh your
typing.
recollection?
Yes.
And with respect to the presumptive test that was performed on exhibit 47, do you recall what the results were?
The KM test was negative for this thing.
In 48,
48 was another blood-like stain in the same general area. It's right here by the stairs. Again, I sampled that, and tested it and sampled it in a similar manner.
and the results of that one?
I'm not sure if we do.
If I can, if I may just have a moment. Your Honor, if I can, I'm just going to provide Detective Riley with 11A, or I'm sorry, 11 for ID, which is the exhibit report. Sir, if you can just take a minute and take a look at that, if you can, to refresh your recollection with respect to the results of any testing performed on Exhibit 48 on 527.
Yeah, the KM test for Exhibit 48 was positive.
49?
49, another blood-like stain, is located up here in the same general area. It was tested and swabbed, collected in the same manner as the others. And the test result for this stain was negative.
And picture 6?
Again, another blood-like stain on the garage floor, located here. I sampled it, tested it, sampled it in the same manner, and the test result was negative.
Okay, so these are some of the ones that they were saying that they didn't want, the defense didn't want this to come in because they're showing all of these things and they're saying, okay, we tested this further and it came back negative, or we tested this presumptive and it came back negative. So these are some of the ones that the defense was saying they didn't even want them to show because they didn't want it to confuse the jury.
After it was photographed, I just collected it now.
I'm squeezing
Picture
my-
8?
Is a photo of a blood-like stain. Again, it appears to be a swipe located in area G. A sample of which was seized as Exhibit 45. It was tested and collected in the same manner.
Do you recall the results?
The test result for this stain was positive.
So that's, I think, important
Picture
too,
9?
because the positive one is where you can see, like some of those are just like drops that it looked like it and it was negative. But the one where it looks like blood that was trying to be cleaned up was positive.
This is Exhibit 36. I tested it and swabbed it, collected it in the same manner, and the test result for this was positive.
Picture 10?
As a stain marked as G19, located in area G, that I tested, swabbed, and collected in the same manner. The KM test result for this was positive.
Picture 11?
This is a picture of a stain pattern found in area G after, I'm sorry, 2 stain patterns found in area G. And this photograph was taken after the Range Rover was removed.
I wish on this they could just show the thing and be like, okay, these are the ones we tested. This, and this were positive. Done. Move on to the next.
This was photographed along the process of Lieutenant Davison's examination of the blood-like stains on the floor.
And if I may just have a moment, Your Honor.
Yes.
From the counsel.
See, when I'm doing my recap stuff, that's the kind of stuff I do. I'll take all this and I'll be like, here's my chart. These were positive. These were negative. Let's move on. But we don't get to do that going through these. We have to go through one by 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 one.
Your Honor, have on a separate disc 10, states 10. I believe there's no objection to it. If I may just have a moment to switch it out.
Yes. No objection, Attorney General.
No objection, that's correct.
Case 10 will be admitted as a full exhibit.
Sir, were you present when the Range Rover was removed from the garage?
Yes.
And did you conduct further processing of the garage scene with the Range Rover removed?
Yes.
If you can just take a look behind you, sir. This is states 10, filed 16. What does that depict?
That appears to be a blow-like stain, that swipe pattern, sample from area G.
And
You pull up the exhibit number? Yes, this was tested and sampled and seized as State Police Exhibit 45.
And just to be clear, the same process, same everything?
Yes.
Okay, results?
The test results for this was positive.
And at some point, the Range Rover was removed. Who removed it from the garage?
I believe we just towed it out of the garage and went it up on a flatbed.
Okay. And did you continue processing the garage floor after the vehicle was removed?
Yes.
Okay, I'm going to turn your attention to the photograph 2. What does that depict?
That depicts the 2 stain patterns that would have been underneath the Range Rover. One here in the lower part of the photo, and one here a little bit higher.
Just scrolling in. So does the higher one appear on the screen?
Yes, up in this area here.
Okay. Now, what does picture 3?
She does. She's very thick hair.
That is the selected stains that were designated as GW1, GW2, GW3, GW4, and GW5.
And sir, what does GW mean?
Area G, I'm not sure what the W stands for. That would be Lieutenant Davison's area of expertise.
And were these the, I'm going to show you a series of photographs, please. You just indicated some numbers. Are these the ones that correspond to the numbers that you marked?
Correct.
Okay, that would be for the records for photo, sorry, 8, 7, 6, 5, and 4. Are photos 4 through 8 depicted in photo 3?
Yes.
Okay. Now, photo 9, what is that, sir?
This is that upper stain pattern in Area G. It was seen in the overall photograph. Here you have stain GE1, GE2, GE3, GE4, and GE5.
And just briefly, you could take a look at 10. What does that depict, sir?
That stain designated as GE1.
Could you point to the stain? Okay. And for the record, it's the middle of the photograph?
Center of the photograph, correct.
Thank you. Picture 11.
This is stain GE2 in the center of the photograph.
Is this oriented like this picture? Sir, if I can, go back to.
So you can see the elongated stain here.
Okay. So
The elongated stain here.
which way is it on the garage floor? Is it perpendicular or I guess parallel?
So if you turn this photo clockwise, they would align.
Okay.
It was just taken from a different angle.
Picture 12.
Stain GE3 in the center of the photograph.
Oh,
Stain G.
I apologize. Same question with respect to GE3.
Similar, the scales did not move.
Okay. And GE4?
GE4, again, the stain in the center of the photograph, and the scale did not move from the overall.
And GE5?
GE5, similar. Is this elongated stain here? And again, it's oriented, the scale's in the same position in the overall photograph.
Just safe to say it's the way the photograph was done.
Exactly, it's just the way the frame was taken.
And picture 15, please.
15 is a photo of a stain on the garage floor. Appears to be a tire mark.
Thank you. If I may, Your Honor, the state's going back to states 9.
Oh my gosh, they even turn pages aggressively. It's like bam, bam, bam.
States 9, file 13. Sir, what does that depict?
These are the garbage cans that were found inside of the garage at 69 Wells. They were in the corner of the right-hand bay. The garage door would be on the right-hand side of your photograph.
And did you find anything of evidentiary value on the garbage cans?
Yes, there were blood-like stains found up and around the lids on both garbage cans.
Photograph 2, what is that?
That is a photograph of the left garbage can.
And photograph 3.
Again, that appears to be the left garbage can. And you can see the blood-like stains both here and here.
What are you doing?
Photograph 4.
That is a photograph. I prefer my report to get left to right.
If it would refresh your recollection,
Yes.
please.
That's a photograph of the left-hand garbage can that you saw in the overall photo. This was taken during the evidence collection process. And it was tested, swabbed, and collected as State Police Exhibit 66 from this area here.
Were there other swabbings that were taken out of the garbage cans?
On the right-hand garbage can. So that's a right-hand garbage can. Again, in a similar area, we found a blood-like stain.
Okay. And with respect to the garbage cans, about how many stain or swabbings did you take in all of the left garbage can? If it could refresh your recollection, could you go get your report, please?
Still the same, 2 swabs.
And with respect to the right side garbage can,
2 swabs.
and were those also tested?
Yes,
And the results?
positive.
So positive for blood.
Now,
Swabs
sir, did
on
you
the
all have an
trash
opportunity to examine the Chevy Suburban that you, or be part of the processing of the Chevy Suburban that you earlier in the day had gone to Lapham Road to
Yes.
examine? You can have a seat, sir. When was that?
That was on June the 28th, so it would have been the Tuesday after Memorial Day.
And actually, prior to leaving 69 Wells that day on May 27th, 2019, you testified earlier about latent prints. Did you conduct any latent print documentation?
Yes, we did.
Okay, I'm actually going to go to States 9, File 4. Where did you take latent prints from?
Well, we searched for latent prints around the points of entry.
I'm going to object as non-responsive.
Well, the question is, where did you take latent prints from? And the answer was, we searched for latent prints. So it is non-responsive. to
I
say.
will ask some foundation questions, sir. What exactly is a latent print?
It's a, lack of a better term, an invisible fingerprint. A fingerprint that's deposited on a surface that needs some sort of development to make it visible.
And is there a process that you utilize in searching for these?
Yes.
What is that process?
Process is visual observation, utilizing side lighting, different lighting techniques. And then in this case, it was the application of just standard fingerprint powders.
And how does fingerprint powder allow you to search for latent prints?
The fingerprint powder is extremely fine, and it adheres to the fingerprint residue and makes the print visible.
And did you conduct that process at 69 Wells?
Yes.
At what locations?
Various locations throughout the house, the first floor, in and around the points of entry, around the mudroom door, around the kitchen island.
I'm going to show you some photographs, sir, if I can. If you take a look behind you, States 9, this is File 4. What do you see, sir, depicted in that photograph?
That's an overall photo of the door leading into the mudroom from the garage after latent print processing and prior to the collection of the prints.
And, well, actually, I'm sorry, I went too fast. If you could, would you mind standing up and going back to the screen? Thank you. Couple questions, sir. Where is all on that photograph, if anywhere on the photograph, you mentioned the black powder, fingerprint powder? If you could just describe it for the record, please.
Right. It's all it's this dark color smudges all over the white door.
Did you put that on there?
Yes, I was one of the people who searched for latent fingerprints with
I'm going to object as non-responsive. It's either he did it or it was one of the people.
Well, the question was, did you do that? He said he was one of the people, and the court understands parenthetically who did it. Overruled.
What is the process for putting that fingerprint powder on a door such as this?
We have special brushes that we use that we put the fingerprint powder on and apply it to the surface. And sometimes fingerprints readily appear, become visible. Sometimes it takes a little bit of work to clean up smudges and things like that with the brushes.
And how would you do that? Clean up smudges, or what do you mean by that?
Oh, you just, if to get more detail out of the print, you'll work it with finer brushes, smaller brushes to try and clean out the fingerprint powder from in between the ridges that you see on the print.
Did you develop any latent prints out of the mudroom door?
Yes.
Where?
Right here above the lock cylinder.
I'll show you what's been marked as states. Picture 2. Sir, what does that show?
So this is the latent prints prior to collection, prior to lifting them.
And what do you mean by that?
So we will take photographs, obviously, to try and pick up the detail. And then once that's completed, we'll go ahead and take adhesive lifters. Usually it's adhesive clear acetate, almost like tape. In this case, down here, we used a gelatin lifter, which is a thin layer of gelatin on a rubberized backing. It's just used for different surfaces.
And the markings on the measurement tape, or the white stickers, I should say, what exactly does that mean?
So the LP stands for latent print, so we run them sequentially, so this would be
Your
latent
Honor,
print.
again, I'm going to object unless he's referred to himself in the plural. I would ask that he at least clarify whether he did this or someone else did it, just for clarification.
Well, the question, as the court understood it, is not whether he did it. He was asked to explain what those designations mean, if the court understood it correctly.
That was the state's question, Your Honor.
Overruled.
So this is my handwriting on the markings. So LP stands for latent print. Latent print 7, which is also designated as State Police Exhibit 82. Here, LT8, latent print 8, State Police Exhibit 83.
Did you go anywhere else in the house and conduct this process?
Yes.
Where?
The kitchen of the residence.
And with respect to the mudroom door, is this the side going to the garage or the side going into the kitchen?
So this is what
Hi, Bacon Bit.
we designated as the exterior side. So this is the garage side of that mudroom door.
Picture 3, do
you,
you recognize
Jamie.
what's depicted in this photograph?
Yes, this is the the area
Anniversary.
around the inside face of the mudroom door. You can see down here where I had removed the doorknob. So this is one of the casings. You see LP1, late print 1, exhibit 73. Above that, late print 2, exhibit 74. And down on the wall, exhibit 75, which is late print 3.
The blue writing, is that actually on the wall?
Yes, I did that with a grease pencil and China marker.
Why would you do that?
That designates which one I'm actually looking at, or what the actual lift is. So and it just depends on the amount of detail in that print. So in a photograph, if I just put up a scale, I don't know which one of these is the exhibit. That's why we circle it with the China marker, and the arrow just orients the print. And then sometimes that gets picked up on the lifter itself. So it's more for the examiner.
Did you search for latent prints in the kitchen area?
Yes, I did.
Where?
Mainly around the kitchen aisle, or where I found those other exhibits.
I'm gonna show you what's been marked as picture 4. Do you recognize what's depicted in this photograph?
Yes, that's the inside of one of the cabinet doors.
And if you can, that same blue writing is on there. Can you explain that, please?
Correct. That's I marked out the print in blue China marker and designated it as latent print 4, exhibit 76.
Show you what's been marked as states 5. What does this photograph depict, sir?
That is on one of the entry doors. May I refer to?
If it would refresh your recollection,
Thank you.
please.
Hi, Tina. Hi, Dallas.
Okay, this is the French doors leading out to the backyard, the rear patio.
And if you could walk me through, did you do this one?
I'm not sure if I dusted this, but I designated it and marked it up.
And if you could just walk me through what you did.
Okay, so after the latent prints were developed, I go around, people tell me where they found prints, and I will go around with a magnifying glass, pick out the prints with the best detail, mark them, and label them in a similar manner, then notify the photographers to, as to their location so they can be properly photographed prior to collection.
And picture 6, please.
That is off of a exterior door handle, and if I could refer to my report, I can get you the correct door.
If you can, thank you.
Okay, that's the same set of French doors that we took prints off of in the previous photograph. And this is one of the exterior handles. And you can see the latent print here. I remember developing this, and then I went ahead and marked it as Exhibit 80, latent print number 6.
Thank you, sir. You could have a seat. Now, I asked you previously about the Chevy Suburban. If you can, just briefly, and did you have an opportunity to process the Chevy Suburban at a later date?
Yes.
What day was that?
It was the 28th of May in 2019.
Where were you located?
At the New Canaan Police Department. The vehicle was located in their Sally Port.
And who was with you during that processing?
It was Sergeant Joe Duva, who was our supervisor. It's myself, Detective Gavin, I believe Detective Pearson, Detective Keppel.
And if I can, sir, I'm going to draw your attention just to take a look behind you. This is under States 9, File 14, Picture 1. Do you recognize that, sir?
Yes, that's the Chevy Suburban prior to our start of processing.
Picture 2,
That's the rear of the Chevy Suburban.
Picture 3,
That's a view of one of the running boards of the Chevy Suburban.
and if I can scroll in a little bit. Sir, what is depicted in the white marker and the, I guess, pink arrow as well?
Right, so that's a blood-like stain we found just above one of the running boards. It was designated, tested, and swabbed and collected in the same manner as we did in the house.
And with respect to the results?
The test results were positive.
And the swabbing, did you conduct that in the same process as you did the 2 swabs? and
Yes, 2
every-
swabs, same collection.
Okay. Now, were you wearing gloves and protective gear in the course of processing the vehicle?
Yes, just gloves.
By the way, what was your assignment with respect to May 28th processing the vehicle?
I still maintain the position of evidence collection officer for this.
Okay. Picture 5, sir.
That is a blood-like stain pattern found on the lower edge of one of the doors.
And picture 6.
And that's a sample from the stain pattern. I tested, collected as State Police Exhibit 106. The arrow denotes the stains that I took.
The stains that you took for what?
Oh, I'm sorry, that I swabbed and collected as evidence.
State 7.
Again, those are additional stain patterns found on the door of the Suburban.
And state 8.
And that's another blood-like stain pattern.
And same questions, same.
It was tested, collected, and marked in a similar fashion, collected with the 2 swabs.
States 9.
That's the blood-like stain that I first saw on the bumper on Lapham Road. And again, I tested it, collected it, and marked it as State Police Exhibit 105, and the test results were positive.
States 10.
That is blood-like stains that were found on the steering wheel of the Chevy Suburban.
And same question, sorry, did you?
Same collection method. It was tested. Test results were positive. It was swabbed and collected as State Police Exhibit 118.
Were there also any swabbings done further of the inside of the vehicle?
Yes.
Where?
I do believe we did DNA swabs of the various parts of inside the vehicle in an attempt to collect DNA. So we choose these areas based upon the areas that people touch when they're driving. So the insides of doors, steering wheels, top and bottom, gear shift, areas such as that.
States 11. What does that depict, sir?
That's the rear cargo area of the Chevy Suburban. The adhesive scales in the pink arrows denote areas where blood-like staining was found.
Specifically, I'm going to ask you about states 12. What is that?
That is an area of blood-like staining. It's hard to see with the dark carpet. And that was found in the rear cargo area. It was tested, collected and seized in the same manner as all the other swabbings of blood-like stains. It was denoted as State Police Exhibit 121.
And the test results?
Test results were positive.
And one more, sir. What is that?
That's a blood-like stain found on the driver's side wall of the rear cargo area. This also field tested positive for blood and was swabbed and collected as exhibit, State Police Exhibit 120.
Your Honor, with respect to the next few photographs the state intends to introduce, I know the court's ruling previously, but if I would, perhaps now would be a time to excuse the jury for a few minutes, or the state can go into it.
Well, the court would not expect 10 minutes worth of argument.
No, sir.
So, ladies and gentlemen, we will excuse you for a brief period. There will be some discussion of the next exhibit. And so we ask that you retire to the deliberation room and please do not discuss the case.
All right, let me.
Please be seated, please.
Sure, Your Honor. If I may, I believe it is. This would be picture 14, picture 15, and picture 16.
Thank you.
So these are the luminol pictures from inside. Is that what they're about to?
Easiest way for the court to probably do this is just a
If I may.
brief offer of proof as to how these exhibits are going to be explained.
If I may, Your Honor, may I just
Yes.
inquire of Detective
Yes.
Riley? Thank you. Detective Riley, I'm going to have you draw your attention to photograph 14 behind you. What does that depict, please?
That's a photo of the rear cargo area. It's a time exposure, so the photo's taken over a longer period of time after the application of a chemical called luminol.
Okay, a couple questions about what you just said, okay? With respect to the content of the photograph, you said rear cargo area, is that of the Chevy Suburban?
Correct.
Okay, now with the, were you present when this happened?
Yes.
Okay, you used the word luminol, what does that mean?
It's a chemical that we use
We all know what it is.
to detect latent blood, that is blood that's not readily seen. We use it as a search tool. It's not we don't use it as a presumptive. We use it to search for blood that's not readily visible. If we find stains of or areas of interest with the luminol, we'll go ahead, conduct further observations. We'll utilize the KM test, and if the KM test is positive, then we'll take evidentiary samples from those areas.
And with respect to a luminol, does that give it any presumptive, wait, you said luminol for blood that's not readily available, how does that work? or readily seen, I guess is the way you said it.
Correct. Yeah, the blood, we use it to search for latent blood. So the luminol reacts, it glows blue due to the iron present in blood. However, it reacts with substances that contain iron, along with several other different substances. What we do is once we mix up a batch of luminol that we're going to use on scene, we'll apply it to our known blood sources, the horse blood, pig blood, and see how that reacts, and then we'll use it on an area of interest and see if we see any similar reaction.
So is it really the detection of iron? Is that what luminol is looking for?
Well, that's what luminol reacts to in blood.
Okay. And with respect to the fact, well, strike that if I can. You said you mix it up on scene.
Yes.
Walk me through that process.
So we get our luminol from a forensic supply house. It comes with a solvent, a bottle of solvent, and the luminol comes in powder form. We follow the instructions, we mix them together, we attach a spray head, and then we'll apply it to a surface.
Is this something that you're trained in?
Yes. I remember one class where we did use luminol.
And is this a tool that you have utilized in the course of your career at the Connecticut State Police?
Yes.
About how often?
Not a lot. I would say I've probably applied luminol 15 to 20 times.
And with respect to the photograph exposure process, how does that work?
So we'll set a camera up on a tripod so it's steady. We'll put the camera settings to keep the shutter of the camera open for a longer period of time. And then we'll apply the luminol, and if there's a reaction, we'll open the shutter, the camera will do its thing, and once the photograph's complete, we'll move to a different area.
Is there a lighting on anywhere around?
Yeah, I apologize. So luminol has to be used in a darkened room. The bluish glow is very faint if we have a reaction. So in this case, we close the sally port door. If there were windows on it, I don't remember if there were, they would be papered over. So we basically work in the dark with flashlights.
If I may have one moment.
No.
That would be the state's offer, essentially.
Yeah, briefly, cross.
Well, this is just essentially an offer of proof.
Yes.
So this is how the court understands the offer. Luminol detects blood that cannot be seen with the naked eye. However, it detects, and the court is not certain that this was the testimony, it detects any substance that contained iron. That includes blood. After that, there's further testing. After that, there may be the swabbing and the collection and essentially the KM test. That's how the court understands the testimony. The photos that are viewed at this time are time-lapse photos. In other words, this isn't a snapshot, as the court understands it. It's a time-lapse photo. The blue as it appears on the screen, as the court understands it, is bluer than what would be seen typically, because the testimony in the offer was that the blue is very faint. Here on the screen, the blue is not very faint. So during this offer, the court will ask you, Detective, is the color of the blue on the photograph darker than the blue that would appear after the application of luminol?
That's what a positive reaction looks like, Your Honor.
So you would describe that as faint?
It's faint where if it was in natural daylight, you wouldn't be able to see it.
So because it's against the backdrop of essentially a dark backdrop, it looks more vivid than it would look.
That's fair, Your Honor.
Well, the defense is concerned, Attorney Schoenhorn, you may indicate.
Yeah, very briefly, the latter comment by Your Honor, this isn't how it would appear even in in the detective's visual appearance of the back of the vehicle. But my bigger concern is there wasn't, this luminol is not a detection for blood, it's a detection for iron. This is the back of the vehicle. It detects steel, iron, I understand it also can detect copper. It also can detect any vegetables or that have iron, such as turnips and horseradish, those kind of root vegetables, and a number of any other kind of food that might contain like meats and whatnot. Or
So this is back to the radish thing, saying that it can the luminol can detect the radish stuff because people just throw radish in their truck all the time, right?
hamburger, if a child was eating a hamburger in the back or it spilled a little bit in the back. So more so my concern than more so even than the concern I have about the Castle-Meyer test, where there's an observation, it was a test was performed, a presumptive test, and then it was passed on. Here, there was no confirmatory test whatsoever. Therefore, and when the DNA from these areas was later tested, there was no DNA that was determined to conform to the DNA of Jennifer Dulos. So in addition to the concern I have about it being misleading, the additional concern I have is that in light of what is going to happen later, there is no relevance to it whatsoever. And I'll just note as an aside, my other concern is that the court allowed in the Castle-Meyer multiple times, suggesting that, well, I can take care of that in cross-examination. My concern, Judge, is that's shifting the burden to the defense to go over each and every time there was a claimed presumptive test when it's going to determine that many of them turned out to be negative when they were tested at the lab. But my concern here is different, at least in the other, my other objection. There was, at least as I understand it, the court said there was a visible item that was being tested, and that was why the witness did what he did. Anything else here, he's already testified up until this point that there were items he swiped. He can simply testify that he did take additional samples in the back without getting into what luminol is, what it does, and since it doesn't test for blood, it tests, and I left out bleach as another substance that glows when luminol is applied. I don't know how that's going to, I don't even know if the state would then not put on evidence of the what was done in the back of the car, and therefore that leads to the defense having to call laboratory people to say, no, it was negative. It leaves a false impression that this was in fact somehow blood, when I think the court is correct. It only tests for things that have iron in them, and I would know copper is not iron, but it also tests for copper. But in a motor vehicle, all of those things, especially in the cargo compartment, would likely be found. And I'll just incorporate my prior arguments when I repeat them.
If I can.
Okay, so basically, because I know that this gets hard to follow. So basically, they're saying that all of this presumptive, like, you know, what luminol can be considered a presumptive test, right? But luminol is not just finding blood, it's finding iron. These are things that we already know because we've talked about that before. It can show up for cleaning products. You know what? Hearing that radishes show up, that's a new one for me. But hey, here we go. Radishes can apparently show up as well. So it can be, you know, luminol is looking for iron. So it can be cleaning products, blood, or radishes. Okay. So what his objection is here is that he doesn't want the jury to see that this is see these pictures where this luminol has detected, you know, something here with iron that could be blood, because these specific pictures, there was no confirmatory test done to show that it was blood, and when there was DNA samples done, there was no DNA on there. So they didn't do a test to further let them know if it's definitely blood or not, but they did do the DNA test and there was no DNA on there. So he doesn't want the jury to see this, because he's like, they're going to see this luminol and they're going to automatically, you know, like think that this is blood, and y'all didn't prove that it's blood.
The court can address this right now.
Or a hamburger. You know how kids and their radishes and hamburgers are.
The, again, issue of false impression, essentially giving life to what may be considered to be misleading, is not evident here. Not only is the luminol application far from conclusive, it is not even at the level of presumptive. It detects many more things than blood. It detects iron. Then there's further testing to get it up to the point of even being presumptive. So the court sees no danger for unfair prejudice or misleading evidence. The court is going to allow the evidence.
Could the court at least, what I'm not understanding, I'm not understanding Your Honor's ruling, because what the court said is it has essentially no evidentiary value, and then the court rules that it's admissible. Could the court at least articulate how it gets to that position? I'm just trying to understand down the road, since we're going to be having this happen more often than you think.
The court did not say it has no probative value. Relevant evidence is evidence that has any tendency to make a material fact more likely or less likely than it would be without the evidence. The court did not say it has no probative value. The state has the opportunity to present the case the way the state wishes to present the case. If it wishes to present evidence of luminol and latent blood that falls below a presumptive finding, that's the state's determination.
I'll just ask the court to note my strong exception, since I'll just remind the court that State v. Moody said that luminol has no probative value. So the fact that the court says it does, I don't know where to go with that other than to just enter my strong objection.
We can bring the jury back in.
Bring the jury. So he's saying the judge is ruling that it can come in, like they don't have to show they don't have to
Just prior to the jury coming out, Your Honor, those 3 photographs are still ID only. May I
necessarily
inquire,
prove
they moved to
everything.
full exhibit at this time?
The jury will be able to decide what weight they give to that.
Will counsel stipulate to the presence of all of the jurors?
Yes, Your Honor.
Thank you. Do you wish to make your offer of those exhibits, counsel?
Yes, Your Honor, I would. This would be States 9, File 14. The offer involves photographs 14, 15, and 16.
And objection, Attorney Schoenhorn.
I stated my objection.
Thank you. Overruled. Which numbers are they, please?
They are States 9, File 14, numbered photographs 14, 15, and 16.
States 9, file 14, photographs 14, 15, and 16 admitted as full exhibit.
Thank you. Sir, if I can, I'm going to draw your attention here. States 13, if you can take a look at it, sir, is that, where is that located in the Chevy Suburban?
That area is in the rear cargo compartment of the Chevy Suburban. That would be on the driver's side.
With respect to the rear cargo area of the Chevy Suburban, did you do anything in the course of processing the car with respect to that area?
Yes.
What did you do?
So we conducted a search for not only visible floodlight stains, but latent floodlight stains.
What do you mean by latent?
Latent just means that you can't see it. You need something to be developed.
And what did you do to develop that?
So we utilized a chemical called Luminol that we get from a chemical supply house. It's a liquid that you spray onto a surface in a darkened environment, and it will react with the iron contained in blood and glow a faint blue.
And with respect to reacting with the iron in blood, does it react to other things as well?
It reacts with a lot of different things.
Can you name a few, please?
So it reacts with iron, or anything with iron in it. It'll react with bleach, so it's of limited use in like a bathroom. And it will also react with some foods as well. There's a laundry list. We utilize it as a search tool. We have to do further presumptive tests, and then of course, any samples that we collect, we have to send to a laboratory for a confirmatory test.
And just for the record, the photograph 13 behind you, was that KM tested as well?
That exhibit was KM tested.
Okay. And seized as exhibit, what exhibit number did you seize?
State Police Exhibit 120.
And with respect to the pink arrow, what does that depict?
That's the area where I took those evidentiary swabs from.
Now I'm going to show you what's been marked as States 14. What does that depict, sir?
That is a time exposure of our application of luminol.
Of it. Well,
Oh, I'm sorry.
of
This
what?
is, sorry. This is the rear cargo area of the Chevy Suburban. While it was still parked in the Sally Port, we closed the doors, we make it a darkened environment. And we sprayed luminol throughout the rear cargo area. It took several time exposures.
Where do you get the luminol from?
We get it from a forensic supply house.
And how do you, I guess, apply the luminol?
So it comes, the kit that we get from the chemical supply house comes with a bottle of solvent, and then luminol comes in powder form. We mix those two together, we attach a spray head, and then we do a test on our known blood samples, either pig blood or horse blood, and see what kind of reaction we get. Then we will apply it to an area of interest and see if we get any reactions. If we get reactions, we'll go ahead and test those areas with the Kastle-Meyer test, and then determine whether or not we want to take evidentiary samples.
And did you do that in this case?
Yes.
Okay. How did you take a photograph?
The photograph is a time exposure. So basically, we put the camera on a tripod and either set the automatic settings or set shutter settings. So this shutter stays open on the camera for a longer period of time. Since it's a darkened environment, it takes that amount of time to take in enough light to make a photograph.
And were you, I'm going to show you behind you States 15. What does that depict, sir?
That was taken during our luminol examination. That's, again, the rear cargo area of the Chevy Suburban. I believe that's more focused on the driver's side of the vehicle.
And States 16. What does that depict, sir?
Again, taken during the luminol examination, and that's the passenger side of the rear cargo area.
Did you have an opportunity to examine the Chevy Suburban at a later date?
Yes.
When was that?
June the 26th of 2019.
And what was the purpose of that?
The purpose of that was to try and search for additional biologic material to aid the medical examiner's cause and manner investigation.
Did you look at a specific area of the vehicle?
The undercarriage specifically.
And by undercarriage, what do you mean?
The underside of the car.
File 16, show you picture 17. Do you recognize that?
Yes.
What is that?
That is the Chevy Suburban, Jennifer Dulos' Chevy Suburban.
Where is the location of this? Where was the location of this processing?
This was processed at Troop G Bridgeport.
Yeah, it's translator.
Picture 18. What does that depict, sir?
That is the passenger side of the Chevy Suburban. You can see the black metal of the door on the upper part of the photograph.
If you wouldn't mind, again, sir, if you can get up and point to the photograph, please.
So you have the vehicle here, and here is the undercarriage. This is the underside of the step bumper, frame rail. And this is some blood-like material we found on the edge of the undercarriage.
The word written on the white side, what does that mean?
So that was placed there by the photographer to designate which direction is the front of the vehicle, because the photographs can get a little confusing.
Picture 19, what is that?
Okay, this is an item of interest that we found during examination of the undercarriage. Again, this is on the passenger side. We're looking at this clearish little specimen right there. So, and we designated this as item A. Our collection process for this is I removed this with a sterile scalpel, packaged it in a little paper fold, and later the next day transported it to the medical examiner's office so he could do he can put it underneath the microscope, look and see what kind of cells are there. In the same area, after this was removed, I went ahead and swabbed the area with sterile water, same manner, with 2 swabs.
And photograph 20, please.
Item B, I believe it's on the frame rail. So you can see the exhaust here, bolts for the running board. And so I'm looking at this little fleck of material right there. Again, this was collected in a similar manner.
Picture 21.
Item C is on the running board. It's this area here. You can see it's a little heavier of a stain. There's a little, it appears to be like a little yellow to it. It's different than, there's more there than just typical blood-like stain, so that's why it was an item of interest. Again, this was collected in a similar manner, scraped off into a paper fold, and then the area was swabbed afterwards.
Picture 22, please.
This is a photo of what would look to us to be a footwear impression on inside one of the wheels of the Chevy Suburban. And I believe this was taken on the 28th of May during our vehicle processing.
Picture 23.
Again, we printed the exterior of the vehicle. And I believe we took a swab from here, but I'm not really sure.
Would it refresh your recollection to take a look at your exhibit report?
Yes.
May I approach the clerk, Your Honor? So I'm going to show you what's been marked as ID, states 12. If you can, just take a look, and please don't read from it. Let me know when you're done.
Radish Gate.
Did that refresh your recollection, sir,
Yes.
if there was a swap done of that photo, what's depicted in that photograph?
Yeah, so this is the exterior side of the vehicle's tailgate. I believe this is the bottom edge right here. And during our examination of, you can see the application of fingerprint powders. Right there. There's not a lot of, there's absolutely no ridge detail here whatsoever. However, it was handled, so we swabbed it. I took 2 swabs that were moistened with sterile water, swabbed this area, and then collected it and designated it as State Police Exhibit 113.
And picture
So the other ones that they were showing, when he was talking about the undercarriage, when he was talking about taking all of those samples and all of that, that's going to be to aid the medical examiner. Remember, the medical examiner doesn't have a body to go by, so in order to be able to determine any kind of, anything, they need some kind of jumping off point to stuff to look at. So they went through all of this and all of that stuff. The medical examiner was not, they weren't just testing for the blood, but the medical examiner used that to see what type of cells that was, so it would give a better idea as to the injury sustained, and the like all the clearish stuff, like the whatever it was underneath, he would collect that and then give that to the medical examiner.
24, sir.
This was taken during a latent print exam of the exterior of the vehicle. Again, we're running sequentially with latent print numbers, so this is latent print 11, State Police Exhibit 114. And again, I designated it with blue China mark, arrow for orientation.
And picture 25.
It's appears to be like a partial palm print found on, I'm not sure where exactly this was on the Suburban.
Would it refresh your recollection of the capability report?
Yes.
And just for the record, I'm almost done with this section. And one more question after this.
Well, it's the answer, the length of the answer that concerns the court. So the court is going to conclude for lunch recess after this photograph.
Thank you.
This is this was developed on the rear edge of the right front door. So, kind of near the window, okay? And so, again, designated as latent print number 12, Exhibit 115, marked and lifted in the same manner.
Thank you.
Okay, thank you. Ladies and gentlemen, we approach our luncheon recess. We plan to resume at 2 o'clock. Please do not discuss the case. Thank you.
And just like that, we're caught up. Crazy, crazy. So,
All rise. This honorable Supreme Court now stands in recess until 2.
Thank you.
so it is 2 o'clock now. Let me see if I can find the new stream and see if it started yet. No more speed trial. And we can watch we can break it up a little bit and watch one of the hearings from earlier if y'all want to. They haven't started yet. It's showing that yeah, it hasn't started yet. So I know it does feel like, the thing is when it's going through stuff like that and it's like super tedious, I won't say boring because this stuff is really important, but when it's super tedious, it feels like it's so slow. So, yeah, so there's that. If you want to, though, we can, because they haven't even started back yet, we can watch, let's see, what did we miss today? Lucy's snoring. She's... Oh. They just came back. Hold on, let me pause it so that we don't miss anything. All right, let's see. Okay, did y'all want to watch one of the other hearings while we, so we can watch that a little bit faster, Murdaugh? Okay. There was, let me look at my, let's see. It looks weird seeing him in a different courtroom. The Murdaugh audio is rough. Okay, let's see. what happened? I think Ferriter, I haven't watched it yet. I didn't get to watch anything while I was gone. So I haven't watched anything, but I think I saw that they set a trial date for her, but I don't think that one lasted very long, so we can watch that one too. I'm going to skip through this and we'll just get to the arguments part.
Contention by the state that this, because of the non...
Oops. Yeah, I know there's so much today. They didn't start the audio until later, huh?
trial.
Oh, there we go.
On October the 17th, 2023, defendant Murdaugh received the final trial transcript and very shortly thereafter filed a motion for new trial in the Colleton County Clerk of Court's office. Subsequently, Judge Clifton Newman recused himself from further proceedings in this matter. On December the 16th, 2023, on December the 18th, 2023, Chief Justice Donald W. Bailey signed an order appointing or directing that the Honorable Jeannie Hafer Toll, retired Chief Justice of South Carolina, be assigned exclusive jurisdiction for the limited purpose of presiding over defendant's motion for a new trial. I promptly contacted counsel in this case and set deadlines for briefing and arguments of the new trial motions. The new trial motions were set to be argued on January the 23rd, 30th, and 31st of 2024. And after several rounds of pretrial briefs having been submitted to me, I also set today's date for a procedural pre-hearing. Before I begin, may I say that we certainly welcome members of the media, and I thank publicly Attorney Jay Bender for agreeing to be the voluntary media coordinator for this matter, as he did for Judge Clifton Newman on the trial of this matter. Cell phones are normally not permitted at all in our courtrooms, but the press have been allowed to bring in certain cell phones and laptops and electronic devices because of the non-jury nature of this portion of the proceedings. But if any device rings or sounds to receive a call or to receive an email or a message, that device will be confiscated and the owner will be asked to leave the courtroom. So
Okay, I'm going
please know today, things that they were. The first topic is an evidentiary hearing necessary at all? The state took the position the answer to that was no. Obviously, the defendant not. I have set an evidentiary hearing because I felt like we had to have some brackets on the time we would spend on this matter. But I've made no conclusive decisions beyond that on matters affecting the arguments the state makes about the procedural posture of this matter. The next topic would be the burden of proof. Who has the burden of proof in this matter? And what must be shown to meet that burden of proof? And what must then be shown to contest what has been shown and proved? The third topic is procedural defects, most specifically a contention by the state that this motion is untimely because of what was known before a verdict was rendered, accepted, and the jury poll. And finally, we need to discuss witnesses, juror witnesses, the clerk of court of Colleton County has Hill, and other witnesses and exhibits. I note that at least one attorney in the room is an attorney for some of the jurors, and other jurors may have other attorneys. When I get to the portion of this discussion where we talk about specific witnesses, and if I am asked to hear from attorneys for the witnesses, I will at least consider that request. I don't know where we will be at that time in terms of what has been decided, but I will at least inquire about that. To that end, if you have not already, during the first break, be certain that all of you, the lawyers participating at council table, and any other lawyers that feel they may have some interest in the proceedings that would warrant comment by them, parents, you may proceed.
Sorry.
I would.
Okay.
Skip
You raised
forward a
a number of legal issues from whether we waived, I forget the order in which you just took them, but Mr. Griffin is going to address those in seriatim based on what you said just a moment ago as to the witnesses and the jurors I will be handling
Hi,
that
Jen.
portion of the argument today.
Very good. Mr. Griffin, we'll hear from you now.
Yes, thank you, Your Honor. The first issue that you've asked us to address is an evidentiary hearing necessary? And the answer to that question is very straightforward, is yes. Under established case law in the Supreme Court, the Fourth Circuit, and the South Carolina Supreme Court under Reamer, a Reamer hearing is absolutely necessary where there has been credible evidence presented that there's been improper third-party contact with the jury prior to their deliberations that frankly, whether it goes to the merits or not, a Reamer hearing is absolutely necessary. And we believe that the Court of Appeals decision in this case contemplated a Reamer hearing. In a Reamer hearing, evidence is presented as to what outside influences, if any, were brought to bear upon the jury. We have, in our motion for a new trial, submitted affidavits of one deliberating juror, one alternate, and then another affidavit of a witness to an interview of an alternate, and all three statements are consistent, and in that they heard Ms. Hill, the clerk of court, prior to deliberations, and frankly, before the defense put on their case, Ms. Hill instructed, do not be fooled by the defense. That's what the sworn statements say. And secondly, before Mr. Murdaugh took the stand, Ms. Hill advised one deliberating juror and two alternates, at least, watch his demeanor, which is an implication of, he's going to lie. And so then the question becomes, factually, did those contacts happen? And then, we proceed from there as to what the burden of proof is after that. But the threshold, are we entitled to evidentiary hearing? The law is crystal clear that we are.
Thank you, sir. Mr. Waters, to the state.
Thank you, Your Honor. May it please the court. Your Honor, obviously, you've addressed the issue of whether an evidentiary hearing is necessary. The state certainly understands that. It is incumbent upon us, though, based on the law, to preserve our arguments as to procedural bar, and those are twofold. And the first one, of course, is that a motion for a new trial must be filed within 10 days of the verdict, unless there's after-discovered evidence. And I think an initial inquiry that needs to be determined is when the defense first learned of these particular allegations in conversations with the defense, and they said they're going to give me an answer, that they may have had conversations with Juror 785 prior to her being represented, which was only a couple days after trial. So if that is the case, and they were aware of these allegations, then we would want to argue to Your Honor and preserve the issue that this is not after-discovered evidence and that there's a procedural bar in that regard. Secondly, we made the argument that the affidavits on their face, the only deliberating juror indicated in that 630, in that affidavit only said that she voted guilty. She had questions but voted guilty because she felt pressured by other jurors. And of course, the law is crystal clear in multiple cases that sort of internal debate is actually in Rule 606B, that's not any sort of misconduct or anything that is an appropriate venue or mechanism in order to attack the verdict. So for that reason, we've argued that their showing in their motion for a new trial is insufficient based on the case law for an evidentiary hearing because there is, on its face, no sufficient allegation of prejudice. That being said, of course, we fully understand and expect the evidentiary hearing to go forward, and we'll be happy to address burden of proof after the defense makes their arguments.
Very good. With respect to, Mr. Griffin, anything in reply?
Your Honor, it does not appear that the state takes a position contrary that a Reamer hearing is required. They're arguing that we have sort of waived the right to that hearing. There's no evidence of the record of that. I can assure the court we did not know of this information within 10 days after the trial. And when we learned of it, we promptly acted. That's why I was.
Well, in conversations with Mr. Harpootli and Mr. Griffin, they were going to actually look into that and look at their paralegal's notes. So I fully rely on and trust the defense to give me a fair answer to that question. And then again, if there's an issue to be raised, we would raise that. We're not conceding anything. We just wanted to preserve our procedural issues.
I don't think we need to go back and forth many times about this. I think I understand your position. Here's my position on the matter. First of all, this is not, I am not conducting a Rimmer hearing. Rimmer is a 1954 decision of the United States Supreme Court that deals with the question of influence of the jury and a motion for a new trial on the basis of after discovered evidence of that influence. I rely on the South Carolina decision of our Supreme Court authored by Justice Kittredge, State versus Green. And the Green decision specifically says that Rimmer is not the guidance that South Carolina trial judges should look to in conducting hearings on after discovered evidence. Now, that says nothing about what the burden of proof should be, and I don't intend to say anything thereby. But I do intend to tell you right away that I will be relying on South Carolina's jurisprudence, and South Carolina's jurisprudence specifically on what must be proved in a hearing of this nature and who bears the burden of that proof. All right.
This is Justice Jean Toll.
And that leads to the very next topic that we'll now take up, which is the burden of proof. Mr. Griffin?
Yes, Your Honor. As we cited in our papers, we believe that the controlling case in this instance, based on the scope of conduct as alleged, and that is conduct of a court official, here at the clerk of court, having communication with the jury about the substance or the merits of the case, that the standard to be applied is not green, because green, Justice Kitzer says that the contact by the bailiff was about a procedural issue, not about the merits of the case. Here we're dealing specifically with the merits of the case, and the Court of Appeals decision in State v. Cameron, we believe, is the controlling standard, and in State v. Cameron, and that was decided in 1993, and the court says, in citing Holmes v. United States, which is a Fourth Circuit opinion, says in this case there was a private communication of the court official to members of the jury, an occurrence which cannot be tolerated if the sanctity of the jury system is to be maintained. When there has been such a communication, a new trial must be granted unless it clearly appears that the subject matter of the communication was harmless and could not have affected the verdict. Now, we strongly believe that is the standard. Is the question of, was the subject matter of the communication harmless and that it could not have affected the verdict? And that's our position on the standard. Your Honor, if Your Honor looks to a different standard, we believe that State v. Green, the measure of State v. Green, you can't look just at Justice Kittredge's opinion. You have to look, because he complimented the Court of Appeals decision. And the Court of Appeals decision absolutely applied the Reamer standard of the burden of production is on the defendant, but when the defendant produces evidence of a substantive communication to the jury by any third party, that's what Reamer is, by any third party, that then there's a presumption of bias, and that the state then has to overcome that presumption, produce strong, clear, and convincing evidence that it was harmless. And that was the standard that the Court of Appeals applied to State v. Green. And in State v. Green, the Court of Appeals says that this is the standard of the Fourth Circuit, and we follow the Fourth Circuit law in this area. Now, Justice Kittredge says that the communication by the bailiff, which essentially said, if you're deadlocked, which they never were and never became deadlocked, then the judge may ask you to stay locked. I mean, that was the communication by the bailiff in Green, and Justice Kittredge said that did not go to the merits of the case. Justice Kittredge didn't throw out the Reamer presumption standard in State v. Green, Your Honor. And it's important, the Court of Appeals decision, looking to the Fourth Circuit, because, as Your Honor knows, this case, and I would encourage the Court to look at the Holmes decision out of the Fourth Circuit, which we cite, which applies Reamer. It applied Reamer in a habeas corpus case when they said Reamer is the clearly established law in the Fourth Circuit. And it vacated a death penalty conviction out of North Carolina because the North Carolina courts did not follow Reamer. And so the Court of Appeals decision in Green says we look to Reamer. Justice Kittredge says, we're not going to apply the Reamer presumption here because it didn't go to the merits. What we have in this case, and what we have, presented through proffer on the affidavits, something that goes to the heart of the merits. It's the defense, and it's the credibility of the defendant's testimony. And so we do have the burden of production, but we do believe that the standard in Cameron is we just have to show that the subject matter of the communication, that it was material to the case, and that then the burden shifts to the defendant to prove that it was harmless. Excuse me, the burden shifts to the state to prove it was harmless. That's what we believe the standard is.
Mr. Waters?
Sorry, Your Honor, and I'm going to walk through some of the cases in South Carolina that address this issue. But as Your Honor is aware, of course, when we deal with these issues, we have two types. We have internal misconduct, and our courts have been reluctant, Rule 606 says this as well, to delve into that unless there are concerns of fundamental fairness, like racism and things like that. And then there's external allegations of external influence and that sort of thing. And that's what we're dealing with here today. And to quote State v. Grovenstein, which is a 1999 case of the State Supreme Court, it cites Aldrin and Kelly and says, we have consistently held the defendant must prove prejudice in these sorts of claims. And if we walk Our court has been very careful, and has much said so in Aldred, which was an internal case, to sync the analysis and the standards between those two, and have consistently held that the defendant has to show prejudice. It's their burden to do so. In Blake, in 1992, the court held, don't presume prejudice, and the test, of course, was whether or not the verdict was solely the product of honest deliberation, or whether it was the product of outside influence. We go over to State v. Kelly. Of course, Your Honor concurred with Chief Justice Finney's dissent in that case, but in that case there was a pamphlet in the grand jury room. Clearly an external influence was alleged there. And ultimately in that case, the court held that the defendant failed to show prejudice from that particular external influence. In State v. Grovenstein, in this instance, it was clearly external. There was an alternate who was present in the jury room and even took a preliminary vote with the jurors. So clearly an external influence. Far more
that audio.
In this case, that juror was removed, curative instruction was given, but ultimately the court was very clear that we have consistently held the defendant.
I see what you mean now about the audio being bad.
The burden being on the defendant. In Bryant, this was a capital case, one that I argued way back when, and in that instance there was a police investigation, background investigation into death-qualified jurors in a capital case. Clearly external. The trial court conducted an inquiry with questions submitted by the parties as well, and ultimately noted that it was the defendant's burden to prove actual bias on the part of the jury. In State v. Pittman, another case that I argued before, Your Honor, in that particular case there was a juror who had a conversation with his wife and with the bartender, and ultimately again the court held that the defendant failed to meet the burden of prejudice because the wife's comment was the defendant was not guilty, and the comment to the bartender took place after deliberations had begun. And then, of course, in Green in 2020, Your Honor just commented on that, and the court clearly held that the Rimmer presumption of prejudice doesn't apply here.
No CC available.
And then, of course, to note that the defendant bears the burden of proving prejudice. In Cameron is a case that they rely on a lot, and I would say this about Cameron, that Cameron, of course, goes on to say that the mere fact of any official communication does not necessarily mean that the jury was prejudiced, and went on again to do a prejudice analysis and a harmless error analysis. Covington is the Court of Appeals case from 2000. In this particular case, there were jurors who supposedly knew the defendant and knew some external information about whether or not he had previous difficulties with his wife and that sort of thing. Clearly external information. And again, the court held that the defendant failed to show prejudice. So the case law in South Carolina, both from our state Supreme Court as well as our state Court of Appeals, is clear, it's in sync, it's uniform, that it's the defendant's burden to show prejudice. And that's, of course, only after there's a determination that any sort of extraneous influence occurred. And that would be the state's position, that it is the defendant's burden. And again, we can address at the appropriate time what the state's position is as to the order which the evidentiary hearing should go.
Thank you, sir. Mr. Griffin, can you reply?
Yes, Your Honor. There is a tremendous difference in the law as to how the court analyzes juror misconduct, as in Kelly, where the juror reaches out to her pastor, gives a pamphlet, brings it into the jury room, and that was found during the course of the trial. The trial judge removed Juror O, who had gotten the pamphlet. Board dared every juror to ask what effect that had and if they could put that out of their mind and then deliberate. So that happened during the middle of the trial, but it was juror misconduct. All the other cases that he cited and the state relies upon are juror misconduct cases. Not unauthorized third-party communication that goes to the heart of the Sixth Amendment, right by a defendant to confront his accuser, to cross-examine witnesses who present evidence. And when a third party makes an improper contact with the deliberating jury before they deliberate, that falls at the heart of the Sixth Amendment, which is a different animal altogether than where a juror engages in misconduct. And that's where you get to Cameron. That's where you get to Green, which Green says it was a procedural communication, not a merits communication. And Your Honor, in Bryant, well, I would note, Your Honor, dissented in Kelly, but in Bryant, I mean, no jurors were interviewed, as best we could tell by the record. But in Bryant, it was a death penalty case. Law enforcement, I believe it was Horry County, were out questioning the jurors' relatives and friends and trying to get their belief as to whether they believed in the death penalty. Apparently, some of that kind of leaked back to one juror, or maybe, but there was no record saying the jurors were prejudiced by that. But the court said that behavior cannot stand. And we find prejudice based on the conduct, not on the juror's testimony. And they didn't use the word presumption, but they found prejudice. And I don't want to get caught up in this issue of do we have to establish prejudice? I think prejudice is established, but the question has to be established. But the question is it presumed under the circumstances? And if it's presumed under the circumstances, what does the state have to rebut it? And so, prejudice is a touchstone, but the question is evidentiary presumption. Here, where there's a third-party communication that goes to the merits of the case, the law is crystal clear that there is a presumption of prejudice, and the state has the burden of proving is harmless beyond a doubt.
Thank you, sir.
Thank you.
All right. Mr. Waters? I'm not going to go back and forth a million times, but if you want to have a short comment and additional part.
Very short, Your Honor. He said that these were not external influence cases, and every one of them that I listed was. Your Honor, Blake was a bailiff. Kelly was a pamphlet. Again, it was an external piece of information coming in. Grovenstein, it was an alternate. Again, that's an external influence. Bryant was a police investigation. Pittman was a bartender and a wife's comment. Green was a bailiff. And Covington was, evidence that was not admitted at trial, but the jurors were aware of. So clearly, all of those were external influence cases, Your Honor.
All right. I do not regard State versus Cameron as the guidance that needs to be used by me in making a determination about this case. It's a Court of Appeals case. Since that case in 1993, there have been several cases, including Green, Oliver, and others, that very specifically talk about this issue of what the burden is when a motion for a new trial on the basis of after-discovered evidence that involves tampering or alleged tampering with the jury. All those cases say that prejudice must be proved, not presumed. And it may very well be that that is what's going to be shown. But for purposes of what the defendant must show as the case goes forward to an evidentiary hearing, the presumption simply by the contact, which we don't have any sworn evidence about except in the area of one juror at this time. A presumption is not the way to examine this issue, but rather specific evidence about what was said, when it was said, and how it was perceived by the juror is what I believe is required by State versus Green and other cases. And therefore, that is the approach I will take. All right, the next area of inquiry
I like her.
is the procedural argument of the State that this matter was untimely made. Mr. Waters?
Yes, ma'am, Your Honor. And again, we have raised the issue, as I talked about earlier, that we believe that there is at least an inquiry as to a procedural bar, that if the defense was aware of these allegations during the 10 days, then it is not after discovered evidence and the motion is untimely. And additionally, we also, as I previously expressed, have raised the issue that the affidavits on their face are insufficient to put in play an evidentiary hearing. And there are multiple cases that have in the state that have held, I think Yarborough is one of those that have held that where that showing was not made, that the trial court properly denied an evidentiary hearing. So we would just preserve those issues, understanding the court's plan or procedure that you previously expressed.
All right. Ms. Griffin or Mr. Harpootlian, let me say that I will say to the defense, to the State, I believe that issue needs further exploration, so I am not prepared to rule that this matter is untimely in the least. We're going to have a hearing on this matter, at which time this issue will be further explored. So the State has preserved its position, but you need not argue about that matter at this time.
Thank you, Your Honor.
All right. And now the matter that to me is the heart and soul of what we're doing today is
I do too.
The witnesses, the exhibits, and the procedure needed with respect to the witnesses. And the witnesses, at least, are the jurors and the clerk of court, Ms. Hill. What I'd like each side to explore with me is how those witnesses should be presented, who should present them, and how they should be questioned, and whether there are any brackets or limitations that should be imposed on what these witnesses are asked. And I will begin with the jurors, which is really the heart and soul of the matter. Other witnesses are very secondary to the first issue, which is the jurors themselves. Mr. Harpootlian, you are the moving party, and you may proceed.
Your Honor, we agree all 12 jurors should testify. I think both sides agree, Your Honor, the question of jurors. The only question is, not only question, but the first question would be, as Your Honor questions these jurors, would you, in all the cases the judge questions the jurors, would you want suggestions from us as to what additional questions after they respond to your questions, that raise additional questions? That's number one. Number two, each one of these jurors, except of the original 12, I think all have been interviewed, maybe 2 have not been interviewed by SLED and given statements, recorded statements. The rest have all given recorded statements. And then SLED prepared a memorandum of interview. We have reviewed all these videos and the MOIs, and I can tell the court that the MOIs aren't consistent in many instances with what was said on the video, to the extent that information was left out. Now, if Your Honor is going to be very restrictive and ask, did the court communicate something to you, and did it affect your decision? I guess that's what we're hearing, Your Honor, when you're following State versus Green. If you're going to say that, ask those questions. I mean, there's some of these jurors who indicated they heard the court say what the juror that gave the affidavit for us say, and I think they're going to say it didn't affect them, which is fine. If it affected that one juror, we believe that's enough. And that juror has obviously given an affidavit to us. The alternate, which was excused, and we keep calling her the egg lady, but she was also excused. The alternate because she wasn't needed, the egg lady because the judge found that she had contact with people and discussed the case. They further indicated that the court said what we say she said, and we believe they should be examined. We'll be happy to do that, or the court can do that. So there are witnesses, and then we have the court herself. I talked to her lawyer this morning who indicated she has not made a decision as to whether or not she would assert any constitutional right not to testify, and obviously that would be on a question-by-question basis. Maybe, I don't know, I mean, we're not ready to argue what the standard is on the Fifth Amendment this morning. But if she does testify, there are literally thousands of emails we furnished last week by Colleton County, some information furnished by SLED this morning and the Attorney General, which might be utilized, I can't say right now what it would or wouldn't, depending on her answer, to impeach, to contradict. So I can't tell you what exhibits it would be or what we would do because I don't know what her answers are going to be. We believe we should be able to examine her as a hostile witness. We should be able to call her as a witness because the burden is on us, as Your Honor just enunciated. Now, the only other thing I would say is this. Even if Your Honor determines that a piece of evidence or a question is not admissible for your consideration for purposes of the appellate record, we believe we ought to be able to make it proper. So it may be that Your Honor allows us to go forward, and then in your decision decide it's not relevant, in your decision decide you didn't consider it, or whatever. But a stop and go is going to elongate that hearing dramatically. And again, since you're the finder of fact, you can decide not what a jury's going to hear, but what it matters to you. So we think that the examination of the court should be wide open, and we think that the exhibits we would use to impeach her, we would attempt to keep it relevant to the specific issues in this case. I mean, her son has been indicted, for instance, her son's been indicted for wiretapping. There seems to be some inference, at least what we read in the paper, we don't have any specific knowledge, that she was aware of that, and that wiretapping was in relation to some ethics complaint about her. That's not relevant. We're not going to ask her about it. Now,
that's not relevant, but he wanted to get it on the record right there.
We're continuing to examine whether or not there is some connection there, and we're investigating that. But at this point, I would tell you that's not where we're going. Where we are going, by way of example, is we have been furnished an email that she got on February 24th from somebody, which was a photo, a screenshot of a looks like a posting on some sort of Facebook page, where the ex-husband of a juror, not the egg lady, alleges that his ex-wife has been talking about the case, and she's going to vote guilty because she hates men. Now, we know she got it. We know she got it on February 24th. Yet on the morning of February 27th, she tells in the chambers, the hearing we were all present at, that she had seen a Facebook page posting by egg lady's ex-husband alleging that she was talking about the case, and she didn't think he was guilty. That Facebook page had never been produced, and then she produced a Facebook posting she said by the egg lady's husband. Turns out to be a guy I interviewed in Georgia apologizing for what he had posted on Friday night, which concerned his wife's aunt meddling in their marriage. I think that's fertile ground for cross-examination. Your Honor may disagree with me, but I still would like to put those items into evidence for the appellate record at the time. But the last thing I would say is this. In terms of Your Honor questioning the jurors, we need instructions from you as to whether you want, if you finish with the juror, do you want us to submit questions to you? I doubt you're going to let us question them. How is that process going to work? And will that be done someplace? Will it be done in this courtroom? Will it be done somewhere else? And if the jurors are going to be questioned outside of this courtroom, will there be a way for the public to hear what they have to say? Thank you for your indulgence.
What a weird argument. Yeah, yeah. Not a fan. Not a fan. Come on, Poop, get it together. Y'all have had time for this. This is what you've been waiting on. This is your moment. Get it together.
And Mr. Griffin rightly points out, it's not just what they heard, may have heard from the court, but did any of the other jurors, for instance, Takeaway, you keep calling her, gave an affidavit indicating that he said things like, don't be fooled, watch the body language, watch the body language testifies to Mr. Murdaugh. Did she relay that to any other jurors? It's not just what, I mean, did the sitting juror or the alternate in the
I don't think this is going how they're hoping so far.
One other point. In the memorandum of interview, now, the Cork's private lawyer, Mr. Lewis, objected to any videotaping or audio taping of Cork when she was interviewed. But in the memorandum of interview, Cork indicated she had conversations with the four-lady outside the presence of the rest of the jury about what was going on in the jury room. Obviously, I would cross-examine her on that, but it may be necessary, if she testifies to things that are inconsistent in that MOI, for us to call the sweat agent that did the interview to corroborate the MOI. The MOI may be introducible in and of itself as an exception to the hearsay rule, but I believe it may be necessary for us to call the sweat agent. We're not going to, and Your Honor, you've indicated that you're not going to want to know any sort of summaries of those interviews by the jurors when we talk back in chambers, or necessarily the MOIs. You want your own fact-finding with the jurors. To the extent that they contradict those, we may put all of that into the record for appellate purposes. And if you want to see those before you have this hearing, we obviously put those. We can put those in the record today, or have those available to you, both the MOIs and the videos. We're obviously we're going to do whatever you tell us to do. But we're looking for some guidance as to if there's anything we can get you prior to the evidentiary hearing concerning those memorandums interviewed by the sweat agents.
He basically wants full control over the hearing.
Whatever you instruct us to do. Thank you for your indulgence.
Like him wanting to be able to question them and like give suggestions on what she questions him with.
You mentioned and reiterated to me just now, and obviously you don't need to tell us this today because we're not going to be doing the questioning, but there is the consideration of 606B and the incursion into deliberations. At some point, we don't need to know that today, but at some point prior to you questioning the jurors, we'd like you to enunciate what your position is on that.
You're going to have to outline that a little bit more for me. What part of 606B are you discussing?
Well, it says, if I can find my glasses, apologize. Upon an inquiry into the validity of the verdict or indictment, a juror may not testify as to any matter or statement occurring during the course of the jury's deliberations or to the effect of anything upon that or any other juror's mind as or emotions as influence a juror to assent to or dissent from the verdict.
All right, and what are you saying that in courts for this proceeding?
Well, I mean, for instance, if we prove to you that the court said, do not be fooled, or, watch Murdaugh's testimony, watch the body language inferring he was lying, he will be lying. One of the issues is if the juror who sat during the deliberations who said that the court said that Did she discuss that with any other jurors? Did she infect the jury? Does this allow you to do that?
Well, you certainly, if you go to 606B, it gives you some guidance about that. It says, upon inquiry into the validity of a verdict or indictment, a juror may not testify as to any matter or statement occurring during the course of the jury's deliberations or to the effect of anything upon that or any other juror's mind or emotions influencing the juror to assent or dissent from the verdict or indictment or concerning the juror's mental processes, except a juror may testify on the question whether extraneous, prejudicial information was improperly brought to the jury's attention or whether any outside influence was improperly brought to bear upon any juror, nor may
that's interesting.
Nor may a juror's affidavit or evidence of any statement by the juror concerning a matter about which juror would be precluded from testifying be received for these purposes. I take that to give us the guidance we need about the parameters of the questions.
But if, again, if the juror gave the affidavit, would she be asked, did you discuss that during deliberations? Could she do that?
That apparently is very questionable under the terms of 606, and I intend to abide by that. The way those questions have been asked in many cases I have reviewed is to ask the juror whether that's still their verdict. If they ask about improper context and they talk about improper context, then the way to do it beyond that for the judge is to ask about the impact on the verdict, not on the themselves. That may be a small slice of difference, but I think it's very important to understand that no one, not myself or anyone else, is going to be asking the juror about the specifics of their deliberation, and the rule is quite clear about that.
Okay. And is it clear that you will not be using the SLED interviews or MOIs to attempt to impeach?
I told you when that was brought to my attention in our Chamber's conference this morning, I haven't made my mind up about that. I don't know what's in those summaries or anything else, and we don't have to discuss that. But again, I'm the one doing the questioning at this point, Mr. Harpootlian.
Yeah.
I'm the one doing the question at this point, Mr. Harpootlian. So that part, the 606B, is the where jurors, like if they're brought in, they don't have to testify about what happened during deliberations. So him asking for them to not testify about what happened in deliberations is kind of interesting. I'm not an attorney, but just listening to it, my thought would be, okay, well, he's saying that because he doesn't want anything to come out about what happened in deliberations, because he doesn't want it to show that they weren't, their deliberations weren't impacted by anything she said. But she went over the exceptions to that. Like there are, the exceptions to where they can, if there was something that prejudiced them or that, impacted them in a way that they would need to talk about it.
Yeah. And I'm trying to see what you all are asking, and I'm going to go to the state now and see what their reaction is to what you said.
Thank you.
I like this judge.
Your Honor, may it please the court. Your Honor, again, we would concur with what Your Honor just said about Rule 606 and, of course, all the cases that we've talked about, and the need to show prejudice. And obviously, influence that prejudice, which will be an appropriate subject of inquiry to the jurors, is whether or not there was an impact on the verdict. And we, of course, have suggested to Your Honor, not only based on the cases, that should be judicially conducted in a manner that protects the privacy of those jurors and that protects the privacy of their identities. These jurors were drafted into service, and this inquiry, of course, has to happen, but it needs to be conducted in a manner that respects their privacy and should be, of course, judicially conducted. We have suggested those two questions. If we look at the Bryant case specifically talked about the fact that depending on how the examination goes, there could be questions suggested by the parties. And obviously, I think we would need to cross that bridge if and when that bridge needs to be crossed. And that starts with the court's inquiry to those jurors, and only if something arises that needs further inquiry could that be addressed at that point. And that could be even a discussion from counsel with the court as to what additional questions may be proper. When the state first became aware of these allegations, the first thing that we did was have SLED do an independent investigation, and the goal was, good, bad, or ugly, to get to the bottom of what, if anything, happened. And the result of that is why we're still here today. And that is that in speaking with the jurors that spoke to us, that the balance of the evidence, as well as in talking to the clerk staff, was that there was no impact on any verdict. There was nothing unprofessional or or untoward that happened that had any effect on the verdict. And so when we did that inquiry, and that is what the jurors said, that is why we're here today, and that's what this hearing is going to address. The only juror that we have is the one who filed the affidavit. That's 630, and even she, or that person, only said that she, eventually voted guilty because she felt pressured by the other jurors. Did not even mention any external impact. And so unless she's going to change her story, that is what was in her affidavit. So the balance of the evidence is the reason why we're here today, and why this hearing needs to take place. Your Honor, as far as inquiry to those jurors, again, there could be a need that the parties would suggest questions, and it could be, depending on how things go, that the affidavits or maybe even the recordings, all of which have been provided to the defense, full recordings of those interviews of any potential witness in this case have been provided to the defense. It could be that issues could arise from either the state or the defense as to impeachment, and we can address those issues as they arise under the appropriate rules, 608, 613, and the like, dealing with not only prior inconsistent statements, but other evidence that would be properly impeachable. Ultimately, I do need to address one thing as it deals with all of this, and that is the defense's contention that somehow the clerk is a party opponent in this particular case, and we believe that that is incorrect. Obviously, there is a hearsay exception or a non-hearsay determination in the evidentiary rules, I believe in 801, that excludes statements of a party opponent. But just because the clerk is an elected official and of the state, that does not make them a party opponent in the way that term is defined. A party opponent is an active litigant before the case, and that is, I think, different. So we would certainly say that the hearsay rules would still be in effect as it relates to Ms. Hill and any testimony that she may provide. I know there's been some discussion about the order in which the witnesses may be called and whether or not Ms. Hill would be a hostile witness. And obviously that's under Rule 611 and I believe C, which will allow leading questions, if a person is hostile. I think, again, at this point, I don't know that any showing necessarily has been made, but I understand the defense may raise that point and we may have some arguments at that time. But I don't know that there's been such an identification between Ms. Hill and the state that would allow, A, her to be identified as a party. I think that's far out of bounds, but also that she would be applicable to allow defense leading questions under 611C. Your Honor, in looking at the type of examination that would need to happen here, and again, the issue also arose of the Fifth Amendment. And I know that the defense would like to brief that issue, and we're happy to respond. We don't know exactly how that might arise in the course of any examination. We need to cross that bridge again when we get there. We would say, though, that the Fifth Amendment is question specific, and so again, it may be something that this court has to rule, as in any sort of evidentiary presentation, question by question, based on any objection by the party. So it's kind of hard to say that exactly what the blanket position would be until we actually get to that determination. Ultimately, the defense referred to some information provided this morning. Actually, both sides exchanged last night their communications with the clerk during the course of the trial. So both sides did that last night, and there were a lot of communications with the defense as well. And so again, I just want to point that out that there's any sort of allegation or insinuation that the state's not providing information. We've been very diligent about providing any and all information to the defense, and if any additional information arises, we will continue to do so. But both sides exchanged that last night. And of course, there's been some reference in their filings as to emails that were forwarded from the clerk to me and to my paralegal, and they've actually even listed me on the witness list. And Your Honor, as we have had a chance to peruse the defense communications with the clerk, there was just as much communication and offers of help. It was just a uniform across the board courteousness that's reflected from those. So we think that that's a non-issue, and we think that should not be something that arises during the course of this evidentiary hearing, at least as it would require communication from or testimony from attorneys. Your Honor, ultimately, as we look at the inquiry that will need to be conducted, as the state has made clear, it starts with the jurors. And only if something arises in that inquiry, further inquiry to those jurors may be necessary. And that could be in discussion with the parties, as I've stated before. And then, I know Your Honor has indicated the clerk should testify, and we certainly understand that. The clerk filed an affidavit denying any of these allegations. And so, again, as we address the clerk's testimony, the state would have objections to some of the information I believe the defense would propose to examine her on. We believe that an inquiry should be limited to what is appropriate and relevant impeachment, but not should be just a far-ranging fishing expedition or full inquiry into a lot of subjects that have come up since the trial that we believe are not relevant to any inquiry that is before the court here now. Obviously, rules 404, 401, 402, and 403, as well as, which of course address relevance, and 403 objections, 404, which addresses other crimes or wrongs or acts, Rule 606, or excuse me, 608, which addresses inquiry into other specific acts and impeachment, and Rule 613, which talks about prior inconsistent statements. All of those rules potentially could come into play depending on the nature of the testimony and the nature of the inquiry. But there have been allegations since the trial about the book, about this wiretapping case, about investigations into alleged use of office for improper gain. But again, all those are subsequent to the trial. And so again, depending on how the testimony goes, the state would raise appropriate objections at that time to limit the inquiry to what is appropriate for what is before the court we would submit, and that is what occurred during the trial. So we would make those particular evidentiary objections as things developed. Ultimately, that would be the state's position. I know that we're trying to put as much meat on the bones as we can at this particular point in time, but I think the reality is that the court's inquiry to the jurors will really determine the nature of the inquiry that needs to proceed from there. And at that point, the state would take the positions that I've outlined here today.
You reply.
Please, Court, Your Honor. 404, I find it somewhat ironic. The state is quoting Rule 404, Your Honor. One of the exceptions to 404, I know this will be surprising to Mr. Waters, is motive, as if he's never heard that before. He told me this morning one of the assistants that worked for Ms. Hill during this trial was told by Ms. Hill during the trial that a guilty verdict would be good for sales of the book. Motive, selling books. So
that's not what this is about,
we should
though.
be able to get into that. We should be able to ask Ms. Hill about it. If she denies it, to call that witness, that assistant, and have her testify that she was told that. I mean, why would a clerk do what we allege she did? We think is important for Your Honor in terms of credibility and context. That's number one. Number two, Your Honor, I think we've all agreed, you're going to ask the questions, whether we agree or not. And we do agree with that. The question is going to become, as we go through that process, how, if a juror says X and they've said in their interview Y, or if they've said to us Y, or didn't include it in their original affidavit, and you don't ask that question initially, how are you going to handle, or do you care, how we suggest to you a further question? Because as Your Honor's seen this morning, the back and forth can go on for a while, and we certainly don't want that to go on with a juror. So we're going to need some guidance on that. I'm not expecting that guidance this morning. But the last thing is, as these jurors are examined, I need to understand a little bit about the logistics. Are we going to do it in this courtroom? Are we going to do it in another courtroom? Is the public going to be able to hear the responses? Will there be an audio feed if we do it somewhere else? Are you going to have cameras turned? You do it in this courtroom, have cameras turned off? And we're obviously not going to refer to jurors by their names. Even though 3 of these jurors went on the Today Show, another one went on ABC. They were all in the courtroom when the judge had them brought in. They were in the courtroom, all except one of them, for the verdict. Cameras were there then. Again, I'm sensitive to their anonymity, but I don't know that any of them have any real anonymity anymore. Saying that, I think it's important not only for Your Honor to hear their answers, but for the public to hear their answers.
He's like doing an attack on the jurors. Like, I'm not okay with the way I don't, sit down, Poot. It's like he's turned this into, instead of this being about, did, Becky Hill or anybody else speak to you, and did she speak to you? Did something she said influence you in any way? Instead of it being about that, it's like an attack on, Becky and her, his whole, it's about the motive and all of that stuff. It's like, it's more of the, pomp and circumstance and the showman, the show of it, like the circus of it, than it is about the actual law. I don't like that. And then pointing out that they did interviews, that's their right to. You don't get to sit up there and be all Judgy McJudgerson over that. I'm not a Poot fan.
All right. With respect to the jurors first as witnesses, I will be doing the questioning of the jurors.
Good.
And I will notify the parties pretty promptly what I intend to ask the jurors. The ambit of what I will be asking them is informed by the question of whether improper contact was made with them and whether it affected their verdict. I understand that
exactly.
you, on the defense side, have views about what further should be asked the jurors on two levels. One, as a predicate to what you want to do with the clerk herself in examining her. And two, as a means of further attacking the credibility of the clerk in her testimony. I have not seen any of the SLED material or memoranda concerning the state's summary of these interviews and so forth. I will be open to receiving that if it's done promptly, because we've got a hearing coming up the 29th, and I want there to be plenty of time to revise any current ideas about who to subpoena, who to call as witnesses, and who has to do that. But I can tell you that I am very, very reluctant to turn this hearing about juror contact into a wholesale exploration of every piece of conduct by the clerk alleged to have been improper on its own, indicative of her characteristics or personality or anything of that nature. This is a very focused inquiry that deals with this jury and what impact contact, if any, had on this jury. So I am very mindful of the limited nature of it. As I say, I'm not excluding submission in advance of information that would take the questions beyond the limited questions I've initially indicated. But I will be very hesitant about any of those questions as it involves propounding those questions to the jury.
Oh, I like her.
It involves questions to Ms. Hill similarly. This is not a time to explore every mistake or incorrect statement or false statement that ever has been made by this witness. I am the judge of the credibility of this witness for purposes of this new trial motion. I don't think it's necessary, nor do I think it's proper, to explore each and every impropriety alleged to have been committed by the clerk. At the same time, what specifically should be asked is something that I will look at as I look at the submissions that are made before the hearing takes place about what is requested to be allowed as topics for questioning of the clerk and what exhibits should be used. I can't imagine allowing thousands of emails to be made exhibits in this process. Either emails sent by her to attorneys in the case, to other court officials in the case, or to other individuals during the course of the trial of the case. I certainly will try to preserve the appellate posture of defense in this regard, but I will put certain limitations on just a wholesale exploration of every problematic piece of conduct, ethical dealings with the county, and so forth. This is a very focused inquiry about this jury and its ability to render the verdict it rendered in an impartial manner.
Okay, I just want to pause and say I love that, because that's pretty much what I was just saying. Instead of Poot wanting, like Poot, wants to turn this into like a big circus. Like, and look, if Becky Hill's done bad things, Becky Hill needs to be dealt with, but that's a separate thing than this. What this is about is, were those jurors influenced by any improper communication to her or anything that was said? That's it. All of the attacks on her are like, that's not what any of this is about. And I love the fact that she's like, this is a very focused thing. We're not going to let this be a big circus. We're not going to let this be a big show and, like throwing all these emails and all of this stuff in there. Whatever is, going on with Becky will be a separate thing where they will look at all of that and decide that. This is very focused. I love that she's like, nope, not doing your show here. This is what this is for. So
I say that to tell you that when the clerk is offered, and I think the clerk is going to have to be offered as a witness, the whole allegation revolves around the contention that the clerk made contact with the jury about matters material to their verdict, that contact was improper, and that it impacted their verdict. There's a whole lot more that Mr. Harpootling has indicated he'd like to explore that I regard as totally extraneous to the inquiry that we maintain. I'm not going to allow those questions to be asked by way of proffer and then have the clerk answer those questions and have that be the proffer, although I consider them irrelevant questions. We're not going to handle the case in that way. If I exclude a certain question from being asked, then the proffer will be whatever in writing is chosen to be offered in that regard. But I will not conduct a hearing where there's a whole side hearing in which every question desired is asked and either required to be answered or dealt with in some other way. I don't think that is an appropriate use of this very targeted hearing that I'm directed to have. I also think it makes a great deal of difference whether the questions that are being asked relate to the clerk's conduct at the time this case was tried, as opposed to other conduct at a later time or in connections with other things than the trial of this case. So I will be looking very carefully before we conduct this hearing and trying to give the parties as much advice as I can about what I would find to be acceptable topics to pursue. I think you're entitled to that, but I also think the record of the case is not to be used as a platform to explore each and every fault of each and every witness, whether it be the juror or the clerk. And I'm not going to have the hearing conducted.
Oh, good
in that
for
manner.
you.
I think
Good
there are
for
other ways
you.
of preserving topics that I rule should not be pursued than having those questions asked and answered, even though I rule that they are not proper in the hearing. So I hope that explains kind of where I am on the subject of how questions are asked. And therefore, some of the suggestions that are made in the filings you made with me about the additional witnesses you'd like to call and subpoenas, I think we need to be sure we're all on the same page about what is acceptable in evidence and what is not. But I can tell you that I would not allow the subpoenaing and examination of attorneys in this case, of the judge who heard the case, or any of those type of witnesses. This case is very focused on the jurors and the clerk of court, as I see it. Now, it's about 11:15, not close to it. I'm going to do this. I'm going to take a break for a minute. Let's take until 11:25.
All right, I'm skipping forward.
I'm sure they'll let.
Oops. Skipping forward.
I
I like
question
her.
only the jurors who sat and considered this case. So the alternate who was dismissed by the trial judge. That alternate did not participate in any way in the deliberations about this case. There's nothing that's been brought to my attention about anything the alternate might have done that was improper at all in terms of communications with fellow jurors. Nothing's been alleged in that regard.
Look at that face.
Our focus will be on the jurors that heard this case.
He knows that's
and not
bad.
on either that alternate or any other alternate juror that has been proposed for questioning.
He knows that's bad for him. If she's only questioning the jurors who actually deliberated, that gets rid of Egg Lady and the alternate juror. So this is, which is what we've kind of talked about from the beginning, is if this is going to be, about a trial or like a verdict or jury being tampered with, then that was one of the questions that, we've talked about before, about like how they have Egg Lady who didn't even deliberate, and then they had an alternate who didn't deliberate. And if the impropriety or the if the judge was going to say, okay, it's about the jurors who deliberated, the ones who didn't deliberate, it doesn't matter if their minds were affected by anything because they didn't actually deliberate on anything. So that answers that. And did you see his face? That's a big blow to the defense, because really most of what they have, like what they feel like they have working for them, are jurors who didn't deliberate. So his face right there is exactly how he's feeling, I'm sure, because Egg Lady is out, the alternates are out, and this is just going to be her asking the jurors who actually deliberated if their verdict was impacted by communications.
Witnesses or testimony I do not allow let me explain about proffer. Proffer will be a written proffer
That's
by
huge.
The party dissatisfied with the limitations of my ruling. But there will not be some examination as to proffer. The proffer will be a written proffer by the attorneys in accordance with their positions about witnesses and testimony. With regard to the subpoenaing of witnesses, the parties should subpoena these witnesses. And when it comes to the jurors, I would urge that the parties, the state and defendant, jointly deal with the issue of subpoena of these witnesses. I do not think it is the court's place to subpoena witnesses or order witnesses' appearances. This case is driven by the parties and their positions. The initial position of defense was that only certain jurors should be called. The state said no jurors should be called, but if you do, all should be called. All who sat on the case should be called. If the parties can't agree on how that subpoena should be accomplished, then I'm sure they'll let me know, and I'll try to take some measures in that regard. The concept I would have is that the jurors would report to a place that I will specify, and when they report, they would be taken to a room with appropriate supervision by court personnel, and then called individually to recite their testimony. And then when their testimony was complete, they would simply take their place in the jury box until all were questioned. And then if there were any questions further by me that would be collectively made to the jury, I could do that. And if there are any further questions that were submitted to me by the parties that I chose to question, I would do that. And then when all of that was complete, the jurors would be allowed to be dismissed. So that is how I would handle the juror witness portion of this. And of course, I know I'm going to get some commentary from each side about that, and that's why I talk about this in advance. The other witness that surely needs to be called because of the allegations made is the clerk of court. The state has submitted a preliminary affidavit by the clerk of court, and the defense has many areas that they want to explore for the court. Again, I would like for the parties to develop some joint way of subpoenaing the clerk of court. And if I need to be a part of that, then I'm sure the parties will let me know. But I say this for the benefit, particularly of the attorney for the clerk of court, to know that I would expect that the clerk of court will be called as a witness in these proceedings, 29, 30, and 31 if necessary. We'll be using the same courtroom for these proceedings, this courtroom. And 3B will be used as an overflow for the press. Excuse me, 3A is the one over here, and that's the one I'll be using to conduct the hearing. This courtroom we're sitting in now will be an overflow courtroom for press with I'm sure, a court TV monitor that's available for them to monitor the proceedings if there's not enough room. Based on the attendance today, it might be plenty of room, but we'll see. We'll have this I will try to figure out a way to be sure that the broadcast in here of the proceedings will not interfere with...
Oh, hold on real quick. Look at that. That must be where his handcuffs are like digging into him. That's kind of crazy.
Conduct of the hearing past this partition next door. I will trust Mr. Vendor to work with the press to arrange the courtroom and the overflow room in accordance with the rules I will set forth here and anything else that may come up that needs my attention.
So having it written proffer too, like that means that the defense can't get up there and just ask anything that they want. This is all, she's going to be in control of this.
So the first thing I'd like to do is to get some clarity from the attorneys as to what furthermore, for the parties, as to what furthermore needs to be discussed. And then after that, we'll explore with the attorneys for the jurors and the attorney for Clark Hill any other issues that still need to be developed. Mr. Hopkins.
Please report, Your Honor. I'm trying to make sure I understand what you just ruled. Are you ruling that we cannot call the alternate juror or the so-called egg lady to corroborate what was said to the sitting jurors since they were all told this at the same time?
I'm not sure I understand your question, but I'm telling you that I want the these jurors, these alternates would be called apparently to testify as to what the clerk said.
Yes.
At the present time, I see no necessity for them to be called to say what the clerk said, because we're talking about what the clerk said to the remaining jurors, those who actually sat on the case. The corroboration is something I don't think I need at this time. I think I'm perfectly capable of evaluating what the jurors tell me.
Dang!
I'll do that. I think I'm also perfectly capable of evaluating the credibility of Ms. Hill and the jurors for that matter.
Well, Your Honor, for us to, and then you said you wouldn't allow a proffer of that except in writing. Now,
Yes, I'm not going to have a courtroom proffer of any kind. If you want to proffer what would be offered by means of affidavits, copies of emails, anything else you want to, that's fine. But I am not going to have a courtroom proffer, no. I think the only reason for the proffer would be to preserve your right to appeal. I believe your right to appeal, my rulings will be perfectly preserved, frankly, even if you didn't have a proffer, but even more so if you supply an in-writing proffer.
well, I'm trying to determine whether an affidavit is sufficient for an appellate court, federal or state, when the state won't have an opportunity to examine that witness. But I mean, they've given, I mean, we can get more detailed affidavits. You know, these people are witnesses to what the clerk said to the juror who deliberated. I don't understand how that can't be relevant to Your Honor's decision. I understand there's two steps. One, did she make the statement? And two, was it prejudicial? These witnesses corroborate she made the statement.
Well, of course, that's what you say. So far, I haven't seen any of that. If that's what you say and you offer it to me in some form that I can evaluate it, I may revisit that decision. At the present time, but at the present time, I see nothing that prompts me to think I need to have people who did not sit on the case talk about what they think the clerk said to other people, when I've got to direct people to who it said that I will question.
Well, Your Honor, we did submit an affidavit. I have no problems going back.
You submitted one alternate affidavit and one affidavit of a dismissed alternate. I'm aware of that.
Right. So.
And that doesn't prompt me to change what I just said to you.
All right, we can get you more specific. I understand what the questions are you have, and I would only put those folks up to deal with those very limited issues that you described. Put them up in 10 minutes.
Well, again, I'm not going to rule in a vacuum. I'll see what you say, and I'll rule upon it.
We'll get affidavits and file them in court.
Very good.
Thank you.
Your Honor, just one issue as to logistics. Obviously, these jurors are down in Colleton County, and we're up here in Richland County. I've spoken with SLED, and in as much as we need, there may be jurors who need transport. SLED has certainly agreed to have 12 cars if we need to make sure that they're individual. They can then come in through the garage, and obviously they'll be brought up to a jury room. I think Your Honor indicated they can be in a jury room with a bailiff in there to make sure that no one's talking about their testimony and that sort of thing, but also so that they don't have to come in through the public entrance and that sort of thing. So that would be.
I think that would be a good solution, and of course, to satisfy the concerns that the defense may have, you could either have a member of the defense team or one of their employees ride with them, or if you could agree upon a sworn statement by the agent or person that does drive them that they, A, will not say anything, and B, did not say anything, then that may cure the problem too. I think you all can work that out. But I do think having proper transport would, first of all, be a comfort to the witnesses themselves, the jurors themselves. But if they can arrange something otherwise, of course, they'd be free to do that. But to the extent it's a burden on them, yes, I think that's a good idea. And in all events, I would want arrangements to be made to have the jurors come to the parking garage in this building and be escorted up in a private way into their assembly room.
And yeah, absolutely, Your Honor, and we will, and I'm sure SLED has already spoken to them about that, have uninvolved agents who will be under strict instructions not to discuss the case, and happy to have them sign affidavits or whatever.
Very good. All right, anything further before I go to the lawyers for the jurors? All right.
Your Honor, only one other point, and that is, you asked us to give you exhibits that we would use.
Yes, sir.
Having not asked or had the opportunity to ask Ms. Hill a single question, I can't tell you, and in terms of, there's not thousands of emails we've used, probably 5.
I'm just going on some of the descriptions that were in the filings y'all have made to me.
Well, we've received thousands of emails from Colleton County based on a subpoena we issued. We've received hundreds of pages from the AG's office and from SLED.
It'll make it a lot simpler if it's a small number and a discrete number, submitting them to me. Again, I told you I would evaluate that when I did.
Of course, I don't think you can evaluate them until she testifies. You don't
I think you're going to have to trust that I am going to do some evaluating before she testifies.
No.
Okay, and Your Honor, she's given an affidavit denying making any of these statements.
She has.
So these alternate jurors that have been dismissed, would you allow us to call them to impeach her if that's what she testifies to?
At the present time, the answer to that is no, as I have indicated. But again, I'm not going to rule in the vacuum. I would hope that what you all will do is send me a pretty specific idea of what you want and how you want me to permit it. So I'm not going to rule on something I haven't seen yet, which is your proposal as to exactly how these witnesses and alternates can be used.
All right, we'll get more extensive affidavits from those two alternates.
Oh, okay. That's fine, or descriptors of some sort from you as to what you intend to do. I'm not going to dictate how you do it, but I'm going to have a lot more than just kind of the generalities that have been discussed in these briefs in order to permit something.
Well, I think we're going to need an affidavit for appellate purposes, nothing else. I mean, my description to you is not evidence.
Oh, I agree. But, again, I will tell you how I'm going to accept the proffer. What you put in the proffer, in the written proffer, is up to you. I don't want to dictate that or manage it.
Well, I just want to say that we're going to hopefully be able to get affidavits from these folks.
Yes.
Much more descriptive than the original affidavits.
All right.
Thank you.
All right.
Your Honor,
Wow.
may I consult with counsel very briefly?
Sir.
They wanted Newman off the case. They got what they asked for. I bet they're like, Judge Newman, come back. You can blame it all on me. Newman, come back.
One of the things that was discussed earlier was the independent SLED investigation that was done. There were recordings of some of these interviews and MOIs prepared that were just meant to be summaries. I know Your Honor mentioned earlier that you would be open to receiving those. I just
I'd be glad to review that.
discussed that with counsel, and I believe they said, well, we want to send the ones we want to send. I think if Your Honor's amenable to that, we would just add Your Honor to the discovery upload that was provided to the defense so that that information is available to the court for whatever purposes the court deems necessary.
Can I ask this?
Yes, ma'am.
First, would that discovery upload include your interviews, the tape of the interviews, as well as your summary of them?
Yes, ma'am.
All right. I will ask you to let my clerk, Eva Diaz, talk with you afterwards about how to send me something of that volume.
Sure.
Our court, IT has a lot of barriers in our system to us receiving even conventional websites and web tools for examining in volume documents. And so I will want her to interact with you all about exactly how I am to receive that material. But yes, I would be happy to receive it.
And we would be happy to get a couple of flash drives and provide it that way, if that makes sense.
That might be the better way to do it,
Yes,
because, again, I can very easily examine a flash drive, even though it takes a long time, particularly if you're kind enough to provide an index at the front of the flash drive as to where the various materials are located. That might be better than using one of these web document sources, since so many of them are excluded from our system.
All right. Well, we'll prepare one and have a copy for you, Your Honor, and then for Ms. Diaz, the clerk, as well. Thank you.
Now, on my list, I have in the courtroom at this time, Mr. Bland, who represents certain of the jurors, Mr. McCullough, who represents certain of the jurors, and Mr. Lewis, who represents Ms. Hill. Are there others in the courtroom who represent jurors or Ms. Hill?
Your Honor, Ronnie Richter, I'm Eric Blaine's partner.
Went a little fast for me.
Ronnie Richter, Mr. Blaine's partner.
Right. Any others? All right. Well, then we'll begin with you, Mr. Bland, if you and Mr. Richter would come forward.
I just like how she's focusing so much on
Please, Court, Your Honor.
the law of it and not the show.
4 jurors who rendered verdicts in this case.
I would like their numbers, but only if that doesn't violate the attorney-client privilege. And you may give them to me now or later.
Can I give them to you later? I have them now. Our job is we want to preserve their anonymity.
I understand.
2, we want to make sure that they're not harassed. And 3, we want to make sure that the verdicts of their conscience remain. And that is not only because they voted guilty. If they voted not guilty, we would feel the same way. After hearing what Your Honor has established by the way of procedures, we're very comfortable with what you have established to protect their anonymity and that they're not harassed. Ronnie came up with a good suggestion. Maybe you renumber the jurors 1 through 12 And that way, because there has been some public disclosure.
I think that's a good
of the
idea.
jurors' numbers in some of those emails, they were the big batch of emails that Mr. Harpootlian referenced. So maybe we cross-reference with the chart 1 through 12 and the juror numbers.
I think that's a great
As far as
idea.
the questioning goes, there's no need for us to be part of this. You're going to make the questions. You've indicated that you're going to preserve their anonymity, that they can't be photographed, they can't be on videotape, and that's about all we have to add.
Yeah, Your Honor, I would amplify that I certainly respect and appreciate the significance of the issues that are before you. And I respect your decision that you're going to make this public. I would have asked you to make the jury portion a closed courtroom. And Your Honor, only for this reason, that I don't know what the jury's going to say, I don't know what you're going to rule, but let's just say in a hypothetical setting that because juror number 9 said something that you believe deprived Mr. Murdaugh of his right to a fair trial, you're going to grant a fair trial, a new trial. I would hate for there to be any mechanism for somebody to backtrace to who was juror number 9. Because I know the public has very firm opinions about this matter, and I wouldn't want that person to be subject to any kind of public scrutiny. So I would have asked of you that for the juror portion that we do closed courtroom, that the press would be present, that their likeness, both voice and face, be muddled, just as an additional safeguard. But I certainly appreciate the safeguards you have put in place. I respect your ruling. I just throw that out for consideration. And on a broader perspective, I know that you've had this experience as well, Your Honor. It's becoming more and more difficult in this state to see the jury. And I can't think of anything more injurious to jury service on a broader perspective than to see jurors who've given up 6 weeks of their lives being pulled back in for a process like this, as necessary as it is. So I worry that the process be handled as gingerly as possible so as not to further prejudice our ability to get juries going forward.
Thank you, sir. What I will do is this. I think your suggestion of renumbering is a good one. It's something that my clerk and I have talked about between the two of us as well. In every proceeding I've ever seen where a juror was questioned, in every case I've read where jurors were questioned because of allegations either during trial or post-trial that they had been tampered with, those proceedings have been in open court. And I don't feel it would be appropriate for me to have some kind of in-camera proceeding, even if it included the attorneys that would have to, and even if it included members of the press but not the general public. I don't think that is in keeping with the public nature of trials in this state and public nature of court proceedings. However, I think we could make some protective arrangements for when they testify and their ability to be dismissed after they testify that would protect them from being set upon to the best extent possible. So that is the way I will handle it, and I hope all things on balance that is as protected as you think it needs to be.
We trust you, Your Honor.
All right.
Your Honor, on behalf of our clients, we will accept their service of the subpoena so that they don't have to do so.
Well, that's great, and of course you don't represent all of them.
No, our 4.
You're 4, but that's great, and it may very well be that these parties are going to be able to work out something with respect to some of the rest of them. I don't know, but I appreciate that on behalf of the ones you represent.
Do you want me to come up and tell you our juror numbers? You want me to wait?
No, sir. You can. I don't need that at this moment.
Okay. Thank you.
Thank you, Judge.
Yes, sir. Mr. McCullough?
Would you like me here or later?
Oh, go to the podium if you would, please, sir.
Your Honor, I believe that some of your rulings today, they've satisfied several of the things I was going to mention. One, Your Honor, was, of course...
How many jurors do you represent?
I'm sorry, Your Honor. I represent number 785 and 630. One is was a deliberating juror, I suppose we could call her, and the other was the removed juror.
Right. Now, with respect to the replaced juror, I think my ruling about the end of any testimony from that juror satisfies any requirements you made. I rule that I will not hear testimony from that juror, alternate juror at the present time. Now, Mr. Harpootlian is going to submit additional information. As regards your client, I'd ask you to submit that information to you as well, and then I'll see if there's any revision of the position I take about that. You also represent one sitting juror, so you may continue.
Your Honor, the other juror was not alternate. She was an actual seated juror.
That's right, the sitting juror.
Who was removed at the end of the trial.
Oh.
Prior to the election. Whoops.
I need Mr. McCullough to speak up, please.
You need to speak up some, Mr. McCullough.
I don't get that much, Your Honor.
Yes, sir.
Your Honor, if you'll indulge me just a moment, I think much of what you've said today bears on a quote that I'm taking from the response of the state, which was filed and is part of your record. And my letter of November 10th responding to that filing is also part of your record. But, the state said that jury duty is this cornerstone civic duty. Needless exposure to jurors to litigative stress and impeachment by zealous attorneys in a case, especially of this public exposure, can only serve to discourage citizens from willingly participating in this civic duty. Your Honor, I'm delighted with your ruling that you'll be asking questions. I've been subject to your interrogative skills in my appearances before the Supreme Court, so I'm pleased with that, and I check that off the list. I would like, Your Honor, for you to take judicial notice that there have been excessive public comments by, and I have to say, Your Honor, in my letter of November 10th, I took Mr. Waters, who signed the letter, to task for labeling one of my clients, one of these jurors, as dishonest. I think I wasn't pleased with that. I think that discourages civic participation. I would ask the court to admonish the litigants, the attorneys.
Mr. McCullough, let me stop you there. I am not aware of any of what you're talking about in terms of comments about jurors or otherwise. So that's just not something I'm going to take into account by listening to it or by taking any judicial notice of it. I don't know.
Good, that's not what this is about.
I do not know anything about what you're talking about.
Well, Your Honor, both my letter and the response of the state are part of the record, which you obviously have not gotten to, but I would assume yet. My only request is either admonish lawyers, officers of the court in this courtroom and outside of this courtroom who represent people to be cautioned that this is a search for the truth, not an effort to protect the verdict, nor an effort to discourage people from participation. Negative commentary does that, or runs the risk of doing that. That's all I'm saying.
I understand, and I decline to instruct or admonish participants in this procedure in any way about what you say.
Thank you. Your Honor, next, I'd like...
Okay, can I just point out how ironic it... You know what? Let me keep my mouth shut. Why would I keep my mouth shut? This is my channel. Can I just point out how ironic it is that he wants, like, you know, he doesn't want anybody saying anything bad about the egg lady, but, you know, they have no problem getting up there, like, hardcore attacking Becky Hill, even, like to not even just like the things that, you know, she's alleged to have done, but even like how her book is poorly written and stuff. That's okay in their eyes, you know. And I say they because he's buddies with them.
Mr. Richter and Mr. Bland, appreciate your efforts. I suspect that we will decline a ride to the courthouse, but I would ask the court to consider allowing the jurors who choose not to ride with SLED agents to be permitted an entry and exit from the courthouse that would involve or relieve them of the necessity of coming through the front door.
I think I've already said that I would make arrangements for juror witnesses to report to the basement where the law enforcement station is, and they'll be appropriately directed to the assembly room.
And Your Honor, lastly, I think, if I understand your rulings or discussions about the process that will occur here, this may run at odds with it, and I'm not arguing with you, Your Honor, you know best. I am of the belief that this litigative stress that I earlier referenced could be avoided, and the public and the media not denied their opportunity to gain access and knowledge of the proceedings by not exposing these jurors to a crowded gallery and a full gallery of press by allowing its recording through, I understand Court TV will be the full camera. That is to say that I have actually in my history participated in proceedings that involved the questioning of jurors, which was done in camera. So I don't think it's without any precedent, but I would obviously respect your ruling, but I would ask you to consider or reconsider that no damage would be done to the right of the public to know and participate in the proceedings, but you can accomplish the same thing by allowing the pool camera and avoid the distraction and the imposition of that on these jurors. And
I hear what you're saying, and I'm not inclined to change the ruling I've made at the present time, but I'll keep an open mind about it as we make pre-trial preparations for the hearing. At the present time, the jurors will be examined in the courtroom, as I have indicated, with appropriate identity protection.
Thank you, Your Honor. And subject to your rulings, I will have both of my clients available for these parties as they might be needed subject to your subsequent ruling.
Thank you.
Thank you.
Your Honor, do you expect all jurors to be present for all 3 days?
So, let me make it very clear that I expect the jurors will be the first witnesses to be called in these proceedings. And the jurors will testify, and then they would be dismissed. They would not be required to stay for the rest of the proceedings at all. So that is very much part of my thought about what it takes to protect their identities. They would be protected as best I can, and the ability of others to come and to set them with questions as they need would be protected. So,
Do you expect that you could get through all 12 in one day, or should I tell them, because a couple have to take off of work?
yes, I do.
Okay, thank you.
All right. And Mr. Lewis.
This is Becky's attorney, right?
Your Honor, I'll be brief. In light of your rulings, I don't think you need much from me. The only thing that I'll add is I'll have Ms. Hill available for here as the parties need him, and happy to accept service to alleviate one issue for this court. Unless you need one from me, Your Honor.
All right. Thank you for that. And before you leave the podium, let me just consult with the lawyers. I'm not going to ask them to examine you. That wouldn't be fair at all. But I'm going to ask them if there's anything else I need to inquire of before I let you go. But as I understand it, the subpoena, and we would have a formal subpoena of Ms. Hill, would be placed in your hands as her attorney. And you would assure her appearance, and I appreciate that very much.
Absolutely.
Is there anything else on behalf of Mr. Murdaugh?
Your Honor, just in an effort to try to expedite this matter, I have 2 questions. One, will Ms. Hill meet with Mr. Griffin and I?
I'll evaluate that.
You'll evaluate it. Okay, that's all I can ask. And secondly, should we have her here on that Monday, or wait? I mean, if you're going to be doing the jurors most of all day.
She should be here as court proceedings.
All right. Thank you.
Nothing from the state, Your Honor.
All right.
Thank you, Your Honor.
All righty, moving right along.
I'll go with my checklist one more time, but I think I've covered everything I want to cover. I'll come to each of you in a moment. Yes, just to clarify other witnesses, as matters now stand, the witnesses in this proceeding would be jurors and Ms. Hill. So I want to be sure that we're all understanding exactly what's going on in that regard. I would not allow the attorneys to be called. I'm unclear about the mention in some of the papers that SLED investigators would be asked to testify, or any other witnesses. So I'm going to go one more time. I want to get real specific so you will understand what you need to prepare for by way of in-court examination and what you need to prepare for by way of submitting properly. All right. First of all, for the defendant.
Please, Court, Your Honor, just a couple of issues. One, we don't know who we're going to call to impeach Ms. Hill, because we don't know what she's going to say. So it's difficult for us. I mean, once she testifies, at that point we'd say we'd like to call so and so and so and so and such and such and such and such. Number one. Or maybe no one. I mean, she may concede every issue we have. For instance, she did tell, according to the state, she did tell one of her assistants, one of the people helping her, I hope he's found guilty because it'll help book sales. Now, again,
I hope that's the last time you're going to repeat that until I ask for it again, Mr. Harpoon. I've told you that I can't imagine a situation in which I would go that far. So, a statement like that, and she may well have said it, if it goes to anything I'm asked to consider, it would be to her credibility. And I'll evaluate whether I think that's even proper to ask, but let's move on from that.
But there are other questions concerning her credibility.
Yes, sir.
404 motive. If she did this, it is a crime. And so, the question to why she would have done this extraordinary act, and we can argue this at another time, but in terms of me the reason I mention it is for us to proffer those people now, not knowing what she may admit. That question may get asked, she may admit it. There's no witness that needs to be called. So it's difficult for me to game this out. I don't think I've ever been asked to list witnesses I would call to impeach somebody if they lie under oath. I've never heard of such a thing, but I will attempt to do the witnesses we would call prior to Ms. Hill's testimony. That's all I think I can do, if that makes sense.
It doesn't make complete sense to me because this is not the trial of Ms. Hill. Issues
Thank
about
you.
motive and so forth and the possible commission of crimes are not what this inquiry is about. It is about her contacting any of the jurors and what she said. I will be treading very carefully with a good deal of what you say about what you might or might not ask. But I am going to ask all the parties to be pretty specific with me about what I should be asking the jurors, and I can make a decision in advance as to what I am going to do about that, and what is going to be, at least by general topic, pursued with witnesses.
Yes,
And the reason I do that is because it gives me the opportunity to then consider what rulings I would make and move the proceedings along in an orderly way.
Well, Your Honor, maybe premature for me to note this for the record, but we would accept your ruling on that.
All right.
Okay. Secondly, Mr. Murdaugh has been unable to review any of the discovered material in this case because of the confidentiality order prohibits us to distribute to him while he's in jail. We don't have time in the next less than 2 weeks to go sit down with him and review everything. Would Your Honor allow him to have, and the materials are not as to the evidence in the underlying case, it's as to juror issues. And while he is no longer a lawyer, he was a lawyer at one point, and can evaluate this and be of assistance to us if he has an opportunity to review that material.
You're speaking to me about something in a complete vacuum as far as I'm concerned, so I can't really evaluate what you haven't been able to review with him and what you have been able to review with him. As I understand what you're telling me is I have received certain information as the attorney for defendant that I have not been able to show defendant for defendant's review because of the confidentiality order. I can't imagine that. I think what you may be saying is Mr. Murdaugh has not been able to keep for himself, while I'm not there, confidential materials.
That's correct.
That is something common to many folks who are under incarceration or limited in the kind of materials that they can receive and keep in their possession when they're not with their lawyer. This is not an issue where he's being deprived of the ability to consider material that you have received. This is a question of whether he can have that material in his possession when you are not there or your representatives are not there and study upon it and so forth. I can't control what the limitations of the Department of Corrections are, nor can I control what limitations may have been put on confidential material because of the fear that it would fall into other hands. So I'm not going to rule in the abstract on things. I would have to have something that's pretty specific, but I can tell you this. I would certainly not order these materials be wholesale given to him for him to take back to his cell and have in his possession, because I don't know who might see them were that the case. And if they are confidential materials, that would be an extreme risk of breaching the confidentiality of the materials to do that because of his situation. And his situation is as it is. Not my making or yours.
That's the way I was hearing it too.
Your Honor, I would only note for the record this. Much of the material we've received has been within the last 2 weeks. This hearing is scheduled for 2 weeks from yesterday.
Yes, sir.
And you've given us more stuff we have to do between now and that hearing. There's nobody to go sit with him at the jail, and his time is limited as to when those people can visit. So without him being able to review this material, I don't believe we can be effective, and we would be ineffective in representing him.
Well, I understand that those are wise statements for an attorney to make to preserve your position on the record. It doesn't change my view of how we should proceed in this matter at all. I think you will be able to, if there are deficits in what you have been able to do with your client, you will place those contentions on the record, and the appellate courts of the state will have adequate chance to review them.
Well, Your Honor, would you consider continuing hearing on the 29th to allow us to meet with the client and effectively review these materials?
No, sir.
Okay.
Thank you.
We respectfully accept your ruling.
I understand.
Thank you.
Mr. Waters?
I don't have much to address, Your Honor. The initial question that Your Honor asked was about SLED agents being listed on the potential witnesses. And, again, Your Honor, when these allegations were first raised, we instructed SLED to do an independent investigation, good, bad, or ugly. And only because of the results of that investigation, or is the reason why we're standing here and litigating these issues before Your Honor. Ultimately, the only way that SLED agents could potentially be testifying, and again, when we filed our response, we didn't know exactly the parameters of the court would rule. The only way that I could see them potentially testifying is in the event that there is a accepted witness by Your Honor that there was some sort of prior inconsistent statement under Rule 613 or some other permissible inquiry. But I think Your Honor's rulings as to the nature of the inquiry we're going to conduct would probably remove or make it very unlikely that need.
All right. Anything further?
Nothing from the State, Your Honor.
Nothing to defend, Your Honor.
All right. I say to attorneys for both sides, the court is deeply grateful for the very fine materials you have submitted so far. It's an extreme amount of work in a very truncated period of time, and I appreciate the burdens it places upon you. Mr. Hopkins, and I particularly thank you as a member of the General Assembly for not interposing your immunity because you are in session, and I respect that. I set these matters after consultation with y'all so that I could fulfill my obligations to the court as expressed in Chief Justice Beatty's order. But I realize that I'm doing that with your extreme cooperation in light of the other duties, and I appreciate it very much.
Thank you, Your Honor.
I look forward to further submissions from the parties and from the hearings commencing January the 29th. Court will be in recess.
Thank you.
Thank you, Your Honor.
Wow. Wow. That was.
I asked Ms. Harris before these matters commenced to please expedite, even if it's in a rough form and not in a perfect form, the court would like to produce their transcript. I asked her to produce a rough copy of the transcript just as soon as she possibly could for both sides. I hope you all will consider, without me having to order, sharing the expense of this production, this early production of the rough copy of this matter. She will be in touch with you, and you may be in touch with her with regard to the rough transcript of these proceedings. We'll be in recess.
Thank you, Your Honor.
So that was really interesting. I was nervous about her, like, you never know, getting a new judge all of a sudden. I was nervous about how that was going to go, but I love that, where the thing I have complained about from the beginning is this is, the defense trying to throw a bunch of, like crap all around and like have, all these things that didn't actually affect whether or not there was, a fair trial or whatever, like having all of these extra things and all of these attacks on Becky Hill and all of these separate issues that should be separate from whether or not there was a, any kind of issue that would grant him a new trial. And she just cut out the nonsense and was like, this is not an issue for this. This is not an issue for this, and focused on the issue. And I love that. She did a great job. I'm thoroughly impressed. All right. So now let's go back to, our trial. Now that we've got, like an hour and a half in, we get to speed trial it a little bit and we'll do 1.25, just enough to, as we finish with the evidence part. That, I think, those were some really big wins for the, not even big wins for the state. It was just big losses for the defense, really, because the state is just going to do what the state does there, regardless. It's really a loss, I think, for the defense, because they were really wanting all of that extra padding to make it wild. So anyway, all right, so let's get back into it. Now we are back to our trial with Troconis. Interesting. I love speed trialing with y'all. Really?
Yes.
Okay.
All right.
Picture
Here we go.
25, is that correct?
Yes.
Okay. Just briefly, with respect to this photograph, there is a arrow at the bottom right of the
Oops.
photograph. Do you see that?
Yes.
What is
Gosh,
that arrow
thank you.
supposed to do?
That arrow basically designates up, or it helps orient the print.
And last photograph on that file, 14, picture 26.
That is another latent print lifted from the Suburban.
With respect to the, was this also designated a number, an exhibit number?
Yes, this was latent print number 13, State Police Exhibit 116.
Okay. With respect to the Chevy Suburban, was there another day that it was examined or processed?
Yes, in June.
Okay, so in the June processing, what did that entail?
That entailed examining the undercarriage of the vehicle.
Okay, and was there a third time that that vehicle was processed?
Yes, that was sometime in September, I believe.
Okay. In a few months later?
2019.
2019, thank you. Where was the vehicle located when it was processed?
It was located in the impound lot at Troop L. Litchfield.
And what was the purpose of that examination?
That was to obtain more swabs from the interior of the vehicle, more swab samples.
And were any swabs taken?
Yes.
So what were those swabbings?
I seized swabs from the steering wheel, gear shift, I believe seat adjustment controls, things like that.
And do you recall what exhibit number those were?
Not off the top of my head, ma'am.
If I may just have one moment. Don't have the box up here. Never mind. If I may just have one moment, Your Honor. I'll withdraw that, Your Honor. I don't have my file for that one. May I just have a moment?
Yes.
No, I was just looking to see who it went to, and it doesn't tell me who received it. Normally, it will tell me. It doesn't show me.
Okay, so with respect to the other vehicle that was inside the garage, the Range Rover, I'm gonna draw your attention specifically to States 9, file 15. If you can, take a look behind you, sir. What does that vehicle depict, please? Or, I'm sorry, what does that picture depict?
That's the front of the Range Rover that was parked in the garage at 69 Wells.
Picture 2, what does that show?
That is the driver's side of the Range Rover.
And I'm gonna draw your attention actually down to and scroll in to the here where there's a pink sticky and a marking. It's a little blurry, but can you?
All right,
see
I'm going to go back to
that
1.5
picture?
again for this, because this part is just so painfully slow.
I can't see, ma'am, but it's marked up in a similar manner of a swab being taken.
Do you recall what swabbing that was?
Can I take a closer look at the screen?
Yes, and would it also refresh your recollection to take a look at your report?
That would be better.
If I may just approach the clerk, Your Honor.
Yes.
So now we're moving on to the Range Rover and
11 for ID.
Thank you.
what they got from the Range Rover. Ooh, apparently Adam refused to attend the hearing this morning. Judge is considering request to sever charges into 2 trials. Oh, wow.
Did that refresh your recollection, sir?
Yes.
If you wouldn't mind, if you wouldn't mind getting up and pointing to the screen again, I apologize. And could you please identify, if you could, to your knowledge and recollection, what markings those are?
Yes, that is Exhibit 61 is on the front door, and 62 is on the rear door.
And with respect to those exhibits, did you swab them?
Yes, they were field tested, swabbed, and collected in the same manner as the other stains in the garage.
And was that 2 swabs?
2 swabs for the evidentiary collection.
And KM, the result?
KM was positive.
So blood was on the Range Rover that was parked in the garage.
There's another blood-like stain found on the Range Rover. As far as location, I would have to refer to my report.
If you could, sir, please. And do you know the location of that photograph, or what's depicted in that photograph?
Yes, that was a blood-like stain we found on the left side of the hood.
Okay. Was that swabbed?
Yes, it was field tested, swabbed and collected.
And the results of the field test?
Field test was positive.
Sir, picture 4 out of file 15, I believe. What does that picture depict, sir?
So that's the Exhibit 61 I spoke about before on the front door of the, left front door of the Range Rover. And you can see the apparent spatter pattern that the stain was collected out of.
And same questions with respect to the seizing of it as an exhibit, please.
Yeah, so that was field tested. It was field tested positive, and then it was collected in the usual manner.
And that's 2 swabbings?
2 swabbings, correct.
Thank you. Picture 5?
That's a blood-like stain found on the left rear door of the Range Rover. And that was field tested. It was KM positive, and then it was collected with 2 swabs, similar to all the others.
Hey, when you say rear door, which side of the vehicle?
That was driver's side, left side.
Picture 6?
Picture 6 is the left front corner of the bumper of the Range Rover. State Police Exhibit 60 was a swabbing, or 2 swabbings, collected from that stain that the arrow was pointing to. And Exhibit 69 is a sample of the blood-like stain that was found below it. Both items were field tested. They field tested positive, and both were collected in the usual manner, 2 swabs.
Picture 7?
That is a photo of State Police Exhibit 63, the location of which escapes me, ma'am.
If you could refer to your exhibit report, please. Which for the record is dated 11 Friday.
Okay, that stain is on the left rear fender of the Range Rover. It was also field tested positive with the KM test and was collected with 2 swabs in the usual manner.
Picture 8?
So 8 is a latent print taken from the Range Rover. Latent print number 9, Exhibit 93. If I could double check the location.
If you could refer to your report, please.
And latent print number 9 was lifted from the front fender.
And just with respect to the latent print number 9, can you just walk us through the process of taking the print off of the vehicle?
So this print, again, once it was developed and marked, photographed, we would take adhesive acetate, something clear. Probably in this case, I used a gelatin lifter. Again, it's a thin layer of gelatin on top of a rubber backing. It kind of molds better to the curves of the car.
Picture 9?
That is a photo of Exhibit 58, which was a sampling of the blood-like stains found on the grill.
And if you could just head up to the screen, I have a few questions with this. Now, with respect to Exhibit 58, what did you designate 58 as?
It was these blood-like stains here.
And did you do any testing or anything on those stains?
I field tested these with the KM test, which was a positive test.
Okay. Actually, if you could, what about up here, one above? I'll start with the one above the V.
I believe those scales were placed there to document the apparent spatter found up here, probably placed there by the photographers.
Did you take any samples or swabbings, I should say, for anything above the rover, the words rover?
No, those are not marked as an exhibit.
Okay. Above the, I guess, the measurement marking or the label, the Exhibit 58, was that the area that was swabbed? Or that you're designated as Exhibit 58, or is it, my other question is it above the grill? Is it separated it, or did you include that as the entire, any of the blood spatter?
I'm sorry, can I refer to my exhibit report?
If you can.
Okay, I was mistaken. This wasn't a blood swab. We were treating this apparent impression or print and blood-like material that we found on the grill We photographed this in the usual manner, in a manner similar to the way we did the prints on the floor. So these were photographed, and then later the photographs were designated as Exhibit 58.
So just to be clear, there was not swabbed in this?
I did not swab this.
Okay, and it was not tested, or it was tested?
I believe...
Objection.
I'm just asking to clarify, Your Honor.
The question is, was this swabbed or was it not swabbed? And the response was going to be, I believe. You know, there can be a follow-up question. Court will overrule the objection.
I can't say for sure.
And with respect to any testing on it, do you recall if there was any testing on Exhibit 58?
Nothing beyond photography.
Moving on to photograph 11. What does this depict?
That is more blood-like stains on the grill of the Range Rover.
And picture 12.
That is another photo of the blood-like stains on the left rear door of the Range Rover.
And what about this marking from, I guess, in the middle
And
of
so, along the side of the car, you can see in this road grime here, salt, dirt, sand, you can kind of see like a swipe mark through there.
Picture 13.
Photo of some blood-like stains on this is the left front wheel of the Range Rover.
Now, with respect to the Range Rover, was there also a additional processing?
Yes, we processed this in our usual manner of processing the vehicle.
And I'm going to show you what's been marked.
Before we proceed, Attorney Manning, it may be more advantageous for the record if there was a better description of wheel.
Oh.
Is it tire? Is it rim?
That's true. Thank you, Your Honor. Sir, if you could just describe what you see in the photograph, please. This is States 13.
Sure. When I refer to the wheel, it's really the rim, not the rubber tire. So I'm looking at these, I'm referring to these blood-like stains inside the metal of the rim.
And for the record, you're pointing to where on the photograph?
Basically in the approximate center of the photo.
And picture 14, sir, do you recognize that?
Yes.
What is that?
That's the Range Rover. We examined this along with the Chevy Suburban at Troop Team Bridgeport on June the 26th, 2019, for similar material, additional biological material from the Undercarriage.
Picture 15, what does that picture depict?
This is an overall view of the Undercarriage, seen while the vehicle was up on the lift. So you can see on this L-shaped scale here, the photographer added a directional arrow for front, so the front would be the top of the screen, and then driver's side, or left side of the vehicle, is toward the right side of the screen.
Picture 16.
This is 1.5.
This was seized from the lower area of the Range Rover as item D. Again, this was scraped into a paper fold, designated as item D, and later the area was swabbed.
And item E. I'm sorry, picture 17. With respect to item E on picture 17.
Yes, this is on the left side of the Range Rover. Again, kind of around the rocker panel. So item E is designated by the arrow. This material was scraped into a paper fold, and later the area was swabbed.
And picture 18, please.
Again, just another photo of item E.
They think that she had part of the conspiracy. She was part of
I want to go back and ask you a few more questions about that
planning.
October processing of the Chevy Suburban. Do you recall how many exhibits you took, if any, out of the car that day?
Not off the top of my head, ma'am.
If I can. Would it refresh your recollection and take a look at your report?
Yes.
I may approach the report, Your Honor?
Yes.
So I'm going to show you what's been marked as 13 for ID. Please take a minute and take a look at it. Please don't read it out loud.
All of the spatter that's in there, they're thinking from when he attacked her in the garage.
Okay. Did that refresh your recollection, sir?
Yes.
Okay.
He
With
hit her
respect
with
to that
something.
processing, how many swabs were taken out of the car that day?
There were 6 exhibits containing anywhere between 2 and 4 swabs.
And what were some of the, for instance, do you recall exhibit 370?
Yes.
What was that swabbing of?
That was a swabbing of the steering wheel, and that was complete with 4 swabs.
And are you utilizing a report to refresh your recollection on this?
Yes.
Okay. Exhibit 371?
371, again, 4 swabbings from the steering wheel. These were from the areas with visible blood stains. The item before that, 370, was taken from unstained areas, or apparent unstained areas.
Attorney Manning, the court heard that there was a third processing in September 2019, and counsel made reference to a processing in October.
If I may inquire of Detective Riley, Your Honor, is there another processing in September?
No. The processing where we took the extra swabs was actually, the proper date was October 18th.
Thank you.
I apologize.
And with respect to how about Exhibit 372?
372 was 4 swabs taken from the interior side of the left front door.
Do you recall where that was on the door?
It was, I ran the swabs around all areas of the door in an effort to pick up as much genetic material as I could.
And Exhibit 373?
That was taken from the left front seat adjustments. This was 2 swabs.
And by front seat adjustments, just what do you mean by that?
So they're the side buttons on the driver's seat used to adjust the seat for the driver.
And 374?
374 was swabs taken from the rearview mirror.
And 375?
And 375 was swabs taken from the rear seat controls in the cargo area.
If I may have one moment, Your Honor?
Yes.
I have nothing further, thank you.
The cross-examination is going to show.
Oh, Lord. Here we go.
Good afternoon, Mr. Riley. You're retired, right?
Yes,
I hope you're enjoying your retirement.
I am. Thank you.
Let me ask you a few questions. Let's start with this presumptive testing that we talked a lot about here. It's my understanding, as you testified, that when we're talking about these chemical presumptive tests, there are at least 2 that you talked about today, right?
Yes.
The first was called Castle-Meyer, begins with a K instead of a C, right? It's like hyphenated 2 names.
Yes.
And the second one was something called Luminol, right?
Yes.
And Castle-Meyer, you said, is made up of 2 chemicals. One is phenolphthalein, right?
Yes.
And the other is hydrogen peroxide, right?
Yes.
Now, phenolphthalein is the stuff that they use to test swimming pools for chlorine, right? Isn't that the same stuff?
I don't know, sir.
So you're not an expert in science, you're not a chemist or anything like that, right?
No.
So when you said you had some training in it, you were trained in how to administer it, right?
Yes.
You don't know anything about the chemistry itself and why something shows pain or glows or changes color at all, right?
Correct.
And the training, you said you also received from the lab some kind of like a kit in order to administer it, right?
Yes.
And phenolphthalein is a liquid, isn't it?
Yes.
And so is hydrogen peroxide, correct?
Yes.
Now, hydrogen peroxide, that's the same chemical that you use maybe if you have an infection, maybe to disinfect, right?
Yes.
And I guess some people might even use it to bleach their hair, right? In the day, right? Isn't there people have peroxide hair where they really white bleach blonde? Is that the same stuff?
I'm not sure, sir.
Okay. But in any event, you also said that there are things, when you talk about presumptions, right? You're trying to see if there's a place that you're going to do some swabbing or photography, right?
For the Castle-Meyer,
Yeah.
it's more, we do our searches visually.
Okay, so you see something that looks like a stain, right? You maybe do a little chemical wipe with the KM, right?
Or conduct a KM test, correct.
You do a KM test, and if it comes back negative, do you still take a picture of it?
Sometimes.
So we saw a couple of those. You tested a stain on the floor of the garage, and it didn't even come up with a presumptive test, right?
Right.
But in any event, if it comes up presumptive, one of the things you indicated that it's presumptive for is blood, right?
Well, the test, it's presumptive for blood.
That's what I mean. The test is presumptive for blood by putting the 2 chemicals together with the sample, right?
Yes.
And you did mention a couple of things that it also is presumptive for, right?
Yes.
Animal blood is one.
Yes.
And of course, there's all sorts of animals, right?
Yes.
Doesn't distinguish between one animal or another, does it?
No.
I think you also mentioned horseradish is something that it tests positive for.
That's one of the classical examples.
Okay. Now, you're familiar with some of the other things that it tests positive for?
I'm familiar with turmeric.
Turmeric, right? Now, does it also test positive for tomato?
I don't know.
What about rust, iron rust?
I don't know.
You don't know?
No.
How about bleach? Do you know about that?
No.
How about copper?
No.
You don't know. Is that what you're saying? Whether it'll show presumptive positive for copper? Like iodized copper?
I don't think so, sir.
How about malt, like you find in either beer or a milkshake?
That I don't know either.
Aren't there, in fact, 16 different food groups that test positive using Castle-Meyer?
I don't know, sir.
Like
You
radishes.
have to have somebody who's like a scientist that knows this to really answer those questions, right?
Yes.
But if we're talking about a presumptive test, if you wanted to be presumptive about the presence of horseradish, this would be the test to use, right?
Horseradish.
I would need to presume something was horseradish, sir.
Well, the presumptive test is not what you think, it's whether it turns pink, right?
Oh, gosh.
Yeah, I'm not sure I'm following your question, sir. I mean, it does react in a positive manner with horseradish.
So I'm saying if I wanted to presume that a stain on my kitchen cabinet was horseradish, I might use this test, right?
If you really wanted to.
Exactly. And so let's say I don't know, spilled piece of hamburger juice. That would test positive, right?
I don't know. I've never tried it on hamburger, sir.
Well, hamburger is basically animal meat, right?
Yeah, but I've never tried it on hamburgers.
Fair enough. But it would also test positive for a cat, little blood of a cat, right?
Oh, yes, animals? Absolutely.
Mice, right? There's a garage, right?
If you had an injured mouse, yes.
But you would also agree, would you not, that you would need a confirmatory test done by a lab to see whether the presumption or assumption turned out to be correct, right?
Yes.
And you know that in your, never mind this case, but in your experience, some of the things that you show a positive presumptive test turn out not to be blood at all, correct?
I've never had that experience.
Well, you don't do the actual testing, do you?
No, I mean, when I learn of the results, I've never had that experience.
So you don't know that in this case, that was in fact, several of these items turned out not to have any evidence of blood in it?
Objection, Your Honor.
Sustained.
You didn't even test all of the spots that we just saw pictures of, did you?
Me personally? No, I didn't.
Let me ask you a few questions about Luminol. We saw some pictures in the back of the Suburban, right? Including a couple in the dark where you see this little purple glow, right?
Blue glow, correct, sir.
Blue, purple. Those were kind of like, those photographs were taken with a time-lapse photography, right?
Yes.
So they appeared brighter than they might with the naked eye, correct?
I can't say for sure, sir.
And you use that in order just to choose where you might take another spot, right?
Yes.
Now, you said that luminol tests for the presence of iron, right?
Yes.
So you know that a car is made out of steel, or most of them are, right?
Yes, it is.
And steel is an iron alloy, is it not?
It is.
So it would stand to reason that in a motor vehicle, there might be some exposed metal places that might test positive using luminol, right?
Correct.
So if you wanted to see if your car was rusty, you might just spray some luminol on it, and you would have a positive glowing result, right?
It would even glow on the non-rusted parts.
Right, but it would glow on even the non-rusted parts because you're in a car, right?
Yes.
And if you're talking about, let's say, a car where there are children that have been passengers in that car, there might be all sorts of other things that will test positive for the presence of iron. Isn't that true?
Possibly, yes.
You know that I think turnips also test positive for luminol, don't they?
I don't know that for a
You know, a lot of root vegetables have iron in them, right?
No.
You do know that.
I do
right?
know.
And it's actually good for you to eat, right? Am I right?
No, object, Your Honor.
Well, the question's not relevant, sustained.
If you wanted to see if you maybe dropped a turnip on the ground in the back seat of the car, you might use luminol and it might glow, right?
Objection.
Ground.
Irrelevance and assumes facts not in evidence.
Well, the line of the cross-examination is a number of substances or fruits or vegetables contain iron. This is just an extension of that line overruled.
All right.
I think you'd be able to see a turnip and would need luminol.
But the luminol might illuminate it, right?
I don't know. I've never tried it on a turnip, sir.
Fair enough. Bleach also will glow in luminol, wouldn't it?
Yes.
You already mentioned horseradish for K&M. This would also test positive in luminol, wouldn't it?
I don't know for sure.
Okay, never in my life did I think I would hear a detective on the stand saying, I don't know, sir, I've never used luminol on a turnip, sir.
Rust.
Yes.
So if a child had, let's say, ice skates in the back of the car, some of that maybe scratched off on the back seat.
Objection.
That would test positive for luminol, wouldn't it?
Well, here's an objection. And it calls for a hypothetical, but the hypothetical isn't developed in such a way as to aid the jury. Essentially what the question is since there are ice skates have metal, probably steel. Steel is an alloy of iron. In other words, it's an extension, but the extension is becoming very thin. So the court is going to allow the question.
And I will then move on, but if you want to just answer that question, I'm not going to go into a million hypotheticals.
Yes, it's possible.
All right.
He said I'm not going to go into a million
A lot of these
hypotheticals.
photographs that we've seen were various angles of the very same spots that you tested, isn't that right?
Yes.
So just by looking at these photographs, you have to look very carefully to see whether or not 3, 4, or maybe even 5 photographs were of the same location that you did a swab, isn't that right?
No, I just swabbed from the areas that were marked as exhibits.
Oh, no, I understand that. I'm talking about photographs of different angles to a certain extent of the same areas that you had swabbed.
Yes.
I also want to be clear about the measuring tapes that are in many of these pictures. The white tape is in centimeters and millimeters, correct?
And I believe it's inches on one side, too.
Well, the yellow, isn't the yellow the inches?
You said the white tape, sir?
Yeah, doesn't the white tape say metric on some of them in those pictures?
I don't know, I would have to look at the pictures.
All right, fair enough. But if you're familiar with the fact that there's a distinction between the metric system, which uses centimeters and millimeters, and the American measuring system that uses inches and feet, right?
Yes.
I guess the ice skates, I mean, she signed up one of the kids for hockey.
I want to ask you a few questions about the paper towels in the kitchen. And the first thing I want to do is call up one of the pictures that was on the exhibit that was introduced through you. And if I could have 8-139. For your edification, this is the image where you put the state police exhibit number 13 on. If you would look at that screen behind you, sir. You see that image there?
Yes.
And I think you testified that this was the paper towel that you examined. You did some kind of a test on it as well, right?
Yes.
And you seized the whole thing or just a portion of it?
The whole thing, sir.
When you came into the house that day, this would be the 25th, correct?
Yes.
Was this exactly when you went in the location where you found this paper towel?
Not the exact location, no.
It was moved around?
It was in that general same corner of the sink, sir.
Did you move it so that somebody could take a better picture?
No, I moved it so I could examine it and field test it.
When this picture was taken and you put that yellow tab next to it, is that the location you found it in before you moved it and examined it?
No, I don't believe so, sir. Not the
Where
same
was
as
it when you first observed it, if you can just point it out on this photograph?
I would just remember in that general corner of the sink, sir.
So when you say in the corner of the sink, was it off the roller? That is the metal device that the paper towel roll is standing next to?
I believe so, but I'm not sure, sir.
Did you observe anyone else move it? Take it off?
No.
And just so that we're talking about the same thing, right? I'm referring to this item here that's to the left of the paper towel roll. You see that there?
Yes, sir.
You recall seeing that there, right?
Yes.
But when you got there, that paper towel roll was not on that device, the dispenser roll.
I think they were separate, but I'm not sure.
Well, if you're not sure, do you not recall seeing someone physically remove it?
Objection.
Well, the response was he's not sure if it was on the holder. And the question was, well, if you were not sure, can you recall seeing someone move it off of the holder?
No, I didn't see anybody move it off of the holder, sir.
So it wasn't placed there in order for you specifically to examine it in that location. Is that fair statement?
No, I searched that area of the house, sir.
Okay. So I'm going to ask you now, I had a couple of screenshots taken from, I think it's Exhibit 7. We had Detective Clabby had a video. I just took a couple of screenshots from it, and I'm just going to show you, if I can.
Excuse me, may I have a moment with counsel?
Yes.
Yeah.
What's on the desk?
Take a second.
Poor betta fish. I hope
Can we have
somebody
this
took
marked,
them.
if I may?
Yes.
Yeah, he wants the jury to see this and be like, you know what? We don't know that was blood.
So I'm going to show you, is there any objection to Exhibit A?
It could have been radish.
That's this one or this one?
Yeah, that's
This one.
It could have been ice skates.
No objection, thank you.
What's the marking, please?
Defense Exhibit A.
Defense A admitted as a full exhibit.
So if you could, before we show you the image, before you got there, you know that Detective Clabby was also on scene, is that right?
Well, we were there at the same time, sir.
Fair enough. Did you all arrive in the van or did you come separately?
No, we came separately.
But you recall seeing him there?
Yes.
You knew that he was assigned the videography for that scene that day?
Yes.
Did you observe him doing any videography?
Yes.
Did he do that, at least the overview, before you got to work making any examples, any swaps or anything like that, taking anything?
Yes.
All right, so I'm going to show you a couple of screenshots from that video that Detective Clabby took. And have you seen that video at any point?
Not in a long time, sir.
All right, so I'm going to show you one screenshot called Screenshot. So we just put that up, please. Now, looking at the video screenshot that I've just put up here, you see that the paper towel is on the dispenser in that image, correct?
Correct.
So my question to you, was that how it was when you observed it, or was it already off the roll when you examined it?
Objection. Asked and answered, Your Honor. He indicated he doesn't remember.
The response has been he does not remember.
All right, does that help? All right. Does looking at this image help you refresh your recollection as to whether or not it was on the dispenser when you arrived?
Objection, Your Honor.
Grounds.
Again, he's been asked and answered. It's now a full exhibit.
Well,
I'll withdraw the question. I'm going to show you another screenshot in a moment, but well, it's up there now. This is from the pantry. Do you recall looking in the pantry at the in that kitchen, between the kitchen and the mudroom?
Between the mudroom and the dining room, sir?
Yes.
Yes.
All right, so if you would just put up that image, this is also from the same exhibit. You recall that this was the view of that pantry when you looked at it?
Yes, that's consistent.
Did you take any swabs or collect any evidence from what's shown in that image?
I did not.
Right. Could I have this marked, please? That's these two.
Wait, oh, that's the PDF? Okay.
I would offer defense exhibit B.
No objection.
No, sir.
Defense B admitted as a full exhibit.
I know. Like they talk about food and then they show the pantry and now all of us are hungry.
I'm going to show you an image that was taken from by the officer who arrived at New Canaan from the New Canaan Police Department on the evening of May 24th, 2019. All right, so if we could have that. I don't know if you don't recognize the New Canaan police officer that's seen in this image, do you?
No.
And I'll just note the time is indicated at 5:24:19 at 19:57 and 33. This is from State's Exhibit 1, I believe, which was the video that was from the body camera of one of the patrol officers that was there that night. Okay.
Okay.
So again, I'm just going to ask you to note. Did you ever see the paper towel roll on the dispenser when you were at the house?
I don't remember.
Now, I'm also going to show you two other images. I think they're also from this exhibit. X8, please. It's image 0064 from that exhibit. Do you recall seeing any of the items that are indicated here during your investigation on May 25th, 2019, inside the home?
Specific items?
Any specific items in the pantry that we're seeing here?
No.
I'll show you the next picture, please, which is it's image 0065, but I'm just calling it X21 for my. Does this particular roll, did you observe this roll of paper towel in the pantry at Wells Lane when you were there collecting evidence?
I don't remember that.
Okay. I'm going to show you a couple of pictures from the garage that we've already been through and you described where you took certain swabs. The first picture I want to show you is from your disc exhibit, which I believe the whole exhibit is, I think, 7. I'm sorry, I'll just have a moment.
Which one? 9. No.
The large disc.
9.
No, the one.
Look at Lucy.
That.
Yes. 9.
It is 9. Okay.
9.
Sure. I'm going to show you some images from exhibit 9, if I may. And the first exhibit I want to ask you about is marked on your exhibit 9 is 12-362. If that, we could have that up on the screen, please. You recall this is the exhibit that you marked as A16, or somebody marked as A16, correct?
I don't think that was an exhibit. I think that was just for documentation purposes.
All right. So let me also get that clarification. If there's a yellow placard, then it was seized as some kind of an exhibit for your purposes of your investigation. Is that correct?
Or it was marked on a similar label with EX, whatever.
So the A letter, was that your writing on this document, on this image?
No.
This would be something that whichever detective was placing these markers down would have noted. Is that right?
Yes.
And I asked you this when we were first putting some of these pictures up. If we look at this image here, when you saw this particular marker, did you note the marking on the sticker itself?
No, I didn't note it.
You did not?
No.
Okay. So you don't know how that got there?
Specifically, no.
Okay. I'm going to show you another image. This one is 13-363. It's in the same series. And this is also one of the images that you testified to yesterday, correct?
Yes.
And I'm asking you specifically about the mark on the middle of this document here. Was that present when you were examining that particular spot on the ground?
I don't remember it.
You don't recall seeing that?
No.
And you also testified, if I'm not mistaken, that there was also a fair amount of, you called it vegetative matter, seeds or leaves and whatnot on this garage floor, correct?
Yes.
And did you gather any of those?
No.
Show you one more in this series. This would be 14-157. Once again, I'm just going to ask you whether or not you recognized or saw this item on the placard when you were looking at this particular location on the floor.
I don't recall it being there.
And when you talk about other items, whatnot, seeds and whatnot on the floor, are we talking about, if we look at this picture, are we talking about all of these other specific items, dots and whatnot that we see on the cement floor in a close-up? Is that what you're talking about?
Yes.
There are also some larger leaves, correct?
Larger leaves, stones, sand, things like that.
Sand, what else?
Small stones.
All just on what you might expect to find on a garage floor.
Before you proceed, counsel, the court needs to clarify something that is quite subtle. Detective Riley, on the previous photograph, you indicated you did not remember whether you saw that spot on the measuring marker, correct?
That's what I said, yes, Your
But
Honor.
then you said, I don't recall seeing it. Now, it may sound the same, but there's subtle differences. I don't remember whether I saw it. To this court means I don't remember whether it was there or not. I don't recall seeing it means, in this court view, I don't remember that it was there.
I gotta get food. Hold on, I'll be right back.
Which one is it?
It was the former. I did not take note of it, Your Honor.
Thank you.
With regard to the search of the Chevy, you said that you were sent back to take additional samples in October of 2019. Is that correct?
That's correct.
And as I understand from your testimony, it was from additional samples of the steering wheel,
Yes.
from the interior of the left front door,
Yes.
from the front seat adjustment control,
Yes.
from the rear view mirror,
Yes.
from the cargo area,
Yes.
from the rear seat controls.
Weren't those one and the same, sir?
Well, that was going to be my next question. Were those separate places, or did you take them from the rear seat controls in the cargo area because the seats were down?
Yeah, I believe when I remember the rear seat controls were in the cargo area.
Because the back seat, the second row of seats were not up, they were down. Is that why you entered that way?
I don't remember whether they were up or down, sir.
You were sent back to do additional swabs because the first set didn't produce any information of value. Is that true?
Objection.
Well, the question is, you were sent back to take additional swabs because the first set didn't yield anything of evidentiary value. And what's the objection?
It's a mischaracterization of evidence, assumes facts not in evidence, and
Well,
it calls for a hearsay answer, Your Honor.
well, let's take them one at a time. The question was, you were sent back. That's one segment. Because what you swabbed the first time did not yield anything of evidentiary value. Well, whether you were sent back or not is not material. It's the second segment. Because what you recovered the first time was of no evidentiary value. Well, that assumes, in this court view, facts that can be interpreted differently, but in this court view specifically, it's misleading. Sustained.
The purpose of going back in October was an attempt to get biological material from those locations in the suburban, correct?
Yes.
And whatever you did, you made the same kind of swipe type activity that you described earlier?
Yes.
And then you sent that on to the state lab at some point, right?
I don't know if I did personally, but that's the usual process.
Right. Well, let me just, I skipped a step, all right? So you gathered it, and it was then sent into evidence, right?
Yes.
And then at some point, that was done for the purpose of, at some point, having it examined by the state forensic laboratory, correct?
I believe so. Not sure though, sir.
Well, whether these particular items were then sent down or not, that would have been the purpose of collecting it, right?
Oh, yes, absolutely.
Just have a moment. I have no further questions. Thank you.
Is there redirect?
Just a couple of questions, if I can. Detective Riley, Do you recall Attorney Shohorn asking you about the other items that a presumptive test could test positive for? Do you recall that line of questioning?
Yes.
Okay. I think some of the things he questioned were about radishes. Do you remember that?
Yes.
Okay. In the garage floor, did you find any evidence of radishes anywhere?
No.
Okay. What about cheeseburgers? Anywhere on the floor?
No cheeseburgers.
What about the undercarriage of the Chevy Suburban? Did you find any cheeseburgers or radishes there?
No, ma'am.
Okay. What about the undercarriage of the Land Rover? Any cheeseburgers or radishes there?
No.
What about turmeric? Any bottles of turmeric or turmeric sources on the floor of the garage?
No, ma'am.
The Land Rover?
No.
The Chevy Suburban?
No.
All right. With respect to the cargo area of the Chevy Suburban, did you find any evidence of car seats? Any evidence that children were sitting in the trunk area?
In the back? No, ma'am.
With respect to that cargo area, did you see a lot of exposed steel and rust areas?
No.
With respect to, actually, that's all I have. Thank you.
Just a couple of questions. In any of those areas, starting with the garage, did you find evidence of rust stains?
Not that I remember, sir.
Did you notice that whether or not under the undercarriage of the vehicle there was some rust?
Yes.
No further questions.
Nothing further. Thank you.
Thank you. Detective Riley, you may step down.
Thank you, Your Honor.
She said, did you
Time
find
is
any
now
cheeseburgers
3:10.
under that car?
You have another witness for this afternoon, do you?
We do, Your Honor.
Judge, we do have to take up a couple matters
Correct.
in advance.
So what the court is going to do is allow the jury to take the afternoon recess now.
All right, let's
Well,
skip forward.
How long do you anticipate your argument on the matter that we have to take?
Yes, Judge. Good afternoon. May it please the court. Your Honor, there's actually two matters that we're asking the court take up at this
All right.
time. You'll recall.
I'm gonna
late
go
on
down
Friday-
to 1.25 now. That was the best. That was hilarious. I'm gonna go down to 1.25 now. If it gets to be too fast, then we can slow it down. Because it was at 1.5 while we got through all that stuff. That was like the most that was the best part of the trial right there is that ridiculous line of redirect. Did you find any cheeseburgers under the car? Did you find any radishes under the car? It's what we were all thinking, but it was really great. So now we're about to get into some of the arguments about what the nanny can and cannot testify to. And then the nanny is supposed to take the stand.
Friday, the state inquired about the court hearing the defendant's motion for a Porter hearing with respect to STR Mix, which is a deconvolution software that the state laboratory uses when interpreting DNA results. We did file a written objection on Friday, which I did email to the court, and we're asking that that be heard now or at least at some point today, because we were intending on introducing DNA evidence as early as tomorrow, depending on scheduling, of course. And then there's a motion that deals specifically with the next witness, which was filed by the defense last week, which was specifically to exclude any and all evidence of so-called marital discord between Mr. Fotis Dulos and Miss Jennifer Dulos, along with hearsay. So that is going to be coming up during the next witness, and so I certainly didn't want to run through the stop sign of the motion in limine.
Thank you. So the court will take up first as we would have to call it, what the code calls it, prior bad act.
If I could just have a moment, Your Honor.
Goodness gracious alive. Oops.
Written out. Well, I'll probably be able to do it from memory in any event, Your Honor. So I'll just note, Your Honor, just a couple of things with respect to the so-called prior bad acts. Firstly, this is a defense objection, but we are going to be making the offer. So I just want to alert the court as to what we intend on offering through this next witness. And they've also moved to exclude alleged hearsay statements from Jennifer Dulos as well, and I'd like to take those up at the appropriate time additionally, Your Honor. But essentially, Your Honor, the defense in this case, as I understand it, from some of the cross-examination which we have heard so far, specifically with respect to presumptive blood tests, as I understand the defense, they are not conceding that there was actually blood in the garage. They're not conceding that Jennifer Dulos is deceased, and they're not conceding that Fotis Dulos is responsible for her murder. Now, I could stand mistaken on that, but I don't think that we're going to be hearing those concessions this afternoon from the defense. So I bring this up, Your Honor, because obviously, in light of the fact that none of those things are conceded at this point, the court needs to decide whether or not animus between Fotis Dulos and Jennifer Dulos is relevant to this case. And I did file a written objection this morning, Your Honor. But I would pose to the court this hypothetical as the court considers this motion. I want the court to consider if the defense had moved to exclude any and all mention of the fact that Fotis Dulos and Jennifer Dulos were married. Let's just say they moved to exclude that, and the court granted their motion. The jury would naturally be sitting there wondering why Fotis Dulos would have murdered a random woman in Buchanan. It is the story of their marriage and the story of their discord and the story of their divorce that served as the motivation that culminated in the death and murder of Dulos. That is our theory of the case. And Ms. Lauren Almeida is going to be testifying on behalf of the state in just a moment. And what the evidence is going to reveal, Your Honor, is that she was the nanny for the Dulos family from 2012 until 2019. And she was present for a series of events, including the breakup of Fotis Dulos and Jennifer Dulos in the spring and summertime of 2017. And she's going to be detailing very specific events for the court. Specifically, she's going to be detailing how, upon the decision to separate, Mr. Dulos chased Jennifer Dulos around with a piece of paper. That at one point they were in some type of screaming match, and he chased Jennifer Dulos upstairs and burst into the room. That she looked terrified when he was chasing after her. She's going to testify about the antagonistic behavior he showed towards her during those months leading up to her finally leaving the home. Specifically, Your Honor, that he threatened to take the children to Greece. She's going to talk about an event in which he allowed the 11-year-old children and the 8-year-old children to drive his Porsche around a very dangerous area, thus upsetting Jennifer. That these things were occurring and seemed to be designed to antagonize Jennifer during the months after they had apparently decided to separate, but were still living together. She's going to detail for the court how he reacted when Jennifer surreptitiously left the home with the children in June of 2017. That he acted erratically towards her in court, her being Lauren Almeida, that he accused her of kidnapping her kids because she went with Jennifer with the children to New York. She's going to discuss the fact that Fotis Dulos yelled at her when she dropped the kids off and said that she needed to be the voice of reason with his wife, Jennifer Dulos. All of these things, Your Honor, are probative to Mr. Dulos's animus towards Jennifer Dulos and serve as the motivation for why he would commit this crime. Because the evidence is going to show that despite the fact that it had been nearly 2 years from Jennifer Dulos leaving the home until her alleged murder, that they still weren't divorced, that they were in the midst of ongoing marital discord. And the defendant, Your Honor, actually spoke about that marital discord during her interviews with the police. She indicated that, I don't know the exact phrase, but I believe it was 2 years of hell or 2 years of torture when she was speaking about Mr. Dulos' divorce proceedings with his then wife, Jennifer Dulos. She joked about how she wished Jennifer would just disappear. So this also serves as the motive for why the defendant would conspire with Mr. Dulos to kill Jennifer Dulos. And
that's true.
As the defense has repeatedly said during voir dire, the state has to prove beyond reasonable doubt that Fotis Dulos murdered Jennifer Dulos. They have repeatedly said that. So the fact that Fotis Dulos would have been motivated to harm Jennifer Dulos and all of the discord leading up and explaining that motivation is highly probative to Mr. Dulos' intent, his motivation, whether or not he would have conspired with the defendant, his live-in girlfriend. It also goes directly to an element of the case the state has to prove. And so, you know, if we look at some of the jurisprudence in the state, and I think I directed the court to State versus Lopez, 280 Con 795, just as an example, anytime there has been sort of hostile acts towards the same victim, courts have routinely held that that is probative of the actor's intent and motivation. So, unless the defense is conceding that Mr. Dulos committed this crime, that Jennifer Dulos is deceased, the probative value of this was extremely high before their cross-examinations. It's astronomically high now. And so I am asking that the court allow Ms. Almeida to testify about those events. There was an additional event which I neglected to mention, which was shortly, I don't want to say shortly, but after Jennifer Dulos had left the home, there was an event in which Mr. Dulos almost hit her with the car. And Ms. Almeida returned to the home shortly after, and Jennifer Dulos explained that situation to her. And she was extremely shaken up. And all of these things, Judge, we believe are probative, again, to the animus that he would have harbored towards her. With respect to, if I can just have one moment, Judge?
Yeah.
With respect to the alleged hearsay statements, I would just indicate the following to the court. Number one, the statements that we're going to be offering that Jennifer made to Ms. Almeida are either not being offered for their truth or meet a well-recognized hearsay exception. And I just want to give you some examples. Farber's then existing belief that Dulos was having an affair, in part because he had been more distant. We're not going to be offering that to show that Mr. Dulos was actually more distant in the marriage. We're going to be offering it to show that Jennifer Dulos believed that their marriage was in turmoil and believed he was having an affair. Her then existing belief that she had found proof of the affair. Her future intention to confront Dulos about the affair. Her then existing fear of Dulos. Her then existing emotional state that she was not in love with Dulos anymore. Her then existing fear that the defendant would take her children to Greece and not return, which, by the way, is independently corroborated. Lauren Almeida actually witnessed an event where he threatened to take the children to Greece. Her intention to divorce Dulos. Her then existing hope that the divorce proceedings would go smoothly. Her intention to leave the defendant, including her future plan to surreptitiously leave the house, and her fear that Dulos would find out. Her request that Lauren Almeida continue to work with her after she had left Dulos. And her intention to take the Chevrolet Suburban to a doctor's appointment in New York on May 24th, 2019. All of those things, Your Honor, just by way of example, are then existing state of mind, statements of an intention to do something in the immediate future, and therefore qualify as a state of mind exception under 8.3, subsection 4 of the Connecticut Code of Evidence. So they're not testimonial. There's no suggestion that these statements were made in anticipation of any criminal proceeding. They're made to the nanny, and that's what she's going to be testifying to, Judge. So all of these things, again, meet well-recognized hearsay exceptions. I would direct the court. There's a more recent case, State versus Ayala, but I also directed the court in our memorandum to State versus Nims. Victim statements as to others as to why he was traveling to Connecticut, specifically that he was concerned with how the defendant was handling his sister's affairs. It was not offered for the truth, but rather to explain why the victim went to Connecticut. State versus Smith, victim statements to others. With respect to the statements about the event with the car, Your Honor, we're offering those as spontaneous utterances. And I would just indicate that State versus Smith, which is 275 Con at 217, quote, "It is well established in our jurisprudence that where a marital or romantic relationship existed between a homicide victim and the defendant, evidence of the victim's fear of the defendant suggests a deterioration of that relationship, which is relevant to the issues of motive and intent." Now, what I'm gathering from the defense, even though they're apparently not conceding that Mr. Dulos is even responsible for this crime or that the crime occurred at all, is that there's somehow spillover prejudice to the defendant. But again, this is highly probative evidence as to why Mr. Dulos would commit this crime. We're going to flush out later on in the trial why it was also probative to why the defendant would conspire with Mr. Dulos. And so we're asking that the court allow this evidence. We think it's very probative.
Thank you. Attorney Schoenhorn.
I guess we have to separate the fact, two issues here. The first is that it sounds to me that if Fotis Dulos was on trial for this, the state would be seeking to offer this kind of evidence, and most of it would be explicitly prohibited against Mr. Dulos because of its prejudicial effect and its remoteness. This court, early on, before we started evidence, I attempted to get certain documents from the divorce file because it sounds to me that the state wants to litigate a dissolution action that never reached its conclusion. The court, in the most recent court proceedings involving the Dulos versus Dulos matter, prohibited the defense from having access to those documents. I want to preface my remarks with that because what I'm hearing now is the state wants to litigate matters from 2016 and 2017, years before the disappearance of Jennifer Dulos and the allegations that are set forth in the complaint. So first, there are a number of issues that apply here. The first is that most of what I just heard is not relevant because it has nothing to do with Michelle Troconis. It also would not be relevant as a motive against Fotis Dulos because of the fact that it occurred before the divorce. It's also relevant for your court's determination. There's no violence involved here. Every one of the cases that the state has cited involve prior acts of actual physical violence. What we have here are arguments about whether the children should go water skiing, whether they were loud, whether whether Mr. Dulos wanted his wife to sign a custody agreement, which is what the claim chasing her around, quote unquote, with a piece of paper is all about. To sign an agreement as to when the children would go, in other words, without litigating it, to agree to those terms. This might be true of any dissolution action, not only in Connecticut, but probably in the entire United States of America. So The problem we also have, which is unique to this case, is that all of these incidents were part of an attempt by Jennifer Dulos to obtain a restraining order. I want to emphasize, because the court may not be aware, Judge Collin had a multi-day hearing where all of these claims were litigated, and he found it not credible. That is, he denied the restraining order. So we have, at the level of a preponderance of the evidence, a coordinate judge of this court finding that the evidence did not meet the minimum requirements for a restraining order, and he denied Jennifer Dulos' motion for...
Oh, and look how that turned out.
A restraining order.
And look how that turned out.
Again, it is testimonial in another coordinate proceeding. It was done for purposes of litigation. These allegations were made during the course of that. It was denied in that court. So how is the court here going to allow the same evidence in here without bringing in the actual findings, rulings by the judge in the divorce case? And then, of course, this all goes back to 2016 and 2017. The fact that there was that kind of discord is not the kind of violence that would permit the court to allow that to be presented, especially in a case of this nature. The police were not involved at that point. There's no contemporaneous documentation. Again, this was something that was prepared in affidavits for purposes of court. Ms. Almeida testified in support of the motion for restraining order. I think it's important also to realize that to the extent that there has to be reference to the fact that there was an ongoing dissolution matter, perhaps it's also relevant that Ms. Almeida was part of the plan by Ms. Dulos to simply disappear from the house and leave without notice and to ignore the police inquiry, which is what happened back then. If the court looks at some of the cases, for example, State versus Espinal is a good example of that, where we talk about whether or not claims, and there are a couple of, I have to separate this out, because on the one hand, you've got a couple of incidents where Ms. Almeida witnessed arguments between Fotis Dulos and his wife. There's no physical touching whatsoever. It was following and yelling. That was the nature of it. Then we have a hearsay statement that Jennifer told the babysitter that Fotis drove into the driveway recklessly, apparently telling her that he was allowing the children to drive one of his cars, to drive the Porsche. These were issues that she found to be unreasonable. It may have been part of the reason that she wanted to leave. And yes, there may be evidence that she, quote, found out that Mr. Dulos was having an affair. But again, that is a far cry from suggesting it is relevant to a claimed motive 2.5 years later, at least over 2 years later, to do away with his wife. Particularly, Your Honor, and this is why Your Honor's past ruling plays a role here. Everyone who was involved that was involved with Mr. Dulos, his lawyers, the guardian ad litem, other people that were aware of it, knew that the report by the independent evaluator, the custodial evaluator, the psychologist, had recommended that Mr. Dulos was the better parent, that he was a better, more caring parent than Jennifer, and that therefore he was recommending joint equal custody, noting that Jennifer Dulos was opposed to that, and that Jennifer Dulos was refusing to turn over her psychiatric records so he could evaluate in more detail whether or not she needed some additional counseling and whatnot to help facilitate the transition to joint custody. I submit, Your Honor, that opening up that can of worms is going to permit all of that, including the evidence that Dr. Heuermann testified, which is why I was trying to get those transcripts, which the court denied my right to have them, even though I submit under Davis versus Alaska, now it would be relevant to the issue of right to cross-examine anyone who's going to be testifying about hearsay about the discord and the divorce. Why is that also important? As Your Honor may recall, if any hearsay is allowed in, under our rules, it allows the opposing party to bring in any other hearsay as if the speaker was actually on the stand. And all of that would suddenly become relevant. It could actually delay this trial by having a week of testimony about who was the better parent, who was, quote, winning, unquote, in the divorce proceeding, which I assume that's not what we're here for. In State versus, a couple of cases I just want to bring to Your Honor's attention. In State versus Espinal, for example, there was some evidence about the marriage being discord, but in that case, there was actual violence, and it was relevant because it showed the current state of fear of the spouse when she disappeared. This is something, again, that goes back years, and there is no evidence, none of recent discord. In fact, Your Honor will hear at this trial that there was a party 2 days before at the New Canaan house. I don't know if Your Honor is even aware that this occurred, but there was a party at the house where Mr. Dulos was present, the children were there, the independent evaluator was present as well, and there was a sharing of food between Jennifer and her still husband at that time. So that's going to come in no matter what, that comes in. But to suggest that the babysitter should be allowed to say, well, they were arguing, they were screaming, whether or not he at one point while they were still married threatened to take the children to Greece. That has nothing to do with what's going on at the time, where an evaluator, within 3 to 4 weeks of the disappearance, had concluded in an 80-page report, which I'll note I have, that says that Mr. Dulos would be the better parent for these children, but he was recommending equal sharing of custody in this case.
Oh, that makes me so
There's
mad.
also the case, Your Honor, of State versus Reynolds, where even though the court allowed in a narrow amount of evidence regarding a claim of seeking a restraining order that never was filed, it was only application of itself. So none of the affidavit, none of the specifics of it, and the court was required to give a very, very specific questionnaire instruction that could not be considered for the truth of the matter. But as I hear what Mr. McGinnis is saying, he wants this all to be about a claimed motive that he was yelling at. There was argument going on a few years before, not in the interim. It's not like it was ongoing. 2 years before she filed for divorce. And then everything else went through the court. They were using the court process the way it was intended to. She made claims. They were denied. They were in the process of trying to work out issues such as finances. They were working out the custodial arrangement. Mr. Dulos was seeing his children, albeit at that time there was an order that he had to have an independent supervisor because he had apparently told one of his children, according to the file, and told one of his children to not mention the fact that he had Ms. Troconis moving into the house with her own daughter. And so as a result of that, they had issued an order for a period of time that he could only see his children with an independent evaluator present, which was done, which was documented, which occurred on a regular basis. So I'm not suggesting that the state can't bring up that there was an ongoing divorce. Number one, the only thing that Ms. Almeida knows about it is hearsay. She might have read some documents. She might have talked to the lawyer for Ms. Dulos because she did testify at that hearing. But again, that's an out-of-court statement, testimonial in nature. Therefore, all of that is both not only hearsay, but it's a denial of right to confront and cross-examine because it was testimonial in nature. That is, for purposes of legal process. And it doesn't matter, it's not this case. It was for a divorce case that was in litigation at that point. Let's see if I've covered. There might be one more point I wanted to make.
No, of course there is. That's infuriating for him to talk so negatively about the victim.
I think the state was trying to argue that when Ms. Dulos told the babysitter, Ms. Almeida, certain things, I assume he's trying to argue they were some kind of spontaneous, excited utterances, but even the way he explained it just now suggested that she later told her about it, and so therefore one cannot even claim that it happened under without the opportunity for contemplation, that it happened suddenly, that it was spontaneous in that sense. And I note that the Reynolds case, it was 2 months, 1 to 2 months after the prior incident, so it was still considered relevant. This is years later, and it did not involve any violence.
He was only allowed to have supervised visitation, and even his phone calls had to be monitored.
I should mention this. There was a suggestion in one of the documents, I think by Ms. Almeida, that Jennifer told her that Mr. Dulos at one point had purchased a firearm. Now, when the restraining order was filed, it was turned into the Farmington police, and it was never, to anyone's knowledge, ever recovered. It was never returned to Mr. Dulos at any time. But I assume, since the state didn't mention that, it has no intention of trying to elicit that, because there are several cases, the one that comes to mind is State versus Gerolamo from the mid-'80s, I think, that said that any mention of a firearm, when there's no evidence of firearms in the case, is one of the most prejudicial things that could happen in front of a jury. And I note that, especially in this day and age, where there's all these mass shootings and all these, on almost a daily basis, that would be so prejudicial for them to be blurted out that there'd be no way, short of a mistrial, that could be remediated at that point. Finally, there's no such thing as transferred motive. So even if this arguably, to a minimal extent, and with a very truncated offer of proof, was admissible against Mr. Dulos, there's transferred intent is if I throw a rock and I'm trying to hit victim A and it misses and hits victim B, there's a transferred intent in the actor to the second victim. It's not reciprocal, however, and it doesn't go to another person who's standing to the side. It's just not relevant, and it certainly can't be used because it would even predate the allegation of a conspiracy or anything of that nature, and therefore there's no way to attribute that knowledge and those specific incidents to Ms. Troconis under any circumstances anyway. The fact that the divorce kept going is one thing. The fact that she said in her statement to the police that it was like, I think the term is 2 years of hell, doesn't mean that the specific acts of misconduct, of alleged acts against Mr. Dulos then can be applied to Ms. Troconis.
Sit down, sir.
I'll just mention very briefly, there's been some suggestion that it goes to state of mind. Whatever the state of mind is of Jennifer Dulos is not covered in this case under either 8-3 subsection 2 or 8-3 subsection 4. Telling her that I'm going to be taking a certain vehicle to New York, for example, although not particularly prejudicial, is, I'm only raising it because that's not the kind of state of mind that would be relevant to the examination. The fact that she was going to New York might be and then didn't show up. That is relevant, but to suggest that one person said, I'm going to be taking one vehicle and you have a choice of two is not the kind of evidence that goes to the state of mind. It's just not relevant or material in this case. Let me just see if I've make sure I covered everything. There's one last point. What I see is happening here is the state's whole theory so far seems to be that they're going to tar Ms. Troconis with what happened that may or may not have involved Mr. Dulos directly. If he was on trial, maybe some of this with a cautionary instruction might be admissible, but it's not only so remote as to Mr. Dulos. When you try and drag my client into this, we've now gone so far off the playing field, we're out of the stadium, we're not even in the parking lot, we're down the street by the highway exit. And that is what we seem to be doing here. None of this evidence applies to Ms. Troconis. And therefore, it is so highly prejudicial. The state has been allowed a lot of leeway. I would suggest more than I believe. I'm not shy about objecting, which the court probably has noticed. But in any event, that I believe has already gone so far down, given the state leeway to put on evidence that will later not be connected. And so for them to be able to put on such evidence, leave that speculation out there only later on to show it has nothing to do with Ms. Troconis. And some of it, in fact, has nothing to do with Mr. Dulos either, but I'm not objecting on that basis. But here we have a witness who can testify to certain things that occurred on that week. We're not objecting to any of the stuff that happened during the month of May of 2019, including the fact there were some court proceedings going on. But what happened at them, what the rulings were, what motions were being filed, any of that is both testimonial and therefore it violates the Confrontation Clause of the state and federal constitutions as well as inadmissible hearsay. Based on that, Your Honor, I didn't hear the state separating out its claim. He just made all these things as if he's going to get into all of them. Some of them I might not object to. But since he didn't say 1, 2, 3, or 4, he just said this is all what we're going to bring in. I'm not going to suggest which ones he might be able to get into that we would object to.
Attorney McGinnis.
Yes, Judge. And I'm mindful of the fact that we have a jury waiting. I did just want to respond to a few things. Firstly, I'm not going to get into who has a better theory of the case at this point, because as near as I can tell, the defense's theory is that Jennifer Dulos, shortly before disappearing, ran over a squirrel in her garage that was eating a cheeseburger. Okay, so the issue. I'm going to get to such pejorative, sarcastic remarks.
Well, before we proceed, there's no jury in the court. The court can understand the cut and thrust of argument. The Court is not going to rule on an objection that is not evidentiary. Court can understand that against some comments, counsel, either for the defense or for the state, may take offense. But unless those comments become unprofessional,
She ran over a squirrel who ate a cheeseburger.
both parties to ride the wave of zeal.
So Judge, just responding to some of the specific things with respect to this issue of remoteness, we're talking about an ongoing discord over the course of 2 years leading up to Jennifer Dulos' death, and even by the defense's own argument at this point, shortly, apparently, before Jennifer Dulos disappeared and we believe was murdered, there was some report which she was opposed to, thus indicating further animus and discord between the parties. I would also just note, Your Honor, that in terms of the balancing that the court has to do, I think the defense...
Hold on. Those of you who missed it, he said he's making fun of like how in depth he went into, like, it could have been a cheeseburger, it could have been a squirrel, it could, whatever. So he said that, aside the fact that Jennifer, ran over a squirrel eating a cheeseburger in her driveway. Hold on. Where?
In any event,
No.
But unless those comments become
such pejorative, sarcastic remarks.
Things. Firstly, I'm not going to get into shortly before disappearing, ran over a squirrel in her garage that was eating a cheeseburger. Okay.
Shortly before disappearing, she ran over a squirrel that was eating a cheeseburger. Hold on, one more time.
Who has a better theory of the case at this point? Because as near as I can tell, the defense's theory is that Jennifer Dulos, shortly before disappearing, ran over a squirrel in her garage that was eating a cheeseburger. Okay. So the issue.
I'm going to object to such pejorative, sarcastic remarks.
Well, before we proceed, there's no jury in the court. The court can understand the cut and thrust on either for.
I needed that.
The court is going to allow both parties to ride the wave of zeal.
That's amazing.
So, Judge, just responding to some of the specific things with respect to this issue of remoteness, we're talking about an ongoing discord over the course of 2 years leading up to Jennifer Dulos' death, and even by the defense's own argument at this point, shortly, apparently, before Jennifer Dulos disappeared and we believe was murdered, there was some report which she was opposed to, thus indicating further animus and discord between the parties. I would also just note, Your Honor, that in terms of the balancing that the court has to do, I think the defense sort of made our argument for us, which was that none of these acts involve a particularly violent act on behalf of Mr. Dulos. So in terms of whether or not this is going to somehow inflame the passions of the jury, I don't think that the court needs to worry about that because the acts themselves are substantially less probative than the allegation that he murdered Ms. Dulos. I did not mention a gun. I did not mention a restraining order in my argument. I tried to keep my offer of proof to what I intend on showing through this witness, and we spent an inordinate amount of time talking about things that weren't part of our offer of proof. I'll also just indicate, Your Honor, that when the defense said that if hearsay is admitted, any other hearsay from that person can be admissible. I'm not familiar with a case that stands for that proposition. I'm obviously familiar with the rule of completeness, but any other hearsay, I'd love to see that case. So I don't think the court has to worry about there somehow being an undue consumption of time. And just because the defense attorney says that something's testimonial doesn't make it so. They have not cited a single case that any of the statements, which they've been on notice of, that Lauren Almeida is going to testify to, that Ms. Barbara Dulos made to her, are somehow testimonial in nature. So I would ask the court allow us to have the witness testify to the specific acts that we've talked about. And
Holly Berry.
Just ask the court to deny their objection.
Thank you. Well, the court is going to scan a few items using a grocery store analogy.
Look, Holly Berry found the culprit.
First, counsel spent in almost every case of every juror about at least 1 hour to determine which jurors would be appropriate jurors for this case. One of the salient questions to the jury concerned the ability to pay attention, and that was with regard to the anticipated number of hours of video evidence. Well, the court is going to credit the jury with being able to pay attention beyond many hours of video evidence. So the fact that some evidence may hang for a while before being picked up is not a reason for this court to believe that this jury cannot tie up evidence when it is time for them to deliberate.
Oh, gosh.
Secondly, there is a discussion between testimonial and non-testimonial hearsay. So the court has to hearken to Crawford v. Washington. If the testimony is if the evidence is non-testimonial, then the rules of evidence would apply. If the evidence is testimonial, then that evidence cannot run afoul of the defense's right under the Sixth Amendment. But we leave that discussion there. It was stated by the defense that this court would have to relitigate the family matter, the dissolution matter. This court in no way litigates the dissolution matter. The dissolution matter involves testimony and rulings concerning alimony, pendente lite, and post-judgment, child support, pendente lite, custody, pendente lite, and after dissolution, visitation, health insurance costs, educational costs, exclusive use and possession of the marital home, pendente lite, and post-judgment. This court is not litigating the family matter. So that premise is without merit. Under our rules, prior bad acts may not be admissible to prove bad character, criminal tendencies, or proclivity. However, prior bad acts may be admitted for other purposes such as motive, malice, intent, identity, knowledge, absence of mistake or accident, a system of criminal activity, common scheme or plan, evidence that will help corroborate crucial prosecution testimony, or to prove an element of the offense. Nevertheless, if prior bad acts are admitted, the probative value has to outweigh the danger of unfair prejudice. So the court cannot remember the court will refer to it as the grocery list of statements from the next witness. However, the court cannot at this point determine where those groceries will go until it hears more from the witness. In this case, as the court has stated before in discussions with counsel, the hearsay exception of state of mind cannot consume every thought that the declarant had and make it available to the jury. Because then that exception becomes the rule. In this court's view, the then existing mental or emotional condition of the declarant has to be focused. In other words, it's not just a matter of what the declarant said under a certain set of circumstances. The exception goes to the mental or emotional state. For example, fear or anxiety or terror. So simply everything that Jennifer Dulos may have said to the housekeeper from what the court heard from the state would not fall into that category. But the court would have to hear the testimony. So concerning the issue of prior bad acts and what may be admissible, the court at this point understands that the testimony can go to malice and motive.
He's talking really slow.
Everything that is said does not go to malice and motive as expressed from what the court understood the state plans to elicit. So the court will be keen to entertain the objections if it appears, even if it does not appear, that simply everything Jennifer Dulos said to her housekeeper is coming into evidence. That is not the court's understanding of the state of mind exception to the hearsay rule. So the court is going to allow testimony of marital discord. However, the fact that there is marital discord, in this court's view, is not exceedingly probative. It's whether or not the statements by Jennifer Fotis Dulos go to motive to murder, her fear, her anxiety, her terror. Not simply whether she did not like something that Fotis Dulos was doing. So the court is going to allow testimony of marital discord, but the court will be keen to essentially use a colander to determine what is relevant and what is not. Do we need to take, the Porter factors in the discussion of Porter is going to take up too much time right now. The jury is out. However, the state's witness is probably not going to be done today. We still have a half hour. So what the court would prefer to do is take up the next witness tomorrow morning, take up the Porter arguments.
That's fine with the state judge. I'll just note that what we're probably going to do then is not ask the representative from the laboratory to come tomorrow. Depending on the court's ruling, we'd ask that she come on Thursday.
Well, the lineup for tomorrow is probably going to be Ms. Almeida, correct?
Correct.
And after Ms. Almeida?
We have Detective Tom Patton. But I don't anticipate his testimony is going to be terribly long. But Ms. Almeida may take a substantial portion of the day.
Thank you. So we'll start now with Ms. Almeida.
A quick question, Your Honor. If the court is going to allow some of the marital discord testimony, will the court give a cautionary instruction to the jury about the limited nature of that testimony, and specifically in light of the fact that it's only, well, it's relevant to maybe the allegation involving Mr. Dulos, but is even one step further removed from Mr. Troconis in that regard?
Well, the court will consider limiting instructions after both the state and the defense have had the opportunity to cross-examine and examine Almeida.
Your Honor, I'll wait for the jury, then I'll call Ms.
All right, finally, we got about half an hour left, which for us will go faster because I've got it sped up to 1.25.
Actually,
I had it at 1.5. Let me go back to 1.25 for the last half hour, which will be a little bit less than half hour. All right, so here we go. We finally got the nanny. Finally, we're getting some testimony. You know, I'm really glad that we speed trialed today because this would have been...
Please raise your right hand. Do you solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
Yes.
Please state your name and spell it for the record.
Lauren Almeida, Lauren Almeida.
I can't pin.
And your business address?
Well, there's no need for a business address. You may be seated. Thank you.
Business address.
Good afternoon, Ms. Almeida.
Good afternoon.
Ms. Almeida, how old are you?
32.
And where did you grow up?
Newington, Connecticut.
Who do you currently live with?
I live with the Dulos kids.
Aw.
And did you graduate high school?
I did.
Which high school did you attend?
Newington High School.
Could you just keep your voice up just a little bit?
Newington High School.
And did you also attend college?
Yes.
Where did you go to school?
University of Connecticut.
And what did you study at the University of Connecticut?
Psychology.
Did you graduate?
Yay. Yes.
What year did you graduate?
2013.
And you mentioned that you currently live with the Dulos children.
Mm-hmm.
Did you know someone by the name of Jennifer Dulos?
Yes.
When was the last time you saw or spoke to Jennifer Dulos?
May 24, 2019.
And did you know someone by the name of Fotis Dulos?
Yes.
How did you know Jennifer and Fotis Dulos?
I nannied for them starting in September of 2012.
Were Jennifer and
really
Fotis
pretty.
Dulos married?
Yes.
When you met them in September of 2012, where were they living?
4 Jefferson Crossing in Farmington.
Where was Mr. Dulos originally from?
Greece.
Did he speak English?
Yeah.
Did he speak with an accent?
Yeah.
Where was Jennifer Dulos originally from?
New York.
And you mentioned the Dulos children. How many children did the Dulos family have?
5.
And what are the children's names?
You have Petros, Theodore, Christian, Constantine, and Noel.
And could you give the jury their age ranges currently?
Yep. Currently, Petros and Theodore are 17, Christian and Constantine are 15, and Noelle's 13.
And you mentioned that Petros and Theodore are 17, and Constantine and Christian are 15. Are they twins?
Yeah.
So the Dulos has had 2 sets of twins?
Yeah, 2 sets.
And when you met them in September of 2012, what was their respective age range?
Noelle just turned 1, I believe. Christian and Constantine were 4, just turned 4, and Petros and Theodore were 6.
How did you get introduced to the Dulos family in 2012?
I worked at a daycare center for a few years, and someone that I used to also babysit outside of the daycare told me that she knew someone that needed help.
Well, the question is, how did you end up working for the Dulos family? Well, this is preliminary, the overrule.
You had mentioned that you worked at a daycare center. Would you just continue your answer?
Yeah, so someone that worked for Jennifer and Fotis said that she knew of a family that needed extra help, and I babysat outside of the daycare, so she introduced myself and my sister.
And was your sister also a babysitter?
Yeah.
What's your sister's name?
Ashley.
When did you first actually begin babysitting for the Dulos family?
It was September of 2012. I don't know the exact date.
How often would you babysit them beginning in September 2012?
It started off just like a Saturday or a Sunday. Like I would usually work Saturday, my sister would usually work Sunday, or we would swap. And then over time, I started to work more and more for them.
Were you and your sister the only babysitters for the Dulos family?
No.
You mentioned that you would work a Saturday or Sunday. What were your typical hours at that point?
It varied, but usually like early morning, like 6 a.m. sometimes, because Noelle would wake up early, and I wouldn't leave until like sometimes 9 or 10.
Were you still attending school when you first began babysitting for the Dulos family?
Yeah, I was in my final year.
What types of activities would you do with the children while you were babysitting with them?
We did a lot of puzzles, magnet tiles, and games. Board games was a lot. They like to play pretend and dress up. They also water skied, so we would spend a lot of time doing that.
And would you actually go water ski with them?
Yeah.
Yeah, the jury's finally in there now.
What did Mr. Dulos do for work when you first met the family?
He owned his construction business.
What was the name of the company?
4 Group.
And you mentioned that it was a construction company. What type of construction?
He was building luxury homes.
Where was the office for 4 Group located?
It was in Fort Jefferson Crossing. It's in their home.
Whereabouts in their home?
It was like right above the garage. They had a 2-bay garage, and above that was a space for the office.
What did Jennifer do for work when you met the family?
I knew she was a writer, but I didn't really know much more than that.
Were Mr. Fotis Dulos and Jennifer Dulos ever home while you babysat?
Yeah.
How often would you say they were home when you were babysitting?
Most of the time.
How would you describe the dynamic of the Dulos marriage when you met them in 2012?
I mean, I tried not to judge, but he was gone a lot, but I just figured that was just kind of what it was in their house. But overall, when I first started working for them, they seemed to get along just fine.
And how did they act towards one another?
In the beginning? In the beginning, they were nice towards each other. I mean, from what I saw, at least in the beginning.
I'm sorry, I missed that?
From what I saw, at least in the beginning.
And did you continue to babysit for the family for the remainder of your final year of college?
Yeah.
And for that final year of college, were you just working weekends?
Yeah, because I was going to school during the week.
I want to direct your attention now to May of 2013. Did your role with the family change at that point?
Yeah, so May 2013, I graduated college, and I didn't really have a job in place yet, and Jennifer offered me a full-time position with the kids.
And what days of the week were you, well, I guess I should ask a preliminary question, which is, did you accept the job?
Yes.
And at that point, did you become the sole babysitter or nanny for the children?
I guess I became like the main one, but there were still some people that would come in, or sometimes there would be 2 of us, mostly on the weekends, because the kids were in school, or they were like at least in preschool, so it's easier with just with one. But.
And what days of the week were you working for the family at this point, now that you're full-time employed?
I think it was like Monday through Saturday, so I always worked a weekend day, but it was like half a day, so I wouldn't go in until like maybe like 11 or 12.
And when you say half a day, you're referring to the weekend day?
No, the weekend day was like a full day, from morning to night. So during the week while the kids were in school, I didn't have to show up like as early as I would on the weekend.
And what was a typical work day for you as the nanny?
Well, the younger ones, it's like, helping feed them or helping Jennifer if they had like certain activities that day. Just playing with them, keeping them busy, playing outside, giving them baths. I would help with dinner, help with like cleaning up after them.
During this time period, did you ever go on vacation with the family?
Yes.
Where did you go on vacation with the family?
All the places.
Yes.
So I've gone to St. Bart's with them. I've been to Florida. I've been to Greece a few times. I went to Virginia once with Fotis. We went to Colorado.
Did both Jennifer and Mr. Dulos attend these vacations?
Not all of them.
All right. And when you say not all of them, who would not attend?
Jennifer.
And did Mr. Dulos ever travel without the children or Jennifer?
Yeah.
Can you describe the dynamic between Mr. Dulos and his children?
Yeah, I mean, when they were younger, they kind of just, they listened to whatever their dad said. They didn't get a lot of time with their dad, so their time was mostly on the weekend. And I was with them most of the time on the weekend, so they did whatever Fotis asked them to do. But yeah, that was like the main time that he spent with the kids.
How often would Mr. Dulos travel without the family?
A lot, where I don't know the exact days, but enough where it was, you could tell it was a little odd how often he was traveling.
Could you describe the dynamic between Jennifer and the children?
Yeah, it was very silly, her relationship with the kids. They always wanted to be next to mommy. It was just kind of what it was, and she would sing to them and laugh at them, and she never raised her voice. She was like so soft-spoken and never got angry, and she was just like incredibly nurturing.
Aww.
What types of activities did Jennifer like to do with the children?
Oh, she would take them to we'd go to these bounce houses all the time with Jennifer, or around the holidays. Getting the Christmas tree was a really big deal, and going pumpkin picking, and she'd draw with them, do puzzles with them.
Did Jennifer like to water ski?
No.
You had mentioned that the children did like to water ski, however, correct?
They water skied.
Okay. Did they not like to water ski?
They water skied a lot. So I saw times where they didn't want to, but still had to.
And as you worked full-time for the Dulos family, did you begin to develop a friendship with Jennifer?
Yeah.
How would you describe your relationship with her?
I confided in her with a lot of things, in my personal life. I just always trusted her. She was my boss, but she was someone that, we just connected really well. We just worked well with each other. I knew what she liked, what she didn't. She knew what I was good at. We had a really good relationship.
Did you ever meet any of Jennifer's family?
Yeah.
Who have you met?
Her mom, Gloria, her father, Hilly, when he was alive, her sister, Melissa. I've met her cousins.
And you mentioned your father. Has he passed away?
Yeah.
What year did he pass away?
I think it was February of 2018, I think.
And is Gloria still alive?
Yeah.
How old is Gloria?
I think she's 88 or 89, but I don't want to get that wrong, but she's great.
Did there come a point in time when Jennifer began confiding in you things about her relationship with Mr. Dulos?
Yeah.
Did Jennifer ever express to you her feelings on whether Mr. Dulos was paying enough attention to her?
Objection, Your Honor.
Sustained.
Did Jennifer ever express to you a desire to avoid arguing with Mr. Dulos?
Objection, Your Honor.
Overruled.
Yeah.
Would you tell the jury what she said?
She just felt like arguing with Fotis, he was harsh and she didn't like conflict, so she could never really express how she really felt because it kind of got looked over.
Now, I want to direct your attention to September of 2013.
Mm-hmm.
Did you begin working at Ford Group?
Yeah.
Did Mr. Dulos, by the way, did he own Ford Group for the entire time that you babysat and nannied for the family?
From what I knew, yeah.
How did you come to begin working for Ford Group?
So I was working full-time for the family from May of 2013 that year. And like I said, I still didn't have a full-time job, the nannying was. And so he just asked if I was interested in coming into Ford Group and, having this opportunity. So I just decided to take it.
And were you working full-time for Ford Group after you took the job?
No, it was half Ford Group and half being a nanny.
What type of hours were you working for Ford Group?
So usually I'd go in at 8:30, 9 o'clock in Ford Group, and then depending on the kids' schedule, I would have to leave around 1 or 2 I maybe basically like crossed the door, and then I was with the kids until like 9-ish, 9:30.
And just to be clear, 9 is 9:30 at night, correct?
Yeah, night, yeah.
How many days a week were you working for Ford Group when you began being employed by Mr. Dulos?
5 days, so Monday through Friday.
And were you still nannying 6 days a week?
Yeah.
Did you have any regular days off?
Yeah, usually at that point I was having Sundays off. But if I needed like another day off, it was like with Jennifer, it was kind of easy to do that. But usually Sundays were my day off at that time.
What were your responsibilities with Ford Group?
In the beginning, it was really just like office work. I was like organizing folders, things like that. I would really like worked alongside Fotis, so I basically would follow him along to work sites, and he would show me some things because I was totally new to this whole world. And then eventually, in time, I became in charge of the punch list at Ford Group, which was when a house was built, the owners would have a list of things that they wanted to finish off, like there's a chip here or whatever, and I would be in charge of making sure that that gets done.
How did you view Mr. Dulos when you initially began working for Ford Group?
Oh, I saw him as like a role model and a mentor, and I thought at the time he's given me this really great opportunity. So I considered him a friend.
And did Mr. Dulos encourage you to go back to school?
He did, yeah.
What did he encourage you to study?
Construction management, but he also was pushing for me to get my real estate license.
Was there a telephone number that was associated with Ford Group?
Yeah, it was Fotis's personal phone number.
When you say his personal phone number, are we talking about a landline or a cellular phone?
No, it's like a cellular.
And did you often see Mr. Dulos answering work-related calls or sending emails?
Yeah.
Would it be fair to say that Mr. Dulos kept his cell phone with him at all times during your time working for Ford Group?
Yeah.
When you were working for Ford Group, did Jennifer ever express to you what her intentions were with the children? Excuse me, strike that. When you were working for Ford Group, did Jennifer ever express to you how she wanted you to handle the summers?
Yeah.
What did she say?
Kind of said that.
Well, did Jennifer ever express to you how she wanted you to handle the children during the summers? Well, the question is, did she express to you how she wanted you to handle the children? Overruled.
You can answer.
Okay. Yeah, I would basically, because the kids wouldn't be in school, so I would be with the kids full time.
And how many employees did Ford Group have when you began working for them?
Not a lot. It was very small. So like a handful.
When you say handful, can you just be a little bit more specific for the members?
Yes, I would just have to count. I would say like 5 or 6, maybe.
Was Pavel Gumiani one of the employees?
Yep.
What was his role with, actually, before I ask that, when did he begin working for Ford Group to your knowledge?
Oh, to my knowledge, I don't know. He was there when I started, even just babysitting before I ever even worked for Ford Group, but I don't know when he started. But
okay.
And he knew the family for a while, that's all I knew.
So by the time you began working for Ford Group, he was already working for the Ford Group, is that correct?
Yes.
Remember, that's who owned the Tacoma.
And what was his
He'll
role
be
with the company?
testifying too.
He was a project manager. He kind of did everything, to be honest.
Did Jennifer know Mr. Gumiani as well?
Yep.
Would he assist her around the house?
Yeah.
How would he assist her around the house?
He would change out the light bulbs when they went out. He would build, I know he built they had this very beautiful playscape in the backyard. I know he built that. He would even sometimes help pick us up from the airport after a trip.
Did Jennifer ever work for Ford Group?
Not that I know.
And you had mentioned that Mr. Dulos was a role model to you during this time.
Mm-hmm.
Why did you consider him to be a role model?
When I first started working, he was just incredibly nice. He made me feel comfortable. He was funny. I was fresh out of college. I didn't know what I wanted to do. And it sounded like I was getting this really great opportunity, even though it had nothing to do with any of the work I've ever done. And it seemed like he just wanted to push me and, make me better.
And did there come a point in time when the dynamic between Jennifer and Mr. Dulos began to change from when you first met them?
Yeah.
Could you describe how the dynamic changed for the jury?
The big dynamic change was in March of 2017, which is when Jennifer found out about his affair. And a few months after that, it totally changed.
So I want to direct your attention now to March of 2017. Did you take a trip with the Dulos family?
Yeah.
And where did y'all go?
The kids had a 2-week break, and so the first week we spent in Aspen, Colorado, and then we flew to Miami for the second week.
Who went on the trip?
The first week was myself, 5 kids, Jennifer Fotis, and his friend Mark Masiello.
And I think you already mentioned this, but why did the family decide to take a trip in March as opposed to?
Oh, the kids, their school vacation, they get 2 weeks off in March. So that's why we went in March.
Where were the kids going to school at the time?
They were going to Renbrook. It's in Farmington.
I'm sorry?
It's in Farmington.
And where in Colorado did you vacation?
It was Aspen.
And what types of activities did you and the children do while on the trip?
Well, they ski. They're very good snow skiers. So they would ski. Noelle, who was younger than everyone else, we kind of would just kind of hang out, walk around the town a little bit. She would ski a little bit. Or whoever was like tired, they would like basically come back with Jennifer and I, and we would do like the hot cocoa stuff. But they skied a lot.
And how old was Noelle at this point?
6 maybe.
And where did you stay in Aspen?
Jennifer's father won a house through a charity auction, so we stayed there for a week.
And did there come a point in time during the trip where Mr. Dulos told the group that he had taken the children to an adult club?
Yeah, and so she was like, we were both kind of like disgusted, I guess is the word.
And what was Mr. Dulos' demeanor like as he was relaying this information?
He was excited that he like paid off the people to let his kids into this day club where, yeah, he seemed really happy about it.
And approximately how long did you guys stay in Colorado?
It was about a week.
And at some point did you travel to Miami?
Yep.
And I assume you flew?
We flew, yeah.
And who went to Miami?
So myself, the 5 kids, Jennifer, Fotis, and then Jennifer's mom, Gloria, met us in Miami.
And where did you stay in Miami initially?
Initially, we stayed at the W hotel there.
And describe some of your daily activities in Miami. I assume you're not skiing anymore.
No snow skiing, but there was water skiing. So
Okay.
they went from snow skiing and they went to Miami to water ski. So really, that was the activity.
And where would the family ski?
It's a Miami ski club.
And who would go to the ski club?
Myself, the kids. Sometimes Noelle would stay back with Jennifer. Jennifer would not go, and Fotis would go.
And during this trip, did Jennifer discuss her relationship with Mr. Dulos with you?
She did.
Objection.
Well, at this time, did Jennifer discuss her relationship with Mr. Dulos with you? The answer is either yes or no. Overruled.
Is that a yes?
Yes.
And what did she tell you?
Objection.
Well, what did she tell you about the relationship?
I'll rephrase. What did she tell you about the relationship?
Objection.
Well, that question is very broad.
Calls for
Calls for an answer that could be a narrative. So the court is going to sustain the objection, but allow you to pursue the line.
You mentioned earlier that Jennifer had found out about the affair. Do you recall testifying to that?
Yes.
What did Jennifer say to you about the affair when you were in Miami?
Objection.
Well, that's going to be overruled.
Nancy.
She told me she believed that Fotis was having an affair.
And did she say why she believed that?
She just said she had this feeling, he's been acting weird, and I didn't really believe her at first.
When you say you didn't really believe her, what do you mean by that?
At that time, I had a good relationship with Fotis, and I believed him to be an honest guy, and I couldn't imagine him having an affair where there's 5 little kids involved.
So what did you say to her?
I said no.
Objection.
Grounds.
Hearsay.
But what
Grounds?
this witness said is not hearsay. This witness is testifying about what she said, not what another declarant said.
It's an out-of-court statement, Your Honor.
Well, it's an out-of-court statement, but this witness is the declarant. The witness is telling the jury what she told Jennifer. She has personal knowledge about what she told Jennifer. Overruled.
What did you say to Jennifer?
I told her I don't think that's true.
What was her demeanor like during this conversation?
She was very anxious, like kind of tight, and she seemed upset.
Was anyone else present for this conversation?
Oh yeah, her mom, Gloria.
Now, during this trip, did you meet someone named Michelle Troconis?
Yep.
Did
Ah,
you see Michelle Troconis in the courtroom?
first time her
Would you
name
just
has
point her
been
out and tell us
said.
what color shirt she has on?
Beige.
Judge
It's the
identified
first
her.
time they've said her name.
the record.
We're at the very end of day 3, and that's the first time her name has been mentioned this
Well,
entire trial.
before you proceed, you have about 2 minutes perhaps. This is an appropriate point at which to conclude today because you're about to go into other matters that are more significant than just identification. So, ladies and gentlemen, we will conclude today's session.
Wow,
That's not
literally
the case. We plan to resume
the
tomorrow
last
at 10
thing.
o'clock.
Literally the last thing mentioned on day 3 is the defendant's name. It took 3 full days.
This Honorable Superior Court now stands adjourned until tomorrow at 10.
3 full days, and we finally heard her name. Literally the very last thing that we hear on day 3. That's kind of crazy. They say her name and then we leave. Very last thing on day 3. That's kind of crazy. I know that there will be more parts that are going to be kind of like tedious. But we made it through some of the most tedious stuff, which is exciting because now we get to hear the the meat and potatoes of all the stuff. And she's going to continue her testimony tomorrow, so we'll hear, more about her. What I'm also really looking forward to is going to be the testimony from Powell, of course, who owned the Tacoma. And also, if I believe that Kent, there's been talk of Kent testifying against Michelle for his own deal. If that happens, that would be wild, but I don't know if that's going to happen. But there's been talks of it. But yeah, now we're to the part where it's an actual trial. All right, one more thing before we go. One more thing. Let's see. The body cam. Oh, that got real loud. The body cam for Donna. We're not going to watch all 26 minutes, but somebody just said that the first 5 minutes is the most interesting or whatever. So let's watch that before we go, and then we'll call it a day. Because I want to see Donna go. All right, let's watch.
Hi, how are you? You have your ID?
Oh, shit. Oh.
Because my attorney said not to.
Why do I have to give it to you? This is evidence.
She tried not to give it.
I have to go with it. I have to go. I have to do it. Let me help you out. No, I have to stay. Please don't do this. Don't stay. You need to grab the bags. Take the bags. Yeah. And you need to wait outside. Okay.
My husband's almost 80 years old. He can't
Yeah,
come
I
with
can't.
me.
Please, can I go? No, you can't join me there. Oh, don't do this, please.
Please.
Oh,
Someone's
God.
got to help him get home. This is terrible. You can't do this. This is insane.
Can you hold on to that for me? Is that okay with you? Please. You don't have that with handcuffs on. She's not going anywhere. Please. Please. Do you have anything in your pocket?
No, no. No.
Do you have anything of value in you?
No, I
Does she have a necklace on? You can take
My-
the necklace. Yeah, take it off. Yeah. And the earrings, the rings, take everything. You give it to your husband.
Because once you arrive at County Jail, they're gonna make you remove all that.
Can I call my attorney?
You have a passport already?
Where am I going?
Which phone open you finger?
She tried to snatch that phone back.
You're going to the Dade County Jail.
Dade County Jail.
Broward County, right?
No, this is right here, the one on top.
They're coming in minutes. No problem. You can have. No problem.
I'm sorry, remove your earrings? How it happened?
1 minute.
This is at the airport in Miami.
Yeah, we'll go back.
Take it right through here.
Yeah, we'll go back out and just.
She sure did try to get out.
Another mistake. It's two mistakes. And try to take the remote. If we can get this off for you.
Can you take it off, please, Donna? I don't want to hurt
her.
her. Please.
Just a minute. Just a minute.
Please.
It's getting there. What's up, honey? Listen to me.
Yeah. I'll call.
Get in an Uber. Go home.
I will.
Take
I will.
it easy.
I will.
All right?
Yes.
Here, hon.
If there's anything else in her person that she wants.
Oh, but it's coming, sweetheart. It's coming. Just a
This
second.
reminds me of that. It reminds me of that commercial where the fisherman is like, he throws the, what was it, like a dollar bill or something. He's like, "Ooh, you almost had it. You almost had it." She almost boarded.
I'm sorry?
It's in my
Yeah.
it's in my purse.
Yeah.
Yeah, then you could get back.
Sure. Do you need her passport? Or can I give it to the husband? The passport can I give it to
What's up?
Where is it?
It's in the blue and white. It's in the blue and white.
Yeah, but
It'll be quicker than that.
Yeah.
And the license, the address on your license is correct?
Yes.
She needs all her.
When she goes to the jail, they work in the hospital.
They're all in here though.
Yes, they work. If I take them here, what will happen is when you go there, they possibly toss them out. So when you go to there, you will meet the nurse and the doctor, and then they'll work in conjunction with the hospital to get you whatever you need.
Yeah, but I don't have a list with me. I know what's.
Driver's license?
Yes.
I have a.
Is it multiple or is just one or two?
There's a bag of medication in here. Is that what you're asking me?
She can take medication.
No, I know. I was just trying to find out if it was like one or two. Yeah, if it was one or two, then she maybe could take the name down.
Do you need anything else from her?
Can I ask
So
you
we're good to
something?
go?
Can someone just get my husband outside and
So I'll get him.
The gentleman here will assist him in any way.
I'll be okay.
I have the ring. Hold on.
Let me have the ring, please. Yeah. No, I'll take it.
That's crazy.
I love you.
Okay.
All right, so I don't have the meds, honey. They're all in here.
Give me 1 moment, please. Hold the body. 1 moment.
Thank you.
Airport 30 here, clear.
Here, let's watch her. Let's watch her go real fast.
Go out.
Perp walk, perp walk. She gone. Look, and you know what's great? All these people. She has to go by all those people. Purple. And this is how far she got. Yeah. Oops. Walk of shame.
You got your case number, Vicky? Okay. All right.
Walk of shame. Walk of shame was a person.
I'm going to go 6 from now, from here, and then I'll get the case number for that video.
She gone. You almost had it. Oh, you almost had it. You got to be quicker than that. Bye, Felicia. Yes, bye, Felicia. Bye, Felicia. You know, I just don't feel bad for her. You know who I feel bad for? The Markells and the kids. Not her. Not her. You know, it's good to see justice served. It really is. It's good to see justice served. So, I'm digging it. I'm digging it. Yeah, people probably thought they caught a terrorist. Well, I mean, in a way they kind of did. In a way they kind of did. Though she is but little, she is evil. Interesting. I wonder how many people who aren't like true crime fanatics like we are. Let's just leave it on this screen for a moment and just enjoy this moment. I wonder how many people who aren't like true crime fanatics would have seen her and recognized her. They didn't arrest Harvey because they don't have enough information on Harvey. Remember, she's the one who did all of the, yapping with old Charlie boy, with the maestro, even though we know that she was really the maestro. Let's get real. So, crazy. So, I'm glad to end our day on this. I'm glad that we finally got to get to some testimony in our trial. And tomorrow is going to be a really interesting day with it. I'm glad we got to see the Murdaugh hearing. And I know we still got a couple more that we didn't cover. I'm running out of steam here. So we'll watch some tomorrow too. When we do the 1.25, because I know that they had told them, speak slower for the court reporter, but they speak so slow for the court reporter. So I'm digging the 1.25 speed because it just makes it feel more normal. But we also, because of that, we also catch up. So tomorrow, like today, we caught up while they were at lunch. So then during lunch break tomorrow, we'll watch some of the other stuff or catch up with some of the other stuff that we didn't get to watch today. So we'll see. We'll see how that goes. Oh, I want to see Wendy in the same way. Me too. There would be nothing better than to see Wendy have had to do a perp walk in that little floozy dress she wore to her son's bar mitzvah. But, whatever. I digress. It was a nice dress and it would be great for, other activities, but not your kid's bar mitzvah. But that's maybe me being Petty Betty or Judge Judy. I don't know, something. But, not a fan. Not a fan. That's okay. All right. Thank you for hanging out. We had all kinds of tech issues this morning. Sure did. I think this is like our, fourth stream of the day, third stream of the day, something like that. We had all kinds of issues, but we got it together and we got through the day and it was really interesting. Tomorrow, will be a late day as well. It'll be like that for the next 8 weeks. Because I've got to be, I won't be getting home in the mornings until about the same time. So we'll start about the same time tomorrow. But like I said, it works out good because we get to kind of speed trial a little bit. Oh my gosh. Watch for squirrels tonight eating cheeseburgers. Y'all, it's dangerous out there. Watch for snow and watch for squirrels eating cheeseburgers. That's some of this stuff you just cannot make up. You just cannot make up. Anywho, y'all are the best. I appreciate you so much. Thank you for hanging out today. Thank you for, let's check before we go. Let's see where we're at. Because we're getting close to the 15K. So updated number for the day, we are at 14,777. Ooh, 777s. That's lucky. That's lucky, right? I'm not a gambler, but I think that's lucky. I think that means that it's lucky. We're going to go with it. And as always, Chrissy Bacon, yes, guard your undercarriage. You know what I mean. All right, y'all, I appreciate you. Thank you so much for reporting to jury duty. I love you all so much. Thank you for your patience today, too, because Lord knows we needed it today. But I appreciate you all. I will see you tomorrow. I'll get the stream set up in just a few minutes, but I will see you tomorrow, and we will get going on day 4. All right, love y'all.